Hey folks, happy Friday. Hope all is well. We're on time. I'm on time. Totally on time. Hey, you guys doing? Happy Friday, everyone. Welcome to a little bit of chaos. We're starting off with a little bit of chaos. 2 weeks off, and we still can't get back on time. So, doing great over here.
Running bets on on start time.
What was the wager off? Yeah. That's kind of the way that things tend to go, especially when you've got a whole lot you want to cover, and you're trying to play catch up on a whole lot of material. So it's been 2 weeks,
folks.
I've told you in the past what January is like for domestic relations lawyers.
Is it as bad as December?
It was so much worse. December's nothing compared to January.
Really?
Yeah.
Because I would have thought the Christmas fights would have been the where the action is.
Not really. You get a few phone calls on Christmas or around the Christmas holiday, but not as much as you would expect.
Because I know for criminal lawyers, Christmas season is nightmarish. Because everybody wants bail for Christmas. And it's like, sure, I'm accused of like 3 homicides, but you can get me bail, right? And it's like,
yeah.
And the other thing is that they all have this notion that the courts are going to be super generous to them on bail because it's Christmas and everybody gets bail for Christmas. Yeah. And it's like,
of course, why not?
No, that's not actually how it works. We can try for it, but everybody wants it. So, yeah.
Well, that's how logically it works. Family law is interesting because family law, they're holding it all together to get through the holidays. Like, let's just get through the holidays. And then they get through the holidays and they're finally there. And then you have several different factors. You have the New Year's resolution where it's like, I'm going to get this done this year. I'm not living another year like this. Then you have the holiday chaos and turmoil that caused someone to miss days or time that they think they should have gotten. Then you've got the couple that has been teetering on the edge, living under the same roof, and they have just made it through the holidays, and that's been their breaking point. So January, the floodgates open.
It's like, I cannot make it another year having dinners with your racist uncle kind of thing.
In some respects. Does that come up? I'm not going to say it doesn't. But yeah. So the other thing is I've got trials. I've got all kinds of stuff. That trial that I was supposed to go forward on last week. We go 3 years without a single cancellation for purposes of snow. And we get snow on the 2 days of like 2 of my trials in 1 month. So it's briefly continued. That thing's continued the first week of March. So I've got another trial starting on Monday with more hearings coming up. So I am slammed. I am busy. I have been able to catch some of this stuff and look at it, but not enough to be able to get on a live stream. I don't know how you've been doing it with all your coverage.
Oh, I basically gave up recreation and sleep.
So
you know how I bought land?
Yes.
I still haven't been out to it since purchasing it.
No.
Correct.
Yeah. Oh, I see Andy. There's Andy the Game Maker. Did somebody say chaos? Yes, Andy. I said your middle name. I did indeed. Good to see you, bud. Haven't seen you in a while. Hope you're doing well. Other thing is the kids have been printing stuff on the 3D printer like crazy, and I've learned that 3D printers. Have you ever heard of HueForge? Like,
no,
that's not a picture. That's printed.
That's cool.
So I've been playing with that, and then the kids found out that I can light switches. Where is it? So I've been printing a bunch of these fun things, which are awesome. So having a lot of fun there in whatever free time I have. The nice thing about 3D printing is 3D printing, you can turn it on and then go to sleep. Well, you're not supposed to, but you can. I do. We have some fun with it. So let's see. Oh, catching up on some of the chat. Outside the box, Rob, how'd your favorite client's trial go? It is not yet done. That has been continued briefly. That is coming to the conclusion very, very shortly.
Wait, Zora's got a trial?
Yeah, no, Zora's not on trial. No, Zora has stayed out of trouble. Hasn't she?
No.
No. You want to come get your client? Because your client's got a skin issue.
Oh, that's no good.
Yeah, we're trying to figure out what it is. Well, yeah, but when I say skin issue, I mean like the skin is clearly irritated. There's something going on with the skin. So we had to do it. Look, the dogs are expensive. I mean, what? So last week at some point in time, I had to take the dog to the vet because we couldn't clear up the skin issue and he wasn't eating very well. And we're going, something's just wrong with him. Something's off. Well, the vet doesn't really know. So the vet's like, we got to do a bunch of tests. Okay. So we take blood and the vet's like, well, we can start narrowing things down, one thing at a time and try to figure out what's going on allergy wise. Well, that sounds like a process. And then do I have to come back every time? And well, yeah, usually you would. I said, well, is there a way of not doing, one thing at a time? We can do an allergy test. All right, let's get the dog allergy tested. I walked out of that vet office, $1,300 lighter in my pocket.
That you got away good.
I know. My word.
Because it's easy to spend way more than that.
I have spent more on this dog. I think we spent more on this dog than the actual little humans. No, little humans are really expensive.
I'm pretty sure it's more expensive than that if you walk into the vet's office and you just ask to use the shitter.
You know what the vet's office has to figure out? You know when I take my car in and they plug the thing into the car and it gives a diagnostic report of what's going on with the car? They need to do that for a dog.
Problem is when you do it with a dog, it just all the things go off.
That's true. It's just a siren pops out of the dog. It's like everything is broken. Well, Leo was really upset. He did really well in the vet's office. I mean, he's a rambunctious pup, but he does well in the vet's office. And until the vet, he was scared of the vet. He loved everyone else. He was scared of the vet himself. The vet came to take his temperature, and he's being really skittish. And the vet pulls out the little the infrared, the laser for the temperature reading. And I said, Leo, I don't know why you're being so skittish. That thing could have gone in the other way, and that would have been a lot worse. He was a good boy, though. Yeah, these pups are expensive and very frustrating.
Yep, they there's pretty much one thing dogs do, and that's cost money and then snuggle.
Leo snuggles
really they're better at the costing money when it gets right down to it.
They really are. Leo is better at he snuggles too aggressively. Like there's this really cute moment when he puts his head right up against your body and he's like, this is really nice. I want to just be there spending time and making contact with you. And then he proceeds to try and get his entire body as near to your skin as humanly possible. And you're like, you can't get much closer than physical contact with all of me. He's like, but I can sure try. Watch. Just wriggling around. And then he's like, oh, this is a good time to play. Let's go ahead and bite each other. No.
The thing I want to do is film what Zora looks like when she is running up. Like when I went to take a nap, right? I'm sitting there and Mrs. Runkle was out. So Zora was sort of patrolling around upstairs because she thought that everybody had left her. So I called her from, the bedroom and she comes running down. But it was a dark room with this light. And then suddenly Zora, just comes bursting into the light from my cell phone. And it's just this like
just like a face. Like there's just a face. You're like, oh no, gosh, no, don't do that. Yeah, no. Leo is a Doberman. And the vet was like, he's a little bit light. I was like, what are you talking about? Have you picked this dog up? So, yeah, he's a little bit light. Okay. Let's see. I think I've got so we're trying to switch him to food, which is always a pain in the ass, trying to switch a dog's food, because they're like, I don't want this food. And you're like, well, fine, I'll mix something into it. And then you mix something into it. It's like the next day you go to feed them the food again. And they're like, well, I want the thing mixed into it. Well, you don't get it all the time.
Also, I got to show you a new thing I got. 1 second.
Let me see. Oh, you want to go get it. So while we're doing that here, someone asked so we can, let's see how Leo does at the vet. Hang on. I took, because there was disparaging remarks being made about Leo's conduct at the vet when he was taken by Mr. Manager. And, you know, I was saying I just had fine. It was fine with me. I didn't have a problem with him. But let me see. Where was he? Where's this puppers? Hello, puppers. Here. He does really good. This big old handsome boy. And there's other puppers. We treat it like a training session. He's like, I'm good. I enjoy this. He did not enjoy it. That's the punchline. He did not enjoy the vet. He was very concerned. Said, but why do I have to be here? But how do you hate that face? Well, no. Sometimes it's easy to not like that face too much. Because that face gets all up in your business all the time. Every minute of our day. Doesn't know what to do. Emily, the defamation will not stand. More toys, pets, and treats would solve all these issues, and I'm sure we can negotiate a settlement. No, there will be no settlement had. He's doing fine. He's a chaos gremlin, but he's a good chaos gremlin. He's upstairs sleeping right now. There's a magic hour. It really is annoying. So the kids, oh, now I'm really jealous. For those of you who just turned on your video, like, oh, I really don't like you right now. Are those straight NVGs or are those infrared too?
Straight NVGs. Well,
I hate you. I really.
It is a lot of fun, and I need to get it to play with it properly. But it's pretty cool.
Yeah, I don't like you. That's brutal. That's fun. Where'd you get that?
That is from Op4 Night Solutions here in Canada. And of course, we're limited as to what we can get due to ITAR. But yeah, I'm going to have to take it out to the middle of nowhere to go play with it. And yeah. So
that's really cool. I'm jealous. That's not fair. I mean, it is fair. Because I could get one if I wanted to, but yeah. Meanwhile,
the other thing I need to get is a flamethrower.
You've mentioned that on several occasions to me, and my curiosity is just why have we not?
I may need to do that. I may need to bite the bullet and do that. So, and I see we've got Emily and Kurt and Recovery Addict all in the chat.
I saw you guys there. Thanks for coming along and hanging out. I've got a short docket today because honestly, I have maybe slept 4.5 hours a night for the past week. So
I saw Karen read on that sheet. You do not have a short docket.
I do not have a short docket. But you know who has a really, really good ability to read the room? Like just a phenomenal ability to just gauge timing and PR? Blake Lively. This was at my grocery store and I walked by it. I was like, no. You decided that now was a good time for the full court press on the Betty Boos?
I guess.
Yeah.
So somebody sent me a picture of one of those that I don't know how to feel about it.
Of what?
They sent one of the Betty Boos ads because somebody had defaced it by putting a black eye on it. And I was like, I am not super comfortable with this. I get where they're going with it, but I am not super comfortable with this.
That's the wrong way to deface that. Like, what are you doing?
I was just like, I just don't know what to think of this one. So, yeah.
Oh my gosh, what a nightmare! No, but I walked by it. Well, you know, look, here's the thing. It's already on sale.
I mean, it might be an introductory sale to get people to start trying it, right? That is a thing, right? So I just,
God,
I hope it's not a sale because it's not moving at this point, because that would be sad.
Well, I don't know if it'd be sad. I don't know if I'd call it sad. I would say it's something. It's certainly something.
Sign of the times, I guess.
I guess. I
mean, I've never seen such a tremendous own goal as that PR move. Like,
which one? I mean, you're gonna have to be more specific, Ian, because we've got a couple of these things that have just been, well, we'll say questionable is putting it nicely.
Yeah, I mean, every PR move she makes seems to be like the opposite of a good decision.
Every step you make.
All of them are decisions. It's just none of them have been decisions that that I would recommend.
Yeah, they're all horribly wrong. Like every one of them just seems to be going, so you thought this was a good idea.
Yeah.
And you went with it. Like the Ryan Reynolds joke at what was it, the SNL when he appeared and did that.
Yeah, I gotta say, if I was Ryan Reynolds and I was appearing on SNL, and I was attending an SNL, I would just be like, okay, I'm just gonna sit here and no matter what happens, I am not moving. Mm-hmm. Like, I will laugh politely, have polite chuckle at every joke, and that's it.
No, he decided that he was going to do something different than that. That would have been a wise move, Ian. I just didn't think that how he engaged in that process was really well thought out. I mean, he made some judgment calls there.
Yeah, instead he decided, hey, you know what? Now is a great time to make light of what's going on. So, yep, it's a decision.
For people in the chat, ask one, I can't play it. NBC is rather.
Oh yeah, they will go nuclear.
Yeah, they're rather protective of their IP. But I can summarize it. Basically, the SNL, it was live SNL showing, and well, it's live, but it auditorium, studio audience, and the studio audience was full of a bunch of celebrities. And they're going around and they're highlighting a bunch of different celebrities, and they point out Ryan Reynolds. And Ryan, he stands up, and it was like, they said, how's it going, Ryan? Good. Why? You haven't heard anything, have you? Like, the big joke is that, their world's a little bit chaotic. Yeah. And they're asking now, I mean, the request more recently, the update in that case that I've got is, yes, there's the amended complaint. No, I can't go over it. That thing is 3 miles in length, and trying to go through that with a fine-tooth comb ain't gonna happen. Not, at least not on my eyes. There are other people that I will commend you to.
I'm like, it could be an entire Monday stream, but I will probably summarize some of it on Monday and then do like Karen Reed discussion, because there's just so much. And at a certain point, like I've been describing it as Hollywood knife fight. And the problem with a knife fight is that everybody gets cut, but especially the person who starts it seems to be getting cut. So
yeah. That was, what ends up sounding or ends up being the truest statement that I've heard so far is when Baldoni's lawyer gave that not the press conference, but when he was giving the interview, and when they were like, oh no, she's being sued like tomorrow. We're going to sue them into the dirt. Like, well, that's a pretty bold statement. I was like, well, no, he's confident. He's going to swing for the fence.
I mean, he clearly meant, he was like, this is happening. Like, that just meant like an associate right now is drafting the statement, the complaint.
I think the damn thing was drafted already. He was just going through it and making sure they had it lined up.
Yeah, it's like we're just proofreading right now. That's where we're at.
Yeah. There's also been an update in the Diddy world.
Oh god. The dismissal or is there something else? Because that case just keeps going on.
Did you see that his lawyer is seeking to withdraw? One of his lawyers is?
Which one? It's not Spiro.
No, it's not Spiro.
Okay. Then he's still got a hope.
US v. Combs. He's also asking for a bill of particulars in the case now. And the government's going, no, you just want accelerated discovery, and we're not going to give you access to witnesses ahead of time in the deadline because you do things that we don't trust you to do with the witnesses. And no. So that case is set for trial. Isn't that set for trial in June? July?
That case makes me hate everything about it. It's just so awful. Like, just such an above and beyond level of awful.
Oh, it's terrible.
Like, it's just...
no redeeming. Nothing redeemable about that case.
Like, everyone is, like, why are you covering, like, Baldoni? And it's like, you know how refreshing it is to have a case that ultimately doesn't involve like a murder or a full-on SA. Like, the allegations on this one are like, if you take Blake Lively at her face, it's still not the worst allegations of any of the things that we're covering right now. So it's like,
no. The Combs case is by far and away the worst. Here, I'll show you what the Combs case update is, and then we can just move on from that.
Oh God, this is gonna hurt me, isn't it?
No, it's not that bad. It's not as terrible as it is. So this is filed on. Oh, it's filed today. Please take notice upon the next declaration of Anthony L. Rico that the defendant Sean Combs moves this court for the following relief: for an order permitting Anthony Rico to withdraw as attorney of record in the case for such other further relief as the court may deem just and proper. And there's an attached affidavit by Mr. Rico. And the affidavit is as follows. I was retained on September 22nd, 2024 to serve as his counsel, and I have served in his counsel since that time. As a result of being retained, a notice of appearance was filed. This declaration is submitted in support of the annexed notice of motion for my withdrawal as counsel, as is required under the local rules. For the reasons set forth below, the motion withdrawal is filed so that Sean Combs may move forward with his defense and to commence jury selection and trial without any delay. Reasons to be relieved as counsel. Now, every time you see one of these, you play a little game of reading between the lines. Sarah Boone's attorneys weren't as graceful in their exits in giving their rationale.
It always astounds me that these things say, because you know how I would do these? I would just be like, where I am, the local rules for how you withdraw in a situation like this is you just say, I'm making application to withdraw. I have an ethical concern, and that's it. That's all you say.
Mm-hmm.
And literally nothing else.
I will get to the docket in just a second. Although we're only like 3 topics in. As a result of the discussion with lead counsel, Mark Angifilo, I will never Agnifilo.
Okay, screw that up. I'm gonna Agnifilo, I think, but I think we're both getting like a box of poop in the mail from him if he sees us trying to pronounce his name.
Oh yeah, terrible. I'm positive I completely botched that. While I'm aware that the local rule requires the application for withdrawal of counsel support and granted only upon a showing by affidavit or otherwise of satisfactory reasons for withdrawal, there are sufficient reasons related to the protections afforded by attorney-client privilege for brevity in my application for withdrawal as counsel in this case. Okay. Application for withdrawal of counsel support and granted. So it gives us the standard only upon showing of by affidavit of satisfactory reasons There are sufficient reasons related to the protections afforded by the attorney-client privilege. Like the fact that privilege was invaded, or the fact that for brevity in my application for withdrawals counsel the case. Okay. Although I provide Sean Combs with a high level of legal representation expected by the court, under no circumstances can I continue to effectively serve as counsel for Sean Combs, consistent with the ABA standards for criminal justice. It was that part.
So there's a couple of things there. One, it sounds like Combs might be impugning his level of representation, but the other one is, it sounds like that one to me sounds like that he's saying I'm being asked to do unethical things.
Yeah, or I'm aware of, by nature of my attorney-client relationship, I'm aware of certain shit going on that I am not comfortable with, and I can't continue practicing in defense.
Like, say, you know, we could theorize that, say, witnesses might be
contacted and offered compensation, or I don't know. That's speculation
in some fashion. Yeah, this is speculation, but that's all we get with these things.
Also, I was really, really confused with this because the ABA has no authority. I always think this is really funny when people bring up the ABA. They're like, the ABA model rules. It's like, the ABA model rules are garbage. I mean, the ABA is, they have no binding authority. And everyone's like, but they're the American Bar Association. I said, yeah, that they have no governing agency over anybody else. Any of the lawyers in America, they're all regulated by their state bar. But what I'm wondering is, has New York adopted ABA ethical rules? I don't think so. No, it just yeah, I don't see anything. New York has their own rules, as every single state does. Yeah, the ABA is garbage. But why are you putting this in the motion? Well, under no circumstance can I continue to effectively serve as counsel for Sean Combs, consistent with the ABA standards for criminal justice. Okay. The motion for withdrawal, if granted, will not result in a delay of the present schedule or the present schedules for briefing. No lapse in representation. He will continue to be represented by 5 other attorneys of record. You know, it must be nice as a criminal defendant to have 5 counsel of record in your defense. Well, 6.
You know how many times I've been on a 5-lawyer file?
Never.
Just never.
Yeah, exactly. Without violating any aspect of the attorney-client privilege or otherwise providing any details whatsoever on the grounds supporting the application, the government has been notified of the filing of the motion withdrawal as counsel. The government takes no position on the motion seeking withdrawal of counsel for Sean Combs. Wherefore, it is respectfully,
usual, right? That's because why would they have an opinion, right?
I don't understand this. It is respectfully, but regrettably, why are you emphasizing certain words? Lawyers editorializing their pleadings is really starting to frustrate me.
This is one of those things that I would just like you just say, I, under penalty of perjury, cannot continue on this. Like, under penalty of perjury, I swear I cannot continue on this file. You know, an ethical issue has arisen. You don't specify who the ethical issue belongs to, so that, you know, and you just, and the thing is who's going to argue with you, right? At this stage, the court's not going to be like, you need to stay on the file, right? It's not like you're doing this the day of trial or anything. So, yeah, I don't get it.
And if you're going to editorialize a motion, like, look, I'll put emphasis on some of my motions and pleadings, like, counsel clearly disregarded this rule here, but when I'm not editorializing my motion to withdraw, like, the client and I, bold, italicized, clearly are at an impasse with how we want to go forward in litigating the case. Just exit cleanly, maintain your reputation. Sarah Bell mentioned the question: is the ABA since federal court? No, federal is all federal ethics rules are set forth by the Supreme Court of the United States, and lower courts have the ability to set additional rules as a supplement to that, and local rules in supplementation of that. But ethics is governed by the Supremes and on down. Very funny, Scott. Isn't having 5 attorneys of record considered a harem? You can't use the word harem in the same context as Diddy. When you say Diddy and you say harem, they must be separated by at least 5 minutes of discussion on different topics before you bring up anything related to, I guess. Oh, God. Oh. Well, that's where we are. We've got a docket that consists of 2 items today. We got to take care of my appellate argument because I didn't get a chance to cover that, and it was pretty interesting, some of the things that were being said. And by interesting, I mean the hospital is just advancing a position I just don't see them winning on.
That case is so sad. Like, she just deserves some justice, and it's just caught up in this endless stream of,
Yeah, for those of you wondering about why, one of the reasons it's sad, Peter, a lawyer had a podcast in which he brought me on because I covered that case extensively, and there was there's a falling out between the 2 lead counsel for Maya Kowalski, and I believe that there's a conflict of interest now as to both of them. So I don't know that she has trial counsel available to her really, unless, I don't know. It's a mess. But I think the appeal went well for her, about as well as you can go. We can cover that. And then we're going to talk about Karen Reed. More specifically, Judge Cannone being very upset about something. And I think that I went back and looked at, I told you this a little earlier. I went back and looked at some of the video. There are a few points at various times across the multiple hearings where Attorney Jackson intimates to Cannone that he's never spoken. So there's a lot of details we don't know yet, which is frustrating because that hearing on, Tuesday, ended really abruptly without a whole lot of discussion. And
she just kind of like threw a grenade and then left.
Yeah. So we can talk about that. We're going to talk about that a little bit. But let's catch up on a little super chats and we'll get started with our first topic. Outside the box, thank you. I went over the docket just now. Mrs. Agnifilo represents Luigi Mangione.
Yep.
Okay. I know they had a hearing today. Did you watch that hearing? I didn't watch it today.
No, it's not televised because, federal court.
Okay. Well, it was... No, wait, the Mangione?
Yep.
I thought Law and Cry was watching that one.
No, federal court.
Oh. Well, I don't want to watch that trial. The trial's not very exciting to me. And honestly, it just seems to be an opportunity to push some statement. I don't know. No, it was. Hang on. Luigi Mangione appears in court back in New York State Court. It was state court proceeding.
Oh. I thought it wasn't televised. Oh, yeah, denied cameras.
Oh, they did?
Yeah.
I wouldn't give him. That's one situation where I agree. I'm going to agree with the judge on that. Very rarely will I agree with the judge on denying and removing access of the press to that. But I mean, the man clearly wants to make a point. What?
I mean,
one of the charges, honestly,
reason to have open courts.
No, one of the charges. I think if asserting one of those charges being by the government that it was an active terrorism, where it was trying to proceed or get a political meaning, a persuasion on the body politic of a certain position and using violence to do so.
Yeah, I still go that just says to me open courts.
Yeah. I'm just telling you personally, from my own personal perspective, that's one trial I have no interest in watching.
I kind of feel like
interesting.
If you're trying to undermine undermine his political position, you want to show as much as you can, because in the absence of that, people tend to mythologize. So
that's true. There's a whole lot of that. He's got a pretty big fan club, which is interesting to see.
And, you know, in the absence of, like, I tend to believe in sunlight. As a sort of measure here on all this.
The true remedy to false speech is more speech, not less.
Yep.
Yeah. I'll agree with that.
And the thing is it's really hard to look like a badass when you're in a court proceeding, right? So I feel like most people you start seeing, you know, that's when they get to start calling the evidence of, you know, they'll get the guy's family members to like identify the body, you know, and, you know, they'll do things like that. And, you know, it tends to, I think, you know, prosecutors are good at like cutting through the sympathy. So I feel like that's, I feel like if we take away that opportunity, we just make it worse.
You know, and there's a case that I might get to, depending, maybe it'll be one of these mid-break things, but the Zachary Hughes case, I watched a little bit of that defendant going sideways on the stand, and whoa, that was a choice. But that actually might be one of those very specific reasons why you would want the court camera there and the camera there so they can see the testimony being given and view it for what it is. So
also, I did love the comment that was just dropped in chat of sunlight is the best disinfectant unless you're cleaning Diddy's hotel room.
In which case, I might suggest just a matching gasoline.
Yeah, I was going to say, in which case your solution is fire.
Yeah. Yeah, that's now I'm going to be traumatized for that thought. Mispronounced name. Blink twice if Canadian sabotage why you're late. I'm not late because of Canadian sabotage. AG, thank you very much for the super chat. I had to quit my job. They announced they were going to charge for the AI BS they forced on us.
What?
I'm not giving up. No way. I'm not giving up. Starting steno school in the fall because I loved what I did and want to take the next step. Happy Friday. Happy Friday, AG. I hope that works out well. AG had studied, actually kind of throughout the process of me being online on YouTube, had studied and passed and become certified as a court reporter. So the AI thing is interesting to me. Speaking of an odd court reporter story, my partner had so finishing this thought, AG, best of luck to you. My best wishes absolutely go out to you in that pursuit. One of my partners had a trial, 3-day contested trial, financial issues, equitable distribution, divorce. The judge at the end of the trial ordered the parties to pay for the full trial transcript prior to the court's ruling. 3 days. It was like $12,000. And the judge was like, yeah, you wanted to do that. I just didn't think a judge had the authority to do it. Apparently they did. So it's quite the hefty cost. Vez is telling you, Ian, that her bot arrived even better in real life.
Oh, that's awesome. I am getting the stuff sent out for the auction. And the thing is it, there's so much stuff to send out, and it's, I'm just like, next time I got to figure out a better organization for all of this. Cause, so many things, but,
I've still got 3 pens that are being sent out because I'm printing different cases for them.
Oh, nice.
And I'm testing the print settings for different cases. Like one of the cases is sitting right here and I need to send it out, but one of the cases is shaped like a gun case, but it didn't print right. So I got to fix it, but it's for one of the smaller pens. So I've got to send it out. I'm still printing the case. I'm sorry. I'm trying to make it perfect. I'm trying to make all these perfect.
Fair.
but I think everything else I needed to send out was sent out. But Casey Cat, hey, Rob and Ian from frigid Kansas City. Hello back to you, Casey Cat. Jill Moore. I was hoping to watch the entire stream, but been awake about 35 hours. That's a good reason to go to sleep. Caught between wanting to stay awake for the stream and trying to sleep. Trying to sleep is usually the better alternative. We'll be here on replay. We love replay crew. Baby Steps 22, 20 plus months of law and fun. Thanks, Rob. Thanks, Mods and Ian. Been here since day one. Took a bit of a become a member. Give a hug to Leo. Let's roll. Leo will get a hug. He gets big hugs at the end of the streams. Cherry Mills celebrating the 2 years clear. Cheers to you. Patty Hoffman, Zora needs her lawyer. She's fine.
Would you believe that Zora's never actually met her lawyer?
That's true. Just on the phone, or not on the screen.
Her lawyer is failing in the duty of
rude. Yeah, people are saying rude. People are saying my audio is funky. Let me make sure I've got the audio on the right. Try that. Maybe that'll work better. Oh, it was I had the gain setting up really weird. Thank you, Petty Hoffman. That's very kind of you. Book Dragon KSC. My 5th grader had a mock trial in homeschool co-op. He was a juror and ruled not guilty for reasonable doubt. I am so proud. I am so proud. He learned it from eavesdropping on y'all. I am so proud.
Cheers to that.
I did get a chance to watch your Monday stream covering the interview by Tournament.
And you have some thoughts. You have some feelings.
I think as in general populace, the general populace, I've made this comment before. I think people have grossly misunderstand what beyond a reasonable doubt means. And I think that lawyers do a really crappy job of explaining it. I hate that analogy, the rain analogy, where it's like if you walk outside and there's water all over the grass and all over that's beyond reasonable doubt. It's evidence that it was raining. I think it's a bad analogy. You got to find a better way of doing it. Because when you have a jury that's kind of going, someone's dead, she was there, and there's a vehicle with damage, and they're stuck on that point, and they're finding that that's beyond a reasonable doubt, somebody failed in giving their instruction at some point in time. So I don't know whether that was entirely the case. You have to take all of this with a grain of salt because we're not in that room. But holy crap. People are too quick to go to this. They're accused of a bad thing. Therefore,
and that's the thing is they straight up said, like, it would have been nice to, have answers to all of these other things. And there were these other people who were super suspicious, but, Karen Reed's the only one who was charged. And I'm like, oh no, that is not how this works. Right. Like, no.
And it's funny because it's an unspoken thing that we all know walking into a courtroom. You walk into a courtroom. But it's just
the thing of, if you're not guilty, why are you sitting in the guilty person chair?
That one. And he actually had a judge get removed from the bench in New York. Was it New York recently for those remarks?
Yeah, although I suspect that one was actually the judge just wanting to get out of jury duty. I really hate it because and I don't know what the cause is. I don't know if it's because, honestly, I think there's a whole lot of media coverage that puts people in this position. The media covers so many bad stories in such a light that, once the accusation's made, the assumption that you did it is there. Well, and you look at how the media covers acquittals, right? The media never covers acquittals as if it's a celebration for justice. They always cover an acquittal like it's. And the thing is the average person, like the media, we have this notion that the media is intended to, that their purpose in society is to educate us and inform us. And that isn't really it, because their purpose is to sell us advertising. And so they often do that better by making us angry and upset than they do by informing us.
The 24-hour news cycle example.
Yep. You get better coverage a lot of the time on YouTube because, you know, at the end of the day, it's like, well, I'm not bothered if you guys are upset by the result. I will just tell you what the result is. We can celebrate a good result. We can, you know, be upset about a bad result. We can whatever. But they always just go like, they always present it as if, you know, it's a criminal got away with things, right? And that's the wrong way to think about it.
I finally got the question from Mini Mischief 1. And by the question, when I say the question, it's going to be clear. The question that you will always get, no matter what, as a lawyer. And I got it this week from.
How do you represent bad people?
That one. Exactly that way. It was a phrase exactly that way. How do you represent, or how do you decide to represent someone who did something bad?
I mean, and it's family law. Everybody did something bad.
That part was one of those that's, because I haven't gone into the whole description of family law to her. I'm not going to put a kid who's in that position through that dialogue at her age and explaining how I go into court to argue how much time a child can spend with daddy and mommy. I'm not going to do that.
Right.
I kind of describe it as I help families solve disagreements when they can't agree on something and they need a judge to step in and make that agreement. I'm the one that has to present one side of that discussion to the judge for the judge to make the judgment call. But so it's easier when there's family law cases, because largely speaking, in the context of divorce, custody, visitation, there are no such things as the pure and perfect victim. There's no such thing there. But it's also one of those where that type of law is so inherently gray that it becomes easier to have that discussion. Because it's very rare that, you know, you run into a case where someone stabbed somebody else and I've got to represent the person who did the stabbing. But it was explaining how, you know, you got to put the state to their burden. You got to make them prove certain things. Like I was trying to explain how every one of the things that we have as rights exists because maybe I was a little hyperbolic of discussion, but things that we have as rights exist because someone bad did the thing and some lawyer argued the case and that right was created. So bad people are the reason why we have certain rights, and those rights exist because they exist for the bad people too. So,
yep. I mean, every right you enjoy exists because it was litigated in the context of somebody who was accused of doing something bad. And in many cases had actually done something bad in like a factual sense. You know, if you're asking like, why do the police not get to search your car? It's because they've had so many cases where they've searched a car, they found evidence of bad things, and that evidence gets thrown out. It is, in fact, the most effective and really the only effective remedy that I've seen to prevent police from invading your rights, is that they know they won't get the benefit of it. So
and this combat witness is I'm not bringing up for to bash you here, but this is conflating the issue. Victims absolutely have they have the right not to be a victim. You have the right not to be victimized or injured or hurt or anything like that. But the state is bringing a prosecution to incarcerate the individual accused of doing the thing. They're depriving the individual of their life, liberty, or property, and therefore they have to satisfy the elements of due process in doing so. The rights that we're focused on, the rights that you're focused on in a criminal trial are the rights of the accused. That's the focus. It has to be.
Yeah.
So that is absolutely what happens. Ohio Palma, my dog has had 3 ophthalmology visits. Oh my gosh. That's not a cheap. Yeah. Sorry. JMcRN, hey friends, hope you're doing well. Rob, message on IG. I don't use X anymore. I'll take a look. JMcRN, thank you. I'm very rarely on any of the social media platforms because it's the time part. But then JMcRN very kindly also gave 20 memberships. Thank you very much. And we also have gifted memberships from Just Because. Thank you. From Joshua. Thank you. From Fiona W. Thank you very much. From Sandy. Thank you very much. Michelle Doverspike became a member. Thank you, Michelle. Phoenix, member for 26 months. My gosh. Mama Betts became a member. Thank you. Jessica, hello, everyone. Hello, everyone says back to you. That didn't make any sense. But everyone says hi back. Destiny Salazar, 1 year with the best of LawTube. Thanks, fellas. Thank you, Destiny. I like the way you spell that, too. Destiny. Thank you for gifting memberships. And then thank you, Destiny. Robin, R&R and BNL. RRBL. Oh, Ryan Reynolds, Blake Lively are both child actors. I think that says a lot. Hollywood's a weird place. Very weird indeed.
And Hollywood used to be a lot more democratic than it is now, in the sense that it used to be that there was a lot more people in Hollywood who got their start by just sort of, risking everything to go to Hollywood and take their shot, or whatever else. And now there's a lot more people who are like the raised into it children of people who so there really is becoming kind of a Hollywood aristocracy. And so it's not all that surprising that we're seeing like child actors and so forth. But yeah,
can't really grow up a normal life when you're living like that. That's can't be easy. XCDA, I rewatched the Colin Griffith portion of the last FNF. So very interesting. Thank you, XCDA.
Yeah, Emily noting it's just Nepo babies. It's Nepo babies all the way down.
Oh yeah, Hollywood is that. It is that way. Now there's some people who break out in Hollywood who are not Nepo, but it's a weird crowd.
It's less now than it once was, and it's getting less all the time. Because I mean that the same thing even happens within YouTube. The number of times you find out that like somebody who just comes out of nowhere and achieves this great success turns out to be like, the best friend of somebody who's got like 10 million subscribers is like, okay, right. That's where that's coming from. Gotcha.
Hey, I don't have 10. Just kidding.
Well, that's the thing is there's a lot of that happens.
Oh yeah. Tara Iced. I love the name, by the way. That's really funny. Tara Iced. Try changing food to ProPlan sensitive skin. Don't let any food with chicken in it. I think that's the next goal, is finding the right food for sensitive skin. Cross stitch 626. Something's up with Rob's sound on the high end. I've messed with a little bit. Hopefully that helped a little bit. You got to let me know if it's continuing. Not sure how to fix it at this point. Unhinged. Honey Badger. Been an emotional day. Boy drama I don't need at 28. Don't be dating boys at 28. I know it's you don't deserve boy drama. So we're gonna try to make sure that.
I was gonna say, Rob, that's probably a little unrealistic, but
I know, because men are boys. I am still a child, admittedly a child. Destiny Salazar, I'm so grateful. My neurodivergence has led me here. Y'all are solid dudes, and the chat is awesome, even for us lurkers. Chat is amazing. You guys are all amazing. Some of the greatest people on the internet. Equality, only -3 degrees Celsius right now. I'm so happy it's not 30 degrees negative anymore. Nope. AG, not a court reporter. I was a certified legal transcriber. That's right, the distinction. I want to become a stenographic court reporter, and I'm excited to start in September. That'll be a lot of fun. It's got to be a challenge. Queenie Bly, love FNF. Hope you two have as much fun doing it. We do indeed. I do, at least. I know that you
wouldn't do it if we weren't enjoying it.
WW Mangione, not having cameras is New York state law. Learn something new every day. Light Queen, we had a minor earthquake on the island today. Everyone was talking about it, but hardly anyone actually felt it. Only a 5.1. Good God. Okay, that's not minor. that's okay. 4.8 on the US scale. That's quite the earthquake, my dear. John Scott, there's a lot of victims' rights legislation that feels good, but that legislation makes the rights of the accused even more confusing to the general public. It shifts the focus away from the rights of the accused.
Well,
it's a tough balance.
The other thing that becomes difficult is that sometimes you don't know who the victim is or if the victim is until after you've run the trial. Because I've run trials for people who were, where the person who was the victim turned out to be the aggressor. And I mean, not even that. Like, guy gets reported to police and the other person says, this guy attacked me out of nowhere. And then when it gets to trial, it's like, well, was it really out of nowhere? Or was it that you actually put a knife in the guy's face and said, hey, I want your wallet? Because, it's like, oh yeah, why did you get hit? Because you were trying to rob the guy, and when that comes out at trial and the court is like, yeah, that is actually what happened. Then, the person who was the putative victim was actually, the problem. It happens a fair bit.
Well, and this is also why you look at the Blake Lively and Baldoni case, and is neither one of y'all should be holding the banner for the rights of all the other victims that are out there. Like, I hate that when
every time they try to make a case into like that this case is a representative of all whatever, and I'm like, no, don't do that, because what it always turns out is that these are not actually, they keep picking these representatives as like, this is the poster child for the cause, and they turn out to be awful poster children. Like Amber Heard was trying to present herself as the poster child for abused women, and it's like, no. Don't, like,
I was trying to explain it the other day of sometimes people look at these issues, and I mean all issues, like legal issues just aside, from the different perspective, right? They look at it from the minute case up instead of from the basic rule down. Minute case up, you have a case and circumstance where you see something terrible that occurred and you believe that that needs to be remedied, and therefore you want to pass something major to address that situation, make sure that situation never happens again. The problem is that when you do that, you affect a whole lot of other cases and a whole lot of issues. So the easier way is to start from the main rule, and then you have a discussion among the body politic about where are you going to create the exception to the rule? Where does that main rule have to give to accommodate certain circumstances that we didn't really predict, or we could have predicted, but we still needed the main rule nonetheless, right? So search and seizure, no unlawful search and seizure. That's your main rule. Start there. And then you briefly and narrowly expand that to allow certain exceptions based on the circumstances that might arise. And the problem that we have is that those exceptions, they naturally take a long time to discover, because you aren't immediately faced with the cases where that's going to come up. So a lot of this one is when you talk about the context of victims' rights, right? So there's the Sixth Amendment right to face your accuser, right? The right to confrontation clause. And in the United States, that is damn near absolute. And it needs to be, because when you start creating exceptions to it, then the question is, well, how do you assess whether the exception is warranted or not? And what abuses can occur based on making that exception, like calling that exception, allowing it to take place. In Canada, don't you not have the right to have to face the accuser?
It isn't the same right. So for instance, we'll have trials where, for instance, very commonly in like an SA trial, what they'll do is they'll have the, like a screen that is, for the person to, and there's various ways they'll do it. Sometimes nowadays they'll do it with like cameras. Sometimes nowadays they'll do it with, They might have like one-way glass or, things with mirrors such that the person is visible to the accused and visible to the court and visible to all counsel, but that the accused is not visible to the person who is testifying, right? Because if the allegation is of a serious, essay or the like, then maybe they don't want to be looking at that person while they testify. And sometimes you do get accused who try to like make faces at people and stuff like that. So I had a file. It was not my client, but it was a co-accused sort of organized crime kind of file, like gang membership. And the other accused kept making faces at the witnesses that were like, sort of like aggressive, threatening faces. Mm-hmm. And, after a bit, the judge was like, I'm ordering screens for every witness so that he can't do that. And I was like, okay. So yeah, it's a thing.
It's interesting. And I think the discussions around it end up becoming very important, especially when you have the cases like the Karen Reed case, or when you have other cases out there where people do get acquitted at some point, or there's a question on the evidence of what it proves or doesn't prove. For example, the discovery question, right? Blake Lively in her case, they're asking for a protective order to prevent outside disclosure of medical records. That's
100%
legitimate.
Appropriate.
Oh yeah, that's 100% fair.
And absolutely. The thing is if they revealed revealed the medical information, I wouldn't cover it. Right? It's like there's just no. It's hard to imagine there might be something relevant there. And Emily's saying having screens to stop the mad dogging is wild. The other thing is that the mad dogging aspect, we do mostly judge alone trials here. The judge was super unimpressed with the mad dogging, and my client was acquitted. The other guy who was doing all the mad dogging was convicted. And I kind of have a suspicion that his facial expressions might have helped him get convicted. So it may not be a good idea. So
yeah, it's not the smart thing, but yeah. So I'm fine with protective orders against public dissemination. I don't have a real big issue with that. Protective orders precluding other parties from getting information when you place the issues at issue, I have a problem with that. But that's a whole nother aside. And again, talk about tangents. Gwynnie Bly, Dad was a cop. He didn't play politics. Unfortunately, politics play a big part in their methods. Conviction above all. Dad was 15 years, one promotion. There are good ones out there. R.I.P. Dad. R.I.P. to your father. Indeed, rest in peace. But this mentality that we drill into prosecutors of your job is to convict, not to find justice, is a problem. And it's not that you drill it into them, it's that their actual practical experience on the ground in actual prosecuting cases and the feedback they get from their superiors, it's the feedback. You're not going to set a criteria if you need these conviction rate or you need this, you can't do that. But when they go back to their superiors and the entire office discussion is about your win percentage or all of these other things, and it's not so much just what's the result of this case, you build a culture.
They talk about like, you just need to play every case fair. But when it comes time to hand out the promotions, did you win that big case? Becomes a thing. So
Emily says she loves seeing the difference between the systems. I think it's really fascinating too. I love that. Yeah.
The other thing here is that if you are self-represented and it's a file where there's intimidation issues at hand, like usually domestics or SA files, the court will actually often appoint counsel for the cross-examination. I've done that several times, where literally your only job on the file is that you come in, you cross-examine this one witness, and then you leave. And it's just so that you can't so that you can't harass the the person and abuse them.
Let me give the chat an example that they're going to hate, and they're going to hate me for it. They're really going to hate me. Oftentimes in the cases that I have, there are allegations concerning conduct around children. It's not always what you think. It's not their super negative conduct, but sometimes it's simple. It's like the allegation is that the child observed one of the parents drinking to such an extent that they passed out while they were supervising the baby, right? Mm. And the allegation came from the lips of the child. So if it tries to be brought in via some other context, you get a massive hearsay objection. You cannot have someone else walk in, speak to what a child said, they observed, and have that be brought in for the truth of the matter asserted. So the remedy that a judge will oftentimes ask is, am I allowed to speak to this child in camera or in chambers, where the judge takes the child back behind in chambers, just the judge and the child, and asks the questions. Here's the challenge, and here's why I say people are going to hate me. Some children are coached. Whether it's directly coached or whether it is subtle messaging that's just been dumped on that child by their surroundings. And with some children and some allegations, I put my foot down and I require that that child testify from the stand. It is not fun. I hate it, but I'm the bad guy. I have to be the bad guy because my client has the absolute right that if this allegation is being made and the specifics of the allegation is being made and my client denies that that took place, that I have the right to hear what that child is saying, and I have the right to listen to exactly how it's being said, and I have the right to cross-examine that child. And the judge cannot cut me off and say, Mr. Morton, I'm not going to allow you to ask questions of the child. That's against my client's confrontation right. So I absolutely will sometimes be put in a position where I have to ask very hard questions of a minor child in an allegation involving their parents.
It can be rough.
So it's not fun, but that's why those things exist, because it's a balancing act and certain things have to.
The other thing that I very much recommend is, you got to cross-examining children in a way that is not traumatic is a skill, and, people have to learn it. And so it's, I would say it's, and it's important because nobody, like if you're in front of a jury, the jury does not want to see you being crappy to this kid, and they will not put up with it. So, you've got to make sure that you are, that you're not in that, that you're not, making them angry and so forth. And the other thing is it's ineffective. You never accomplish anything.
Oh, they shut down.
They shut down. They won't, answer truthfully, which is what you need. And they won't, you'll just, you just get them to, if they've been coached, you get them into, well, this is a bad situation. What can I do to navigate this? They'll fall back on the coaching 100%.
You can find it with, one of the key tips is if the child who might be 7 is throwing out the word perfectly pronounced, disparaging, and you're going, okay, where'd you learn that? I don't give you the benefit of the doubt. Some parents out there really do teach their kids a lot of linguistics, but disparaging is one of those words that is kind of unique to the family law system. And we see it a lot, but when that word comes up, it's usually one of those really, but you're right. There's an art to examining certain kinds of witnesses, and it's very difficult. If you see a first-year practitioner try to ask those questions and they do it clumsily, and you're just grimacing because you're just going, please God, make it stop. Please make it stop. Please make it stop.
Yeah.
Which funny story. Actually, this is here we go. We're going to do a palate cleanse. We're going to go our topics, right? So palate cleanse. It's a double punch palate cleanse. And we're talking about youth the innocence of youth and the joy that youth brings. And we're going to do it in two contexts. So first, Mini Mischief 1, in her full ADHD self, she's not diagnosed, created this. And I happened to discover this.
She's better organized than I am.
This is amazing.
And it's not close. It's
this 6:45, first alarm. 6:46, wake up. First of all,
first of all, I've never accomplished that in my life.
6:50, get out of bed. Well, at least she gave herself a 4-minute buffer there between, wake up and get out of bed. That's 6:52, use the bathroom. All right. 6:57, she gave herself a window for the bathroom. I appreciate that too. Have a drink of water. You know what? I love this. This, reminding yourself, ladies in the chat, write yourself notes of times to have a drink of water. 6:59, make the bed. God, I wish you would do that more. 7:04, get dressed. 7:08, hair time. Now, adult ladies in the chat, do not disparage because she is a mini. Her hair does not take 30 minutes. She has given herself a very, very neat window in there. Then she gave herself 7:22, eat breakfast, 7:42, teeth. And she gave herself exactly 2 minutes because there's a timer up there. 7:44, make lunch. 7:56, fill a water bottle. 7:58, check homework. 8:06, relax. And then 9 minutes later, 8:15, leave.
I like that she's got a relax window in there. That I feel is a very, that's a very good thing to put in your planning.
And then the up top, I mean, the only criticism about the entire thing is anytime in between, which I really need to start enunciating those words carefully, in between, because in between, she says it's time to read. However, to your point, this is a very thorough list that encompasses and details all of the things that would need to take place before breakfast or before leaving the house. So I was remarkably impressed.
Yeah, no, I do not have my my crap together. Comparatively, my poop is entirely ungrouped.
I see the chat is all doing a whole lot of self just destruction. 6:45, first alarm, 9 a.m. get out of bed. Hair time for me takes at least an hour. I have really long hair. Let's see. Oh, this is an interesting point. Denicia, early childhood development degree. The class in the rabbit is an example of how easily a kid will be swayed. Talk about bunny in room, no bunny. By the next week, every kid will talk about the bunny. It's child persuasion is very interesting. And the thing is, when I say parents, there's no person that's the pure victim or who's 100% in the right. Is that both parents rub off on their kids and they have negative traits they leave behind. It's not possible not to. But that was a proud moment. So this is youthful pride and very, very enjoyable. And then the other happenstance of this week was that my young associate, the first year associate, had his first status hearing that I supervised. So he was covering a case. He was in front of a judge that is, I was trying to explain it to Mini Mischief 1. I said, the judge can be a little rude. And she goes, oh, aren't judges supposed to be nice? I said, oh, honey.
Oh, honey. Sweet summer child.
Yeah. Yes. And she goes, why is she a judge if she's rude? Well, maybe
now the question is, can you bring her to court to ask that question? Because that would be the best thing.
Yes. Judge, here is a sweet, innocent child who is asking you a question. Please do not hold me in contempt for the words of this child.
Yeah. How can you be a judge if you're rude?
So this judge, and I said, I told Minnie 1 that maybe I didn't mean rude. Maybe I just meant very stern and requires a bit of pushback. Like just is going to ask you and challenge what you are saying is the truth. Well, Nathaniel, young associate, was there for his first status hearing, and it was so God, I hope I don't sound demeaning or belittling. I don't mean it this way at all. It was adorable in like the proud person way. He goes in, he's dressed to the nines in his suit. It's a status hearing. He's just setting a trial date. And he stands up immediately and he's got the chest down. He leans over to the microphone. Your Honor. And he says name for the other person, just right into the mic. So it's like now booming the courtroom. and every sentence he says begins with and has a pause. Like it's a question instead of a request. And I'm just sitting there in the gallery and I'm just reminding myself, you have
Rob,
to
that was you one day.
I know. I used to let him swim, let him swim, let him swim. And then opposing counsel, who I've had cases against, throws him a curveball. And I was looking over, it's like, you son of a bitch. Like, that's not fair. Throws him a curveball. Well, Judge, I don't think we need to set a status date or a trial date. We can set another status. We want to negotiate. And proud me looks on as Nathaniel leans in the microphone. Judge, I don't think another status date will work. Their last settlement offer was laughable. I'm going, oh yeah, baby. There you go. Take a swing. But it was so staccato, and the questions were, or his comments were so delayed in their presentation, and the judge every few seconds is looking over Nathaniel's shoulder at me, and the judge,
and you're like, nope, let it ride.
I did. The judge issues the order, sets the date. He does everything right. He turns around, he shows the client the order before signing it, then turns around to me and shows me the order so I can take a look at it. And as the judge is getting up, or as he's finished, the judge is like, if there's nothing else, counsel, have a great day. And he gets up and he walks around, and I pat him on the back as he's walking out of the courtroom. And I look over at the judge, and the judge looks back at me, and the judge smiles and does one of these, and he goes, he'll be fine. Yeah. And I was like, yes, yes. That was awesome. But it's when you kind of realize that this practice of law, while adversarial, is intended to reach good, fair, and just results. And we need good lawyers to do that. So instead of tearing lawyers down, you want to build them up, and you want to do it in a fashion where you're teaching them skills. And some skills are learned via hard lessons, and some skills are learned via positive encouragement. So,
and I remember I had there was a junior, very, very junior prosecutor that I had to file with. And he made a misstep, and the court was basically getting ready to savage him. And I sort of stepped in, and I'm like, oh, no, yeah, he made this mistake, but it's not going to be a big deal. We can solve this. We can resolve it. And basically got him out of the trouble there. And the degree to which that earned me like favor with that prosecutor later. Because later when it's like, hey, I need a favor, and the guy's like, yeah, we're good. So long as you're not asking for anything that's going to, be a problem. It's like, yep. So.
Well, it was really interesting.
Don't burn people.
No, don't do that. And, like I said, you want the best lawyers on both sides of the aisle, because that's how you reach the right result. And when you see people building each other up in the practice of law, I always want to draw attention to that. And this judge and I have had our disagreements. And by disagreements, I mean, there have been some tense moments in a courtroom when it's clear we're not going to see eye to eye. And I have made my point 2 or 3 times, and I've made it once more because I've got that dumbass stubbornness that just won't go away. And I've been doing this long enough where I can push back and know when I can push back, and sometimes push too far. It also happened to be that the lawyer he was covering for wasn't me. It was actually our main boss. And this judge hates that lawyer. Just hates it. So on the notice of appearance, it says the partner, and it says the associate under it. So when the notice of appearance gets filed, the judge is thinking that the lawyer that she hates is coming in front of her. I was like, oh, don't worry. She's pleasantly surprised. You're good. You're going to be happy. Yeah, she's happy. So
yeah, She thought it was going to be a headache. It's not a headache, so it's all good.
It's not. Yeah. Okay. 1 hour and 20 minutes in, and we're getting to our first topic. Let's go ahead, double swoop. We'll get to our first topic. These are stories. Guys, I haven't been on the air 2 weeks, so there are going to be stories. I'm sorry, ADHD brain took all the sidetracks. I'm sure we might take a few more. Let's go ahead and do this swoop, and then we'll get to the topic of Karen Read. That's going to be the easier one to handle, and the one where we're going to have some opinions. Because, and by easier, I mean I have all my timestamps pulled up, and I don't want to ruin it. Swoop. And for good measure, just one more. Okay. So, Karen Read was back in court this week. And lo and behold, Judge Beverly Cannone was irritated. However, it wasn't as much sighing. There was breathing.
Well, I'd hope there's breathing. If the breathing stops, court gets interesting.
Well, you know what I mean. There was breathing. The breathing was just not.
There was very aggressive breathing. How about that?
Subtle. Yeah. We call it.
There was breathing with a purpose.
It's almost screaming with your breath. So let me see. There's the motion to compel. I'm going to share the screen. Make sure that's embiggened. Make sure we've got the closed captions. And we have got hang on. We have got noises. That's what we've got. Because instead of having it open in the browser I'm streaming in, I had to open a different browser, which means that it won't let me share it via tab. Now it will. And share screen. There we go. There we go.
Got it in 7.
Easy, buddy. Let's see. Forensic sound copy. That's not the one I want to cover. All these motions. So I made the comment about the Karen Read filings before that I very much wait until rubber meets the road with this, because both sides tend to be rather hyperbolic in what they put into pleadings. And when it comes to what is actually demonstrated before the court, it often is not really what they promised it would be. It's not as emphatic.
Yeah, there's a little bit of shading that happens on all of that.
I think it's right. Let's see. It's right about here.
It's not the opinion that troubles me. It's the relationship, and Commonwealth should have an even playing field. Saturday, June 22nd, Daniel Wolf writes, Alan, I spent some time this morning putting together a brief outline of my qualifications.
Hang on. I zoomed in too much. Side note for 1 second. I wanted to like Brennan. I really wanted to like him.
I liked him a lot less after this hearing than I did before.
I really wanted to like him. And I tried really hard.
We're sharing feelings on that one.
And then it was just like every argument became a whining. I don't care for the way that Yannetti argues. I don't care for the way that Brennan argues. Yannetti, I think, is way too hyperbolic, and I'll emphasize that in a minute. But Brennan is just whining.
Everything was World War III. Like they had no chill at all.
Your Honor, my purpose is not to deprive the defense of an expert.
Oh, isn't it?
Deprive the defense of an ARCCA expert in this case. But there has to be a minimum requirement of reciprocal discovery and discovery before a party can call a witness. It's not enough to say that the witness is helpful or unhelpful. There has to be full disclosure when calling an expert. It's interesting that the defense's position is that the information is unavailable to them, and that since there's been a voir dire and trial testimony, that should be enough. Well, what the government worries about is that there is other things that are relevant, like compensation, promise, reward, inducement, whether there's collaboration between one side or the other and that expert witness that they don't know about, they can't ask about, that there's some type of bias or favoritism that the expert might have towards one side for whatever reason. So if that information is not disclosed, then it is not only an impediment.
I'll give you your first hit. This is also one of those things of, do you need to make this argument? Like, you could have fast forwarded through the first 2 minutes of his argument and not been there. Experts for the Commonwealth are going to be favorable to the Commonwealth. They're going to have biases towards the Commonwealth. Experts for the defense are going to have biases towards the defense. Now, when he starts to get into the meat of the discussion, that's when I get very curious.
It creates a position where it is an unfair examination. It's not the ARCCA witnesses that I have the issue with. It's the fact that I don't have adequate discovery. If the defense is going to be a proponent of those witnesses, they have obligations, Rule 14 obligations for basic discovery. Now, I wasn't at the last trial, but I've read the transcripts. And on June 10, 2024, you asked the defense about ARCCA, and it was represented these experts were hired by the federal government, and they provided a report to us pursuant to a TUI request. It was specifically outlined and ruled that they could not prep with us for trial. Could not prep with us for trial. And so Your Honor said, so I am to believe that the defense is calling 3 witnesses.
We're going to get to this exact clip.
That you've never spoken to and putting them on the stand here. And the answer, that's essentially it. We've spoken to them only for purposes of coordinating their testimony and their background. We've not been able to interview them regarding their findings, which are outlined in detail in the reports that both sides have. Your Honor said,
hang on. I didn't catch that. He put emphasis on a word.
Their testimony and their background, we've not been able to interview.
Did he put emphasis on the word interview?
He did. That's what he's talking about.
Them regarding their findings, which are outlined in detail in the reports that both sides have. Your Honor said, I don't see that as being the report. I don't see that as being detailed. It leaves a lot of questions as the gatekeeper as to what they can testify. And you have not complied with your Rule 14 obligations. And the defense says, we can't, Your Honor. And Your Honor said, so you can't, but you haven't. So I'm left with that you have not complied.
So where in the transcript is this?
On page 2812 and 2813.
Here, Judge, we're going to help out. We are going to help out because we have the means via, technology to, what was it? Wayne's World, and then they did the rewind, right? Yeah, no, just me. Got it. Cool. Love it. Thank you.
I was a fan, so yes.
Killing me all. All right, Yannetti.
So you've changed. You're not calling Frank Sheridan,
no,
right?
No, we're not calling Frank Sheridan.
Right about here. All right, so we are now, for everyone that's wondering, we are now back in time. We have, through the magic of internet, gone backwards to the actual argument that's being referenced. The very day, the very words, the very argument being referenced.
Please, all right, I'm going to stop you. Please direct your comments to Rule 14 and the reciprocal discovery obligations. That
this was what pissed me off.
It's about the 5th line down. It starts during a final pretrial hearing on February 15th, exactly as I said.
Okay.
All right? We pulled the tape from that February 15th hearing. Here is what was actually said. This court asked me the following, quote, while we're talking about DNA, Mr. Yannetti, do we need to be concerned about canine DNA? Where do we stand with that? Yeah. I replied, no, I think this is the only outstanding DNA issue. The court then replied, okay, so all right, we're not dealing with canine DNA. And I said, no. There is nothing in there, contrary to what the Commonwealth has represented to this court in a public filing, that I said there was no canine involvement. There is nothing in there, contrary to what the canine represented to this court and to the public, that the defense was not pursuing such a claim. Can you imagine the nerve of the Commonwealth to spin that into this?
Yeah. And I went back further just because I wanted to capture that little bit, because there was part of me that was going, you know what, Judge? I get it. You know,
she really hates when she really hates when they get snippy at each other.
When he's like, could you imagine the nerve? And it's like, come on, like the jury's not here. The theater can stop. The problem is Brennan does it too. And she doesn't really play it down the middle. It really is, but Yannetti does the same thing in response. He gets very dramatic in his recitations here. Let's see, where were we? We're right about 9:30.
Frank Sheridan,
no,
right?
We are calling Frank Sheridan.
All right. So you've got a new medical, Dr. Russell. We'll do that part of it separately. Tell me about what you've provided the Commonwealth on Chris Van E.
They've gotten his CV and they've gotten the substance of his opinion from us. And they've had that for a long time. And the court, I believe, has already suggested that voir dire will be done prior to his testimony.
All right, so it's starting to look like we might need a whole day of voir dire, and I'm trying to avoid that. So is the Commonwealth satisfied that when did you provide anything recently since the filing of the Commonwealth's motion, Mr. Yannetti?
Not on Mr. Van E, no.
What does the Commonwealth have on Mr. Van E?
On Mr. Van E, all the Commonwealth has is what's contained, the synopsis on page 2, the first full paragraph. We do not know what his opinions are. It says he'll testify regarding his opinions and conclusions about reconstruction and EDR data obtained in connection with this case. He'll testify to chronological data derived from the EDR, including key cycles and triggering events from the time period in question. I have no understanding or information about what chronological data he's going to testify to, what his ultimate opinions are.
30 more seconds. Hang on. 30 more seconds.
On and exactly what his opinion is. All right, by the close of business tomorrow.
That's fine.
All right. Now, regarding the 3 experts from ARCCA. So I've read that report. I can't tell who does what or what the basis of their opinion is. So what have you provided?
Your Honor, we've provided everything that we know. We've mentioned to this court at sidebar, these experts did not arise from us.
I understand that.
These experts were hired by the federal government, and they provided a report to us pursuant to the TUI request, and it was specifically outlined that and ruled that they could not prep with us for trial.
So I'm to believe that the
specifically outlined a rule they could not prep with us before trial.
The defense is calling 3 witnesses that you've never spoken to and putting them on the stand here
that's essentially it. We've spoken to them only for the purposes of coordination of their testimony and their background. That's it. We have not been able to interview them regarding their findings, which are outlined in detail in the reports that both sides have.
See, I don't see that as being
Now we're getting into the sum and substance of what might be concerning. There's a whole lot of words that are very carefully chosen, and then a couple that are awkwardly chosen. So let's go back and see what Yannetti actually says about these experts.
Essentially, we've spoken to them only for the purposes of coordination of their testimony.
All right. Coordination of their testimony. There's an ambiguity in that specific phrase. Coordination of their testimony. Do you mean logistics of getting them to and from and housing them while they're testifying? Or do you mean coordinating what scope of testimony that you're seeking to elicit, which would possibly engage a back and forth on this is the topic I can testify to, this is the topic I can't. So there's some of that coordination issue. Okay.
Yeah, I mean, there is a...
That's it.
Ah, crap. The flamethrower company ships with UPS.
Oh my God. Okay, yeah. But you were saying there's the
the question of just how far they went in talking to them. And there is some real risk here. There's some real risk to defense counsel if she finds that that they weren't honest or weren't accurate with their representations there.
We have not been able to interview them regarding their findings, which are outlined in detail in the reports that both sides have.
See, I don't see that as being, I don't see that as being detailed. It leaves a lot of questions as the gatekeeper as to what they can testify to.
Well,
and you have not complied with your Rule 14
we
obligations.
can't, Your Honor.
So-
We can't.
So you can't, but you haven't. So I am left with you haven't complied. So we need to get everybody here for voir dire. They can testify in a voir dire, right?
Yes.
We need to do that well in advance of their
Okay,
testimony.
that's fine, Your Honor.
All right.
Yep.
And now tell me about this.
Now, here's my question. Did the conversation, well, I'm putting the cart in front of the horse. So this is this June 10th date. Were there conversations before this date? What were the substance of these conversations? And then were there conversations that took place between this day and the day that they actually ended up testifying? So let's go back to Brennan. So now we're fast forwarding again. And I get the point. Here's the part. Yannetti is frustrating, and I do not blame him. Transcripts are stubborn things. And the transcript is what controls. The words being said. Words being frustrated, being angry, and composing yourself and making sure you're saying the right words is the actual job of the lawyer. You have to. You have to choose the right words, regardless of how angry, frustrated, or upset you are.
The number of times I have had to tell counsel, like, hey, I'm doing your appeal and you screwed up. Because I've done a bunch of appeals for like other lawyers, right? Where the other lawyer runs the trial and is like, I don't want to run and they're like, yeah, I totally can't, preserve this objection. I'm like, you didn't though.
Yeah. And it becomes pretty interesting, the words chosen. And I am still very much, I'm on the fence. I don't know based on this.
Of June 10, 2024. Now, having some familiarity with the federal government, it seemed to me, based on my limited experience, there was much more to the story. So I called the federal government and I tried to encourage them to provide full discovery so that the experts could testify. I was resigned to a TUI letter. I've been down that road many times. It's a dark road that never sees the light of day. So I filed the TUI letter, comprehensive TUI letter. And it was delayed. And over a long period of time with requests and deadlines, I finally received a response that was unresponsive. And it was striking that it wasn't noted as unresponsive. Just when I read the materials, and Attorney McLaughlin actually identified them, they didn't respond to our request. So Attorney McLaughlin wrote back, and then we got new materials, just some. But these materials are the very reason why the defense should not be able to call witnesses without giving full discovery. Having not been at the last trial and reading the transcripts, I only have a flavor for the last trial. So there is email correspondence between the defense, not only the federal government, but the ARCCA witnesses themselves. A recent request for their appearance pursuant to TUI, which I have no issue with. But if we look back earlier in the relationship, what we see back in March 22nd, 2024, is that there are conversations between the defense, Attorney Jackson, and Daniel Wolf, who's one of these ARCCA witnesses. Thank you so much for taking the time to get on the phone with me this morning pursuant to our conversation. Please feel free to forward an engagement letter to this email address. I will get that countersigned and returned to you forthwith, along with the retainer as required. Commonwealth, as I understand it, was not aware of any promised rewards or inducements or payment. They relied on reciprocal discovery order of this court for that information.
I don't really care about that part. That can be explained away pretty easily. If turns out he came back, he's like, no, I'm still under contract with the feds. I can't be engaged privately. That one, I don't care about.
Respond.
Also, Commonwealth being surprised and reciprocal discovery order. There's a whole lot of this that, yes, it feels like gaslighting, like to the nth degree, because you're just going. Funny thing about reciprocal means it goes in both directions. So where's your shit? Where's your stuff?
I hate the reciprocal discovery because I don't have to provide anything.
And you can tell that Jackson's not used to it either, even in some of the back and forth. So, and we'll get to that when I get to the next hearing. But yeah.
Subsequent to our conversation on Wednesday, the U.S. Attorney's Office asked we pause any further conversation until we receive additional information from their office regarding how our involvement will move forward.
All right. So what I take from that, and here's the thing. If the Commonwealth has a smoking gun, they're going to bring it out in this hearing. So Brennan is going to convey these facts or this recitation in the light most favorable to the Commonwealth. Absolutely. So he's going to drop the smoking gun if he has it. And what he's got is conversation that took place, a follow-up email saying, send your letter of engagement or your engagement letter. And then an email immediately afterwards is following up with my justice or department. I can't send you that, which looks like they're not talking about the sum and substance of the opinions. They're talking about whether they can be engaged or not as an expert. They might, I mean, it might've been mentioned. Yeah. That's bullshit or something like that. But I'm not focused on that part. I think it's the other stuff that we get to.
Now, it's not the opinion that troubles me. It's the relationship, and Commonwealth should have an even playing field. Saturday, June 22nd, Daniel Wolf.
I am also one of the very few of the mindset that the right for a fair trial exists for the accused, not for the state. That's my mindset. You ain't going to change it. The state, if you're telling me that the state walks into a prosecution with the auspices of fairness to all parties, with the resources the state has, no.
Yeah, if we're going to say it's going to be fair on all sides, let's have the state fund the defense too.
Not just fund the defense, but fund the defense in advance of the investigation and all the other stuff. The state has been preparing a trial for a significant amount of time, has the entire investigative authority of the state police, all of the associate attorneys. They have the labs, they have everything. So when it comes to the fairness aspect of this, I don't particularly ever buy this argument about fairness to the state. That's just my opinion. Judges disagree with me all the time, but that's my opinion.
Writes, Alan, I spent some time this morning putting together a brief outline of my qualifications. Also attached my D&T list. I obviously won't say what the response is verbatim, but
What's a D&T list? Have you ever heard of this term before?
No, that's new to me.
I have never, Chad, if do not touch. Oh, deposition and testimony. Oh, well, that makes far more sense for an expert. Those prior incidents when he's been deposed or testified. Okay. I've never used that damn phrase ever in my life. Okay. So it's about prior dates and times, deposition testimony. I don't. Chat's funny. Dungeons and testimony. No, not Dungeons and.
Gave you a general sense of what my response would be. Again, I thought your questioning during the voir dire was fantastic, verbatim, but occasions. Also attached my D&T list. I obviously won't say what the response is verbatim, but I gave you a general sense of what my response would be. Again, I thought your questioning during the voir dire was fantastic, so please feel free to make whatever changes you feel necessary.
All right. So that email was after the voir dire took place. So all of Unetti's comments about no prior interview and all the other stuff, those were all factually accurate when they were represented to Judge Bev. Because this email and the exchange is after the voir dire.
Now, this isn't information provided by the defense.
Wow, that just changed a whole lot for me. Are you processing what I'm thinking? Like, are you, or have you already thought that part?
I've been sort of playing around with this in my head. I mean, it's going to be a real interesting hearing. It's Tuesday they resume, or it's the 25th. That's Tuesday.
Tuesday.
It's going to be real interesting.
So
I think I'm going to tell Mrs. Runkle or ask Mrs. Runkle if we can move date night.
So Yannetti gets up and makes his comments about not having the opportunity to interview, all the other stuff, and then Brennan relays to the court. So here's the synopsis. There was an email exchange in March that was looking like trying to coordinate retention of an expert. At the time of retaining an expert, by the way, you never know their opinion. So trying to coordinate retention of an expert, which at that point in time would have brought them within the fold. Then they fire an email back and said, sorry, can't do that. Yannetti says that we coordinated their testimony. And then the judge says, we're going to do a voir dire. They do the voir dire and the questions being asked. And then the expert sends this email to Jackson saying, by the way, your questions during the voir dire were great. Here's a summary of where I would go with it. So right now you are after the voir dire, after the representations are made. And at this point in time, I'm not really viewing this as a reciprocal discovery violation because you're in the middle of trial after voir dire. Do you have to make a supplement the next day?
Reciprocal discovery. This is information provided by the federal government after numerous requests, 2 requests, and an insistent, the best I can, to get as much information as I can. We then have provided an outline of questions and answers for a direct examination. The Commonwealth did not have the luxury, the privilege, did not even know.
Hang on, what did Jackson's associate
This morning, putting together a brief outline of my qualifications, also attached my D&T list. I obviously won't say what the response is verbatim, but I gave you a general sense of what my response would be. Again, I thought your questioning during the voir dire was fantastic, so please feel free to make whatever changes you feel necessary. Now, this isn't information provided by the defense in reciprocal discovery. This is information provided by the federal government after numerous requests, 2 requests.
Yeah, and that's not true.
Melanie Little, look at Jackson. It's Melanie Little, right? The other lawyer on the Reed side.
Yes, I believe so.
Look, the second he says it, she looks over at Jackson.
Reciprocal discovery. This is information provided by the federal government after numerous requests, 2 requests, and an insistent.
You see Jackson mouths back. We did. He says it twice.
Yeah. Best I can to get as much information as I can.
Elizabeth Little. Yeah.
We then have provided an outline.
Yeah. Thinking
an outline.
And she goes back and confirms.
Questions and answers for a direct examination. The Commonwealth did not have the luxury, the privilege, did not even know that there was an outline that was being disseminated by this totally independent witness who took no side other than that of the truth. What follows?
Bro, he testified at voir dire. He got a pretty good sense of what his testimony is going to be, which means you get a pretty good understanding of where he's coming down on the issue before that starts to be coordinated. At that point in time, you're in a different time frame now.
From this outline is then the outline with remarks from this independent expert who knows nobody. So we see in the margins in the notes, this fair-minded objective witness says, so not being able to inspect the vehicle is something that's not uncommon in your line of work. And he writes, absolutely not. And then he comments, not sure if you want to put this somewhere in the direct examination. I have a feeling they, the Commonwealth, are going to argue. I didn't personally inspect the vehicle. I had enough information from the material I reviewed, so it wasn't necessary. Need to show the jury it doesn't matter in this case.
What's the date of that?
It's not dated. It's not dated.
It would have been real, and this is the part that kind of pisses me off about Bev here at this point. If she was listening,
the dates matter.
The dates very much matter. And if she was listening, right in there, it says the questions you asked during the voir dire were good. So you know for a fact this is after the voir dire. And he's reading from an email, right?
This is one of those things that you should have lined up.
I don't like this. Probably. Oh, I'm gonna be mad here in a second.
The TUI request is a recent February response, but they send random documents. There's no real accounting. Now, I'm not saying that undermines the conclusions of ARCCA. Or not, I'm not saying they're not qualified witnesses, but it certainly shows some bias. I've turned over a lot less in this case than this. Another comment. Would it be fair to say because you had a lot of nighttime visibility work, your cases frequently involve pedestrians?
Oh my God, I would have driven a truck through that statement. I just thought about it, what he said. I've turned over a lot less than this. I would have said, yeah, you did. We turned this over. You turned over a lot less than this. Oh.
Yes, unfortunately, there is a direct correlation between the time of day and pedestrian fatalities. Statistically speaking, most pedestrian fatalities occur during the evening and night hours. That would have been nice to have. So my specialty in the area of lighting and human factors result in a lot of.
They did actually testify to that at the trial
important
too.
Stuff in this case.
And voir dire.
And then he comments, if you don't want me to say this, that's fine. That's fine. Shh, don't tell them.
And then they specifically testify to it.
It feels so slimy. I feel so gross. Like don't tell them. Don't.
Yeah, that
like don't editorialize testimony and words on paper. I can't tell if I'm going to be. I don't know.
Have you qualified as an expert in court before? Yes. I realize my testimony, I said it 20 times. When you asked how many I've been qualified, I misinterpreted the question. My fault. 11 trials, 7 depositions. Not sure if you want me to clear that up. I don't know if it was ever cleared up.
Maybe you should know before you make the representation to court.
And then a bill from ARCCA to the defense for $23,925. That's not Trimble. That's not trial by ambush. That's getting duped. So I didn't know any of this, but I've tried a few cases. I've been around the federal court a little bit. I know how it works.
I don't like him. I'm done. I'm done liking him. My patience is gone.
I feel like I gave him a lot of credit, and this felt gross. I really didn't like the shh thing, because it's like you did the shh over something the defense actively elicited.
Well, and it's and I'm still trying to make a decision on whether I believe one possibility of the other or the other, and I want to listen to the end before I make a conclusion.
Sometimes parties pick sides. It creates an imbalance and unfairness, and then it allows the ability to one side to use ghosts. You create illusions and shields and say something's there and something's happening, a federal investigation, and this person, and then this happens.
in what capacity were they allowed to produce anything about the FBI or the federal government or anything else in the trial in front of the jury? Because they weren't. So,
and in fact, the jury basically ignored the ARCCA experts on the basis of
that they didn't know who they were hired by.
We didn't know who they were hired by, so we consider them extremely suspect. They made up that they might have been hired by Turtle Boy. Like, Brennan, you've got your complaints, and
nope, that violin's too big. The violin's too big. It's too big. He doesn't deserve that violin. Not that big one.
I don't care if the ARCCA
they don't make a littler one.
I
don't care if the ARCCA witnesses testify at trial. Yeah, you
then
do, jackass. Are you kidding me?
Them?
That's what I mean. Yeah, you do. Don't. Oh my God.
I mean, if I was the judge, I'd be like, "So you're consenting to their testimony or to their testimony?"
The funny thing is, here's what pisses me off. She does that with Yannetti. She does that with Alessi. She doesn't do that with Brennan
or Lally when he was
Lally.
Yeah.
don't care about their opinions, but I care that it's unfair, imbalanced, and hidden. And the Commonwealth, like the defense, is entitled to discovery. So if they can produce the discovery, I'd welcome ARCCA.
I'm going to.
They did.
That's how you know this stuff.
Okay. We're going to have a little dialogue and a guessing game of whether at the time he was making his argument, he in fact knew that the disclosures were made by the defense, or he was under the misunderstanding that it was produced by the federal government.
He corrects that himself shortly afterwards, but
that correction doesn't go nearly far enough.
It might be that he's correcting himself because the defense comes up to him and is like, dude, what the hell?
So here's the thing. I know that these trials are big and dynamic, and trials are dynamic, but it is very rare that I have a document in my possession that I don't know where it came from. Unless we're talking about like financial statements, and I don't know which side gave me the statement because it's the same statement. I want to give him the benefit of the doubt. I don't know that I can. I don't know that I can anymore.
I was going to say still.
He's kind of exhausted that with a lot of the hyperbolic statements and a lot of the whininess. I am very frustrated to hear that because that entire argument loses almost every ounce of weight if you, one, put the dates in the right order. Two, when the judge asks you when that was, if you give her the proper answer and are prepared to give her the right answer, which you should fucking well be. And three, if you knew the documents were given to you by the defense and not the feds. Which is also one of those things where if he knew they were given by the defense, the argument he just offered to the court was full of, full, 100% full of intentional misrepresentations to the court.
Yeah, the problem I have with this is it's like somebody needs a spanking and I don't know who it is. But yeah, if I'm the judge, I'm like, somebody's going to get smoked out of this. So,
and here's my problem with how Judge Bev handles it. Well, we'll go to that in a second. I don't know. Tonight, having watched this for like the third or fourth time, is the first time I'm actually contemplating the possibility of him having knowledge in advance of making that argument that the documents were provided by the defense and not the feds? And the reason, because in my mind, I would never be so reckless. I cannot imagine a world where I would be that reckless. Can you? In front of a...
I could see making a mistake, but I don't know. It's hard to believe that he lined up this as his grand best argument ever and that it was just an oops, right?
But it's hard to believe that he would have made that representation to the court knowing that the response would be, by the way, we gave you those fucking documents. I mean, if you are making that argument, you're jumping on a landmine. You're basically making his entire argument is premised on the understanding that the feds gave it to him and not the defense. The would have been nice to know that, all of the other things.
See, part of that, he swaggers like a guy who thinks he's got the pocket aces. And I don't know that he'd do that if he was weaseling. I think he may have. I don't know. Maybe I'm giving him too much of the benefit of the doubt.
Well, that's why I'm torn. I don't know.
Because I can tell you, there's no way I would swagger like that if I
fucking way.
Yeah.
No way in hell am I walking in front of a judge and making that argument with even and I'm going to say this, with even a suspicion that the document might have come from the other side. Even if I have a thought or an inkling in my mind that this document in front of me, I don't recognize it and have absolute knowledge that it came from a third party, it might have come from the other side. I just don't recall. There's no fucking way I would make the argument that he just made.
And that's the thing is if I knew, I would still be playing it real carefully. Like, I don't think we got this from the other side, but and that, or I would have I don't say that I know where it came from unless I went through every email one by one just to confirm that this was not the way that happened. So
now here's the thing. I've made mistakes in court before. I'm sure Ian has too. And I have absolutely made a mistake in identifying a document or doing something that was not what I believed it to be. And it was a mistake, not an intentional misrepresentation. And I have, in drawing upon that mistake, consistent with my ethical obligation to the court, immediately corrected the mistake the second I discovered the mistake was made.
Yeah. And you have to
do it without prompting, without questions.
Yep. Oh, I mean, you have to. It's an obligation to correct correct misapprehensions.
And lawyers make mistakes all the time. I was doing a case where the opposing counsel wrote their closing argument and they were reading their closing argument off of a piece of paper. And it was clear they wrote their closing argument before the trial because their closing argument made reference to evidence that I got excluded at trial.
Whoops. In front of a jury?
Nope. In front of a bench judge.
Okay. And not quite as bad, but
I objected. The judge says you can reserve and you can make your response in your reply. I objected, and then in my reply, I got up and I said, I believe emphatically that counsel didn't intentionally mean to mislead this court, that there was just a different recollection, but the witness that she ascribed to this statement didn't make that statement in front of this court because the court excluded that statement. And one, that lawyer didn't like me very much for a long time. And I didn't mind because I liked being the bane of her existence. But when I say words matter, they really matter. And
if you did that in front of a jury, That's a mistrial.
Mistrial.
Like, you just told the jury the excluded evidence, you know.
So you know what? I'm going to leave it to the chat. You guys will post either, if you replay crew, post the comments. You know what? Let's do this. We're going to do a poll. It's going to be the easiest way to get the chat's impression on this. Because the thing is, there is still a significant part of me that, based on my understanding of how much my license means to me, and how every lawyer knows their license means a lot to them, that wasn't intentional.
It's just so hard to, like, I mean, it's just so hard to imagine that that somebody would do that on purpose. It's tough, right?
Intentional, accidental, and then I'm going to ask a question of, honestly don't know. All right, chat. That's up in the chat. I don't know. Because I'm just really conflicted on this one. B says, but didn't defense give those emails after the first trial? Yeah. So here's the thing. You have a continuing obligation to supplement discovery, but there's discovery cutoffs. The reason why is the court kind of recognized, the law recognized that there comes a time when you have to stop the obligation on both sides of producing materials, because you have to allow them to actually conduct their trial.
Yeah.
Now, if you want to get something new in that you haven't otherwise gotten in, you better damn well supplement your discovery before you offer it to the court. But there has to be a cutoff. Otherwise, one side of the trial or one side of the equation can just inundate the other side during the middle of the trial, Commonwealth versus Karen Reed, like they did in this trial, inundate them with documents and force them to both respond to documents they're receiving on a daily basis and then also conduct the trial they're conducting. Trial days, we don't sleep. Like, it doesn't happen. And that's,
yeah.
you do, you sleep, but it's few, far between, and every other second is crammed with eating food while prepping for trial and trying the case.
I find the problem I have is, I mean, I never sleep, so it's not really a big change, but the big thing I have trouble with is eating. Because, like, the court will be like, and you've got a lunch break. And it's like, and I've got no appetite because I
pack granola bars for that reason in my bag, so I can quickly stuff something down. I force myself to, just to put calories in my body, because I've also gotten, I've done, I think a 4th or 5th trial day with like 102-degree fever.
Yeah, that's not good.
It was not good because I had killed myself for the first, like, leading up to the trial, and that was early in my career when I didn't have the stamina that I've built up. Kelly, if Chloe bit, you must have quit. I bet defense attorney Brennan would be flipping the table about the egregious Brady violation, listening to special prosecutor Brennan spewing this bullshit. That's it is a very big role reversal that's just really uncomfortable to watch. Lola, Hank never watched the first trial, got a flavor for it. He read the transcripts. I also call bullshit on the not watching. I imagine you watched parts of it. Mama bets this is going to be trial by innuendo. It already is. Leah Baker, Brennan did not watch pre-trials and the first trial, so strange that co-counsel Lolly didn't fill him in.
Yeah, I don't buy that.
I don't. There's parts of this I buy, parts I don't. Lynn Britton, I never thought I would miss Lolly, but here we are. Nope, still don't miss Lolly. Robin R., I'm both going to buy that he misspoke. He should have had his shit together there before grandstanding that long. That's the other part, man. When you know that fact after, and you go back and you rewatch knowing that these were provided by the defense, he makes a lot of statements that make him look like an idiot. Trish 818, Brennan filed no affidavit with the motion. Why? You don't usually file affidavits with motions. It's kind of unique in this case where there's every fucking motion's accompanied by an affidavit. Usually when you sign a motion, your representation as counsel as an officer of the court is sufficient. Angie, he definitely knew in my opinion. I honestly don't discount anyone reaching either conclusion based on what we just watched. Lauren L., I find it gross. There's no need to go through all the emails unless presenting them as from the feds. That's more than just misspeaking. That's the other part. They were selectively chosen. So he had gone through them. How do you not know the dates? Just because anyone want to bet that Morrissey took the liquid paper, took the original, given Brendan for presentation with the script. It reeks. It's either he's really sloppy, I don't know, or he's Chris Caqueen. I label my freaking homework with date received, type, NLT due date. How does a lawyer not label legal documents? What the fuck, y'all? Yep. Brit happens. There was a 30-minute recess that went by before that correction was even made. I know, but here's the thing. If he didn't know, the second that counsel looks over at you and says, we gave you those documents, in your head, you are immediately doing this. You are saying, oh, fuck.
Yeah, you're immediately... Well, and the other thing is, I would probably say something like, counsel is advised they did provide those documents, and I need to check. Like, I am going to, yeah.
What if that McLaughlin misrepresented the source of the emails? Still his fault, but she's done it before. I don't know. Tracy Collins, or perhaps pick up the phone and ask the question instead of relying on your own assumption. What the fuck? I don't know. But it happens. Look at everything else he's done on purpose. I don't know. You guys are killing me. I don't want to believe it, but I'm forced to actually possibly contemplate this. Tamitha, Brennan often misstates things like hashtag. Well, that was a misstatement too. That'll give him. That was a misstatement.
That one I don't think he meant to do. Like hashtag versus hash value. That was just him. And he got dunked on for it. There was nothing to gain from that one.
Beach, please. I don't know how this prosecutor looked at this case and decided to proceed. Then to go this hard, make it make sense. He's a lawyer. He has an obligation for zealous advocacy. But again, you're free to draw your conclusion. He's a prosecutor.
He's got an obligation to justice.
I am with you there too. Julie, if Brennan was a newer attorney, I would say it was an accident. This is a rookie mistake an attorney of his experience wouldn't make. I also don't know that. I've seen very senior attorneys make some pretty big fucking mistakes. It all depends on the case. Caden Banford, Bev's too biased to care about misrepresentations. We're going to get to that in a second. Kelly, it gets worse. He was quoting Yannetti, not Jackson, from the 610 hearing before the voir dire. We watched the hearing. But reading the emails from Jackson from 622 after the voir dire, and the defense sent it to them. Yep, I know. Lola, the good dog. Let's drive down conspiracy road. Hank was either set up by co-counsel McLaughlin or is working as double agent for defense. That would be fun. The double agent for defense it's not possible. He wouldn't be doing that.
I mean, it's a fun notion, but it's not a realistic notion. It's like, what if Hank was secretly a bunny in a person suit? It's fun to think of the idea, but we know he's not.
Yeah. Let's get back to the...
Take a recess.
Right, that comes back.
Also, we're going to talk about the laptop.
All right. So the Commonwealth just provided the court with information that causes me grave concern. The implications of that information may have profound effects on this defense and defense counsel. So for that reason, I'm going to suspend today so that when we meet again to address these issues, all affected will be appropriately prepared. So I'll see you a week from today at 11 o'clock in the morning. You can tell me now if that is impossible for you. And Mr. Brennan, where the federal authorities have been kind enough in the past to allow me to have copies of everything, would you be kind enough to call over there or check with whomever you were dealing with to see if I can in fact get a copy of everything that you just read?
I can, and there's a brief chronology I think Your Honor should be aware of. If I could add that right now, it would take me less than a minute. The chronology is December 4th, we sent another tour request, 2024. January 6th, we filed our notice of intention to exclude ARCCA experts. January 30th, 2025, the United States Attorney's Office sent a response to both our...
Okay, this part pissed me off a lot. So here's what I'm going to say about this. Bev gets on the bench. Sorry, my camera stopped working for some reason. It kicked me out of the studio. You know what should have happened right here?
So the Commonwealth just provided the court.
If I'm Hank Brennan, I'm at the podium the second that she's walking in. And before she starts talking, Your Honor, before we begin, I have to make a correction.
Yeah.
The fact that you may be seated, make your cell phone off, put away.
All right.
Were we sped up? Yeah. So she's clearly furious.
She's going to be on the warpath.
So the Commonwealth just provided the court with information that causes me grave concern. The implications of that information may have profound effects on this defense and defense counsel.
All right, I'm already mad at Bev. Here's why. One, Brennan's an asshole. He very much should have been at the podium to make that correction. He wasn't. Two, I've watched other lawyers comment on this one, and I'm going to bring my opinion, and it might differ from others, but this is my opinion. It was improper for her to leave the bench before allowing the other side to respond. I do not believe that it is proper for you to hear argument from one side, suspend proceedings, review the documents in support of that argument, and then come back to the bench on a warpath.
It would not surprise me if she wanted to give them time to, for instance, get counsel. Because it may be that we see them come back with legal representation on this. That, that he's got his own, professional ethics counsel. And it might be that she's just like, I'm going to make sure you don't. No. And the other thing is she's like physically shaking there.
I'm trying to think back to Judge, not Kranick. Who was the judge in the Take Care of My case?
Oh, I can't remember the names. But I mean, the thing is if she's like so angry that she's physically shaking, that you can hear it in her voice, that the time to really give the other side their chance to talk? Or do you wait until you're going to be able to hear it?
Judge Carroll, that's right. Okay. You're not doing your job. I'm sorry. I get it. I understand that you're angry, but part of it is
yes. But if she can't do her job at that point because she's angry, then her responsibility is to not
stop the proceedings. But then stop the proceedings and don't take the material back in chambers and review it. Leave the material at your bench. Because that's the problem. She suspended proceedings and took the shit back with her in chambers and reviewed it. I have a problem with that because that's one side of certain materials. That's a half image that she's now reviewing separately after listening to one side of the argument in chambers. No response. At the very least, what she should have done is given a verbal caution to defense counsel and said, I have concerns with what I read. Now, given those concerns and the fact that those concerns exist specifically around representations made to this court, I'm going to ask if you want to give her a response now, knowing that you have no obligation to give a response right now. I will give you the opportunity to put something in writing, but if you wish to respond to address one or any of these other concerns, you will have the opportunity to do so. I am not okay with suspending the hearing. And here's the thing. We're all big boys and big girls. You get up, you make representations. What should have happened is at that moment, she came back. One, she shouldn't have taken the materials off the bench and reviewed them. Two, when she came back and took the bench again, she should have, well, one, Brandon should have been up there at the fucking podium making the correction before she started talking, had the balls and cut her off and say, I'm sorry, Judge, I made a misrepresentation about the source of these materials. And instead, Brandon waits till she's halfway done with her monologue and then says, I have a correction on timing. Fuck off, Brendan. You got to be kidding me. That's not a misrepresentation on timing. That is the source of the materials which form the entire crux of your argument. And then Bev gets up there, and you better believe that if the first thing out of my mouth would have been counsel just misrepresented to this court the source of the materials that they are now trying to use to hang the attorneys that are sitting at this table. And then you know what? The judge will say, well, at least you made that and we can have additional hearing on this. But that pissed me off.
I don't know. I'm still torn on this one.
And yeah, I get this. I was surprised the defense didn't stand up and argue.
I think defense was kind of caught off guard. Normally defense is really prepared. I don't think they saw this. I don't think they saw this coming.
Or saw the way it would be argued. But if you're the defense and you were the one that presented the documents, you had to anticipate there'd be something.
So how's this? If they ultimately get cleared, do they bring another motion for recusal?
That she has to hear? I have tried my very best to give everyone in this case the benefit of the doubt. I hate the way Yannetti argues the case. I hate his argument style. It drives me fucking crazy. He's too hyperbolic. Jackson can sometimes be too aggressive on witnesses he doesn't have to be, and he goes too far. Lolly was an idiot. That was rude.
Lolly did better than we thought when we hear the juror interview, because a lot of the stuff a lot of the stuff I thought the jury would just never go for. They were like, "Yep, we're going with Lolly's view."
Yeah, Lolly just didn't know how to ask a question. Brennan whines, and not just that. That last exchange, I am of the opinion where I am now of the opinion I don't give a shit if it was that he didn't know that he was holding materials provided by the defense, or if he knew they were provided by the defense and made a misrepresentation. I don't care. Right now, I hold them just about equal, because Brennan should have gotten up and made the correction of the record and made it in the right fucking way.
I mean, here's the thing is, assuming that all of this results in the judge going, okay, there's no big deal here.
She's not going to.
She would need to turn around and then hammer Brennan for it. So it's like, this is all, yeah.
You know damn well she's not going to. That's the part that really bothers me.
Yeah, and if they end up kicking, if she ends up kicking defense counsel off the file, what ends up happening here.
Yeah, Emily, I'm with you. That showed me Brendan's real colors more than anything else. And honestly, it's seeing it this third time, having watched it before.
Oh, I mean, I changed my view on Brennan on this one because I went from, hey, this guy is, he's doing his best to, this is not.
Chef Nomad, do we know what the 24K was for? I don't care. It was a bill. Was there evidence of it being paid? No.
The apparently what we've heard, what has sort of come out is that 24K was for expenses as opposed to charges. And the reason why that's a big deal is they said we are not paying the ARCCA guys, and they're like, but you got a bill for 24K. It's like, yeah, because the experts don't pay for their own hotels.
The number of times when people send bills and I will look at that bill and say, thank you for the piece of paper. It's lovely. I'm going to add it to the stack over here and never look at it because you don't have the right to bill my client for this. Sometimes yes, sometimes no. Sometimes it's paid by somebody else. It's a bill. We don't know.
And the thing is experts, like, they charge you for things that sometimes are reasonable. Like, hey, the expert needs to stay in a hotel. That gets paid, right? Somebody's got to pay the hotel bill. It's never the expert.
Bev did not have paperwork to review in chambers. You tell me she didn't go back there and take a look at the motion again? Even if that's true, I still don't like the idea of causing a recess after one person gets the chance to drive a stake in the heart of the other side and let them bleed out. Because here's what happens with actual built-up biases by judges.
You're worried she's sitting there stewing and getting angrier.
She is. You know damn well she is. You absolutely know she is. So there's my managing partner, or one of the owners of the firm. I've litigated cases against him prior to being hired by him, and I tend to say that he litigates by filibuster, where he just goes, he just keeps on going, and it's very effective. You have to have the confidence to shut him up and stand up and cut him off. And if you don't, he will keep going. And for so long as he is talking, the judge is getting angrier and angrier and angrier and angrier, so that by the time you get the mic handed over to you, the judge is jumping down your throat. When the right way of handling him is cutting him off immediately and saying, Judge, I understand he has the opportunity to present his case, but there has to be some bounds within which he can do that. So, and just constraining him. But this, because let's face it, the second she walks off the bench, she ain't coming back and saying, Brennan, explain yourself. Let's listen to this correction again, because I really wanted Brendan to be the good guy here. I really did.
So for that reason, I'm going to suspend today so that when we meet again to address these issues, all affected will be appropriately prepared.
All affected will be appropriately prepared. Well, Brennan thought he was appropriately prepared, which is why he gave you that entire argument. That's the other. A person with that temperament, I just don't like on the bench, because it reeks of you just feel it.
So I'll see you a week from today at 11 o'clock in the morning. You can tell me now if that is impossible for you.
I guess we'll see in the hearing how she behaves.
And
see, Brennan still hasn't responded. Still hasn't said shit. Nothing. Still hasn't said anything. She's saying he hasn't said shit. The second counsel would have called that out to me and said, by the way, we gave you those documents, I'd be standing at the podium waiting. Oh my God.
Mr. Brennan, where the federal authorities have been kind enough
see
in
her
the
glasses?
past to allow me to have copies of everything, would you be kind enough to call over there or check with whomever you were dealing with to see if I can in fact get a copy of everything that you just read?
I can, and there's a brief chronology. I think Your Honor should be.
A brief chronology? That's how he phrased it. A brief chronology. Judge, I got to correct the timeline.
Aware of. If I could add that right now, it would take me less than a minute.
He says add that, not correct that, add that.
Chronology is December 4th. We sent another tour request, 2024. January 6th, we filed our notice of intention to exclude ARCCA experts. January 30th, 2025, the United States Attorney's Office sent a response to both ours and the defense requests. Without any prompting, on February 6, 2025, the defense and the prosecution received an email from the U.S. Attorney's Office saying that the contract had ended with the ARCCA experts and that if either party wanted to engage, the original materials are still protected. This was a change in position about whether a party could engage. On February 11th, we filed the motion to exclude. February 13th, the defense provided us the emails that I read, February 13th.
Yeah, he does try to cover his poop like some sort of alley cat.
If I tried to pull that bullshit in front of the judges that I stand in front of, the hearing would have gone for another 30 minutes of the judge reaming me a new one. I would have been sanctioned on the spot, I think, pretty much.
I mean, I think that Brennan knows that he can get away with a lot more in front of this judge than,
which then brings me back to the whole, did he know? The way he lays out that chronology, I'm leaning more towards he knew. And he was trying to obfuscate that these materials were, I don't know. I don't know. I hate it. I hate the behavior.
2025, I think I said the federal government. It was the defense. February 13th, 2025, they sent us the emails and the direct examination outline. We reached out to the federal government again because I was curious about the change in position on February 6th, that the contract has ended, but that parties could contact ARCCA. Obviously, the Commonwealth is in no position to contact ARCCA because that would naturally preclude the defense from retaining them. So we've refrained and we will not reach out to them.
All right. So
also that little chronology was written on a piece of scrap paper and not his prior prepared remarks. So it was something that he came up with while that recess was taking place. 90% guaranteed.
It was a correction there.
It was a correction, but that's not a correction. That's that's really gross. That's really gross. And then he walks off like he's the big boy and doing the big thing. And that's pretty fucking disgusting. That behavior is pretty egregious. That's terrible. Those are the types of lawyers where you run up against them and you only have to do it one time in your career where you have a handshake that falls apart before the next time you have a case with them, everything's in writing. That's really fucking shitty. That's really annoying.
The information that was provided to you, not from the federal government, I'd like a copy of before you leave the courthouse today.
Yes, Your Honor.
All right, 11 o'clock a week from today.
Your Honor, is it possible to move it one day to the 26th instead of the 25th?
That does not. It would have to be at 9 o'clock in the morning.
Your Honor, if I may hand up the discovery that was
Thank you.
provided by the defendant reference by.
Oh, great, thank you.
Is there any way we should use this month for today?
We can do the afternoon of the 25th if the morning doesn't work.
The problem I have, Your Honor, is I've got a hearing on the 24th. I have to fly on the 24th, even to be here.
So you can be on Zoom for this if you want, Mr. Jackson.
That I had a problem with in a big way. Because she's saying like this might have tremendous impacts on defense.
And that's what I mean. You're continuing.
And
you're
not going to like schedule it for when he could be there. What?
Problem is, everyone likes to say judges are biased. Ian, you ever been in front of a judge that you just knew was never going to side with you?
Oh yeah. I do firearm law.
Every judge is biased. Humans are biased.
I've straight up had a judge tell me that that in her view, like nobody should have guns ever. And I'm like, well, that is not actually the law. So can we just do what the law says? Like, but yeah, I mean, yeah, when a judge straight up lays out, like, I am biased against your position, that is always a fun moment.
Well, when this judge, I don't want to be a Kool-Aid drinker and say this judge is completely biased. I don't want to do that. But the thing is, I'm not saying completely biased. I'm saying that there is definitely a way that she views the evidence from one side versus the other. And there's definitely a certain amount of weight she gives to the representation of one counsel versus the other.
There's a lean.
It's a lean. The problem is, it's less of a lean. Everything about this hearing gave me the uncomfortable feeling. All of it. The judge suspending the hearing, not allowing them to respond. The other part is Emily made a really good point earlier about the defense not jumping up. That's a really good point, because there have been times when the defense has previously jumped up immediately and been at podium the second the judge walks in and says, Judge, there's something that has to be addressed right now, and I'm not going to let it stand on the record and in front of Your Honor for another second without me addressing the factual misstatement.
Right. And this time they didn't.
Here's the other part.
I think they were just stunned.
No, here's the other question I have. Did the defense, in drawing Brennan's attention to the fact that they gave the documents, was there a discussion where Brennan said, oh my God, I'm so sorry, I'll make that correction? And that was his version of the correction. But no, I wouldn't have allowed, I wouldn't have allowed him to make the correction. I would have got.
I feel like that's way too deep into theorizing. Like maybe, but is there any like actual thought on that?
There's a whole lot of questions. So let's catch up on those. Amy Z, the way he kept referring to his experience with the feds made it seem so intentional. Well, yeah, your experience with the feds would also tell you to mark the documents you get from the feds, so you should know which one's which. Amber C, backfired on Brennan when Bev cut the hearing instead of treating it like she does all other discovery violations of the case. I don't think so. It didn't backfire on Brennan. It would have backfired on Brennan. It could have backfired on Brennan if Bev had just come in there flaming hot and Jackson would have stood up and said this was what was misrepresented. Trish 818. Hank hurried out of court before Bev. Where'd he go? I don't know. Maybe someone drew his attention. Kristen M6, because of his quips, he did it on purpose. He might have. Bop it. Big grandstand. I'd make sure I had my shit right. Yeah. If you're going to make an argument like that, if you're going to cast aspersions on counsel on the other side, you better have your fucking receipts. Leah Benoit, but he didn't correct it until after she asked for a copy of the emails. Yeah, that's why I think it's intentional. There's a whole lot of the things that I agree with for the kids here from my emotions. Poor Canadian.
Did you see the you see the moment there?
Which one?
I was in court.
Where? Wait, is this the what? A link? Where? Which one? You got to help me.
I think it's in the I think your mods found it in the private chat. So was Emily.
Are you talking on the monitor?
On the screen there, Turtle Boy's screen.
Wait, what? Let me see. Oh shit. Wow, really?
You didn't know that?
I didn't see that part. Hang on. Yeah, look at you.
And there's a moment where Emily's on screen as well.
That's funny. Hang on. So that's that clip? I didn't know that was the clip that was posted in the because I was trying to figure out what they posted there. Hang on. So Turtle Boy's got his computer open. Let's see. I'm going to do this. Let's play.
Okay. Thank you very much. All right, Ms. Giannetti, the next one should be fairly quick and simple. The motion for Pro Hoc Vici. I asked you before when Mr. Alessi joined us.
Everyone look at this.
Rather vague.
Oh, there you are. Oh, that's great. That is funny.
Oh, and that's awesome. That's 100% on purpose.
That is hilarious. Just right there. Oh my God. That's
good cause exists to grant this motion because
newsworthy. Look at that. That's cool. That gave me a chuckle. I needed that after that disparage, that terrible remark. Barbie's 2 bits. What's your opinion? Should Bev have allowed the defense to rebut? I expressed it rather emphatically, loudly, and verbosely. Or was it right to give them time to prepare? You can do both. And that's what I think she should have done. Saying, I'm not telling them, I'm not putting you on the spot to respond right now. There were a lot of hefty allegations. You did not have adequate time to respond to them. Let me tell you what my concerns are, and then I'll give you the chance to respond now. Or if you wish, we can have another hearing where you can respond more fully. That should have been what she would have done. So, Amy's positive pathways. Hello, all. I don't know. He has stated several things wrong, even calling the defense the government a few times. They both have done that, oddly enough. Chris Cat Queen, Ian.
I mean, it's because they're all defense lawyers.
Yeah, that's true. Ian calling Brennan a reverse furry. I didn't catch when you said that, but that's.
I'm not sure either.
Kate
But
Pete,
it amuses me as a notion.
He's not a prosecutor. He chose to take this case, knowing all the BS surrounding it.
When I said that he was a rabbit in a person suit.
Oh, got it. That tells me a lot about the type of case he's willing to put on. Yes and no. Yeah, I can see that. Lauren, not likely, obviously, but genuine legal question since everyone else is pro hoc vice. If Cannone, the local supervisor, is yeeted, does that disqualify the whole team? They can find somebody else to sit and supervise. It's relatively common. Nikki, thank you very much. If Brennan thought those emails communications were genuinely from the feds, they would have been impounded. All the TUI docs are protected. He knew they were from the defense. No, because he relayed the chronology and says they're no longer subject to the order or something like that towards the end. Maybe that was also trying to cover his ass. I don't know. January Garnett, I think Brennan wanted to get the defense in trouble, but I think it was more trouble than he expected. He sounds uncomfortable when giving his timeline. No, he doesn't. I'm going to push back on that. He did not sound uncomfortable. I've seen lawyers sound uncomfortable. That was not uncomfortable.
Yeah,
that was entirely too comfortable for my liking. Him reciting that timeline. Mary Lou Crafts, is this a Young Thug-like situation? I mean, Glanville, not that bad.
I mean, Young Thug is a giant. Yeah.
Apocalypse, who thinks she'll bring fire to Brennan if wrong? She won't. That's the problem. She should. She should absolutely hold them both to the same standard. L. Fliggins, Brennan, as Commonwealth CE, is legally presumed to know. Those are federal materials. He's not. If they're federal materials. Angie, the thing is, he said, I just want to lay out the timeline, not I misrepresented the timeline and who provided the evidence. That really pissed me off. That really bothers me. Legalese, thank you very much. Southern Mom, if it turns out the defense did nothing wrong, how should the court and Brennan correct the errors in that hearing? Could Brennan get in trouble? He should, at the very least, get reprimanded and then his argument disregarded. That's what should happen. I have doubts. CS Tears, hey guys, hope all is well. All is great. But it happens, had ARCCA been commissioned by defense, it would have been a much bigger invoice. Oh, yeah. Yeah.
Oh, yeah, I'm sure that invoice would have been, you add a digit to it.
Oh, yeah, very much. Lola, no motion, asked Hank for a copy when she returned. For me, it's taken the recess right there at the outset. I disagree with that emphatically. Texas Prime, it seemed Brennan was taken back by her reaction, like he did it for shock value and realized how upset she got. I disagree. He would have. I think you would have corrected the issue a lot sooner.
Yeah, no. If you've accidentally set off a bomb that you didn't mean to, you get in on that right away. He was entirely fine with letting that bomb go. And that's where this comment. Lola says Hank came clean when Bev asked him for receipts. She shouldn't have to ask for the receipts. It should have never been there. Morgan, I've said all along Brennan might be a good lawyer, but no ethical lawyer would have agreed to pick out the prosecution of this case with dog shit they have for evidence, and this confirms it, in my opinion. It's a tough case to win. Texas Prime is a person with anxiety disorder. I can say with certainty that was a panic attack she was having, breathlessness, shaking, and feeling of needing to flee a situation, usually brought on by stress. Might have been.
Might have been.
I mean, it's entirely plausible.
I will also say that there are not a whole lot of creatures more angry than a judge that just realized you lied to him.
Mm-hmm.
Having seen witnesses on the stand lying in court and seeing the judge find that out, I will say that is one thing that will piss them off more than anything in the whole wide world. So if she actually thought that she was lied to,
and especially it more from counsel, like as much as they'll be annoyed if they think a witness lied to them, it's 1,000 times more if they think a lawyer lied to them.
This is a question for EDB. If Brennan was on Law Traders, would he win? I don't know what Law Traders is. I have to look at that. Larissa, how much do you think? I don't know. How much do you think this tainted the jury pool against the defense? The jury pools, they're not going to select from someone who's watched coverage of the trial. Yeah. Sitting for a week Also, was this a distraction from their motion to dismiss? No, not a distraction. This is just the number of motions that get filed in criminal cases that we don't usually see is a lot. Quinny Bly, I think Brennan was implying defense only sent after Fed's initial response. I don't care. You correct the fucking record. I don't care. The defense's obligation and their reciprocal discovery obligation had not yet told. Their deadline for providing that reciprocal discovery had not yet lapsed. Not in this trial. 20th Century Fox Plus, Brennan filed the motion to exclude ARCCA before he got the defendant's discovery already the same. I also love how Jackson said he was busy that date. Well, yeah, he's lawyers have multiple trials going on.
Well, and also he's practicing out of jurisdictions, so he's got to fly back and forth.
Yeah.
Right? Like that's 100%.
Tracy Collins, Rob, you nailed it. If he didn't know, he should have. If he did know, how disgraceful. Why in the world does he keep saying he didn't watch the first trial? I.e., what's there to gain? Because all I think is, why the hell not? I don't know. I don't think it gains many brownie points for not watching the first trial. I just think it's something where he tries to play. He tries to use it as a sword and shield. Like, oh, look at me, Judge. I'm ignorant of this because I wasn't a part of the first trial. I shouldn't have to be aware of all these things, even though he's supposed to know.
And the thing is really anything he doesn't know. It's like, you are the Commonwealth.
Yeah. And
if the Commonwealth knows, you knows.
You know who's sitting next to him? Adam Lally. Like right there.
Yeah, although I think Lally has been basically relegated to ornament.
Kelly,
he's the ornamental counsel.
The ornamental counsel. Kelly says if she has a panic attack over this, yet doesn't bat an eyelash over all the Commonwealth egregious investigation, evidence collection, Brady, and numerous other violations, prove she shouldn't preside. This is the conclusion that gets very frustrating. It's difficult to explain to people where it's like you can't use the argument of, but they didn't comply either in your argument. But at some point in time, the court needs to have an accounting or an understanding that there are obligations by both sides, and you can't hold one side to one standard and the other side to a different standard. The metadata and the video footage and all that shit is ludicrous.
I mean, I don't know why this trial is still going on. So
what are the chances that she's doing getting mad at Hank? No way. No way. She came back in and asked him for the documents and for him to give them. No,
she's not mad at Hank.
Defense had just filed 700-page double jeopardy motion to the feds. Just let Hank and Bev figure out their misguided drama. I think you missed my first super chat about Emily and Ian being on the screen. I didn't understand the first super chat. Because I didn't know where to look. Yeah. That federal motion, the habeas corpus. I'm sorry, chat. It's not going anywhere. I'm just going to tell you right now. It's not going anywhere. And a state judge overseeing the trial isn't intimidated by something like that. They're not changing their opinion on something like that.
Yeah, no, the judge is used to that sort of thing, right?
ABC's docket due date for dismissal was today. Well, everything's pushed again. April, didn't Bev file something after this hearing saying they had to be in person next week after telling them that he could appear by Zoom? Thank you for bringing that up because I actually have that. This was the notice to appear. Let me see. Let's do this.
So she says they can appear by Zoom. And then first thing says, but you also have to appear in person.
Let me see. All right. February 25th at 11 a.m. The court will reconvene the hearing that began On February 18th, counsel should be prepared to address issues related to defendant's recent production pursuant to Rule 14, especially as the materials produced relate to prior representations made to the court on the record by defense counsel concerning the ARCCA witnesses. We walked through those representations. In addition, because the Commonwealth referenced a transcript of the hearing on June 10th, Commonwealth is to provide a copy of that transcript to the defense and the court by close of business February 21st, 2025. That was followed by this one. Motion to impound exhibit in support of Commonwealth's motion. Commonwealth moves pursuant to the trial court rule that an audio file associated exhibit page being produced to this court as supplemental support to Commonwealth's motions to impose sanctions be filed under seal and impounded. This audio contains statements of the defendant and defense counsel that were produced to this court pursuant to Commonwealth motion. They move the audio file be impounded, not available to the public as premature disclosure, and dissemination could prejudice the ongoing proceedings. Commonwealth reserves the right to play portions of the audio during the court proceedings if appropriate. So that I read as being a part of a sidebar, because all the sidebars were impounded because they had statements by the defendant. Some of them did, and counsel that were sidebars. I don't know, though. But going back to this one, she's still flaming mad. Counsel should be prepared to address representations made by defense counsel.
Oh, yeah, that is I am pissed language.
Very pissed.
That's not the everything is going to be okay kind of language.
Yeah, very much. Please do all the YouTube things. Please do. June Sidlakis. With all this media coverage, could that go outside of the country, outside of the county to sit a jury some other part of the state and put them in the hotel? It's not going to get transferred. I can tell you that. Texas Prime, it seemed like Judge Bev might have been walking it back a bit when she said AJ could attend via Zoom, or is she that crappy? Any chance he has to testify to this via Zoom?
The Zoom appears to have already gone away.
Yeah. More prepared. Reconvene hearing. Ask for a transcript. Yeah, I don't see that part. Carolyn M., if it was intentional as on Brennan's part, don't you think he knew the defense was going to call him out? Brennan knows he couldn't just get away with it. And that's the other part. I don't know. I am still so torn. Laura Leanne, we complained about Lolly and Brennan, but Morrissey. Yeah, Morrissey's a character from what I can tell. Carolyn M., because Morrissey's also presiding over a lot of these cases that are really sketchy. So that's kind of where I want to leave that. I do want to hit that last topic of the Take Care of Maya case. Did you have any parting thoughts on the Karen Reed matter? Other than
it's going to be a gong show. I will probably see if I can, what is it? I may try to do a recap of it on Tuesday evening. I'm not going to be able to cover it live. Emily was in the chat. I'm sure will be covering it live. So if you want to see it live, that'll be your go-to. Yeah, I hope that Bev takes the approach of let's back this down, but I don't know if that's going to be the way it goes.
Doesn't feel like it. It really doesn't feel like it. I've seen enough. You have too. You've seen enough judges where you get a sense of their tone. Everything is being directed at the defense.
She's mad.
Everything. Yeah. So we're going to end the poll. The poll was on whether it was intentional or not. And with 1,815 of you voting, 57% said that it was intentional, 13% accidental, 30% I honestly don't know. I am still in the camp of I honestly don't know. But I'll tell you what, that benefit of the doubt that I had, she is big mad. that benefit of the doubt is now gone. I cannot give the benefit of the doubt to Mr. Brennan anymore.
Yeah, Emily says, unless you want to see it live without talking. Why would you though? That's
no, because Emily, this is going to be one where
I want to see the commentary. I mean, I'm going to have to watch it twice because I'm going to watch it with Emily, and then I'm also going to watch it on my own because I have to get timestamps. But
well, my question,
yeah,
if Emily's still watching, my question for her is, having watched that live and having watched it at least once or twice more since then, and watching your other friends give commentary on it, has your perspective changed? And how? I think the live reaction is one thing, but having the ability to go back and look at it again and again and again, my perspective on Brennan has changed significantly. The first reaction was, oh, there's no fucking way he knew that was not real. And then it was watching it again and going, wait, if he knew it wasn't real, why didn't he correct it? And then when he corrects it again and watching it again, going, that was his correction. So it's pretty tough. The grace that I have for Brennan is, and this is the other, I'm with you on this one, Emily. I'm more annoyed with Brennan. However, I still want more information about what happened. The timeline is soft.
Yeah.
With one exception, which I cannot get over how egregious that is. The fact that the email he talks about at the end about the communication, the interview, the other questions, specifically references Jackson's questions in the voir dire. So you know for a fact it's after the voir dire. And the fact that that wasn't made clear is a problem. And it wouldn't have been hard for Brennan to flip a page or look or I don't know. So that's where we're leaving that one, because holy shit. God, that case is annoying. It's clearly after the voir dire, but it's before trial testimony. And was that still precluded under whatever the order is? That part's also ambiguous. I don't know. I don't know. But that's the other part about Brennan making that argument. If you're going to present an argument to the court, precision of language. Hello. Brennan has exhausted the benefit of the doubt with me. I no longer trust him. I would like to. I went into this wanting to, but then again, I no longer trust a lot of the attorneys. Like I was making the comment about Yannetti. I don't trust a lot of the stuff Yannetti says, because Yannetti comes in there and makes a statement. The only one I really trust right now is Alessi, mostly because I have a law crush on Alessi.
Alessi is awesome. Straight up.
Like I just
the moment when I was just like, oh, he's doing something impressive, is when he's like
60 seconds.
The 60 seconds is awesome, but the other thing is just that moment where the judge has the wrong exhibit, and he's like, "Oh, I can work with that one too," and I'm like, he's got his case memorized to the point where, like, when she's like, "I'm looking at the wrong thing," he's like, he's able to just shift gears seamlessly on that. And most lawyers would have been like, "Oh, can you get the right one, Judge? We'll just have to wait." And he's like, "No, we're just gonna do this just seamlessly." And I'm like, "Ooh."
Yeah. Oh, don't get me wrong. I like Eliza Little too. She's good. She's clearly younger and doesn't have the ability to pivot and maneuver as much. Alessi is, I mean, he's scary. He's he would be really tough to argue against. really hard to argue against.
So I would be very nervous if I'm sitting there arguing something, unless he comes out the other side and is like, "Yep, I'm taking, I'm on this case." It'd be like, ooh.
Yeah. Especially if there's an expert involved, I'll be like, "Ah, shit, I'm screwed." like he probably knows all the special words, and I'm going to pronounce it wrong, and oh, damn it. Yeah. All right. We gonna swoop, and we're gonna get to take care of my appeal, because we're gonna do that. Okay. So for those of you who do or do not recall, I covered the case of Maya Kowalski versus Johns Hopkins All Children's Hospital. The case that resulted in a $261 million judgment entered in the favor of Maya Kowalski, or $261 million jury award that was then reduced to $213 million by the judge on remitter. And that judgment was entered against Johns Hopkins All Children's Hospital for various counts of intentional torts. And in the process of covering that trial, we talked extensively about certain immunity claims that the hospital claimed to have, and why those exist, and why they should exist, and how we enforce those, and really the hurdle that had to be overcome in order for this to get to a jury. And we talked a lot about how the cause of action for essentially causing someone else to commit self-harm, with self-harm usually being an intervening act, is very hard to get to a jury. The hospital did it. We knew. And the hospital's oral arguments were heard last week, and it was very interesting, the tack the hospital took. So what I'm going to do, actually, let's do this. I actually had this pulled up, so I'm going to pull this one up first. Because listening to the hospital's argument, I was kind of struck by something in the argument, and I went back to the appellate brief. I wanted to review what assignments of error they made and what they gave, and why they said the judgment was wrong. Let's go ahead and gain this up a bit, and we're going to start with the oral argument, and then about halfway through, I'm going to bump over and show you guys the actual appellate brief. The hospital took a position I thought was pretty interesting, and by interesting I mean stupid. Let's see if closed caption will work on this. So, warning. This was recorded via Zoom, and judges aren't as aware of the microphone and their need to communicate into the microphone as litigants. Litigants are reminded by judges all the time to speak into a microphone. Very rarely do we have the chance to look back at the judge and say, "Judge, speak into the microphone." And it becomes a problem in this trial, or in this appeal.
This court remains in session. You may be seated.
As promised, we have returned and we're here for the last case on the docket. Johns Hopkins All Children's Hospital versus Jack Kowalski, Maya Kowalski, and the estate of Beta Kowalski. Each side has 30 minutes for this case. Rebuttal time for the appellant, we will limit to 5 minutes.
So they gave extended time. We have a 3-judge panel: Judge Anthony Black, Judge Edward LaRose, and Judge Andrea Smith. So 3-judge panel. Typically, appellate courts and state court proceedings will be a panel of judges, not the entire panel, and they'll handle the initial appeal. They will usually give you a short amount of time before they start asking questions. We've talked about this before. We've talked about Supreme Court cases, so you guys know the drill. Here we go.
So if you're ready to go, let's proceed.
JHACH goes first.
Morning, Your Honors. May it please the court. Derek Steichleather on behalf of the Appellant Hospital, and under Judge Lowe's direction, I'll have 5 minutes for rebuttal. The $261 million verdict in this case sprang from 3 clear legal errors. And if I could take about 90 seconds to give an overview of what those errors were and why they denied the hospital a fair trial, I'd say first, the plaintiffs were allowed to accuse the hospital of causing the suicide of a patient's mother 3 months after the mother had last set foot in the hospital. Second, the plaintiffs were also
can we pause?
Yep.
That was a bold thing to say. 3 months after she'd last sat in the hospital. Oh, why did she? What a weird thing about how she just stopped coming. Like, I wonder if there's a reason why she just stopped showing up at the hospital.
Yeah. Shall we backtrack a little bit? Yeah, I think we should. Let's hear it again. And I'm being reminded that I did not swoop apparently. So we're gonna have to swoop again because the hospital starts off very bold, really bold. So we're swoop. Okay. Now, the other thing that's interesting about it is the hospital says stemmed from 3 legal errors that I can articulate in 90 seconds. And everyone knows, no, it's not just 3 errors. That's not what they're signing. This is the appellate brief. So the brief itself, this is going to give you an indication as to what the hospital is going to take the most issue with. Generally speaking, this statement of the case and facts will be one section enumerated by a single number and will not be broken out into subsections of different facts that were in dispute. So the fact that when I pulled this brief up immediately and I see that this statement of facts is articulated into essentially a chapter book, like this is a novel, I'm going, oh, so we're now in the whole the jury got the facts wrong argument. So the statement of facts goes on for 45 pages. Caveat. When I write in front of the Court of Appeals, I get 30 total. There are 30 pages, 45 minus, 45 minus 6? 39 pages of facts. Argument.
I can tell you if I tried to do 39 pages of facts, I would get back, we're not filing this.
Yeah. So he says there's 3 errors. Here's one.
If I try to push the margins by 0.1,
oh yeah,
they will refuse filing.
Yeah, absolutely. 1 assignment of error, 2 assignment of error, 3 assignment of error, 4, 5, 6 with different subsections of the different errors that were assigned at trial. So when he gets up and says three errors, he's focusing on what he thinks are his 3 best. So he's saying here judges are my 3 best arguments. We're going to allow him to say his 3 best arguments again.
Dollar verdict in this case sprang from 3 clear legal errors. And if I could take about 90 seconds to give an overview of what those errors were and why they denied the hospital a fair trial, I'd say first, the plaintiffs were allowed to accuse the hospital of causing the suicide of a patient's mother 3 months after the mother had last set foot in the hospital. Second, the plaintiffs were also allowed, without any competent evidence to prove any of the elements of insurance fraud, to repeatedly accuse the hospital of engaging in fraud, lying, and stealing from the family that sought care at the hospital. And third, the trial court profoundly misconstrued the protections of Chapter 39 immunity, limiting it only to reporting immunity and conduct at the dependency court proceedings. These 3 major errors set the stage for wild allegations that this is a hospital that kidnapped and tortured a little girl in order to kill her mother. That did not give the hospital a fair trial. And a retrial is necessary that does not include claims that we caused the suicide of a non-patient, that does not include unsupported claims that we engage in insurance fraud and steal from our families, and only follows a proper application of Chapter 39, such that the hospital is not held liable for conduct that is protected by the order of the legislature, and even for conduct that wasn't even hospital employees or agents, that was state actors.
Could you know about your understanding or your position as far as the immunity? Obviously, you feel it's too narrowly, the statute's too narrowly construed. How would you view the immunity that the hospital arguably is entitled to?
The immunity.
All right. So people are asking for some information. So let me give you a brief synopsis of the case. Maya Kowalski was a young child that was diagnosed with complex regional pain syndrome, CRPS. CRPS manifests in essentially extreme pain that's unlike anything else you experience, that can't really be pointed to any specific malady that the individual is experiencing, right? You can't point to an injury that happens. It's just extreme pain. The challenge with this is it's very difficult to treat because, again, complex regional pain syndrome, it doesn't really have anything that we can call a specific cause. So a lot of the treatment is cognitive behavioral therapy. It is, and then involving pain medications. Well, Maya Kowalski had received several different therapeutic treatments for this diagnosis, and then the therapies and the upgoing towards pain treatment, pain management. And ketamine was utilized by the Kowalski family. Beata Kowalski was Maya's mother. Maya's mother was a registered nurse. And they actually ended up doing ketamine infusions and ketamine as a form of treatment for the pain. The ketamine infusions were significant in quantity, and I mean very significant in quantity. She was receiving amounts that were more than any doctor would be prescribing in a setting of a hospital or in any other context, but this was a different setting. There's extensive testimony by different experts in this regard, but Maya Kowalski presented at Johns Hopkins All Children's Hospital with extreme stomach pains. At the point that she was presenting to the hospital basically brought her in, took her in, and they treated her. Well, mom wanted Maya to receive ketamine infusions. And when the hospital heard about the ketamine infusions and what was taking place, mom, who was a Polish immigrant, who was rather abrasive, registered nurse, had been in charge of this medical treatment, they basically accused mom of Munchausen's by proxy, that this was not a condition the child actually manifested. This was a condition that mom had basically projected onto the child. The hospital then told the Kowalskis they were not free to leave the hospital without a court order telling them they could not leave the hospital. And then the very next day, the court order was obtained that basically put the hospital in the place of a shelter for Maya Kowalski. Then CPS, Child Protective Services, through Sally Smith, began an investigation. And certain actions were taking place by the hospital and by Sally Smith, and there was a question as to who was taking what action and what agent was for acting for what person. So that's the Chapter 39 immunity. Is the hospital acting under the protection of an immunity that's granted to CPS in sheltering a child, or is the hospital acting independently and engaging in tortious behavior? Hospital set up a camera in the child's room overnight to try and prove that she could in fact walk when she was reported not to be able to walk because of the pain that she was experiencing. The hospital denied her access to her Catholic faith, basically. They assigned a caseworker that wouldn't allow anyone to communicate with Maya. Maya was heavily restricted on what floor she could be on. Maya slipped into very severe depression. Beata Kowalski was denied access and contact with her daughter to the point where she ends up petitioning to the juvenile court and the family court, dependency court, for access and contact. And the hospital actually notes an appearance in that litigation. So the hospital, who says that we're just sheltering, actually advocates in the dependency court to keep Maya removed from her parents. And they were actually seeking a placement, I believe, in Ohio for continued treatment. Well, at one of these proceedings, Beata Kowalski asks if she can hug her daughter. The judge says no, based on hospital, Sally Smith, and everyone else that's reporting these concerns. Beata Kowalski sadly goes home, having written a letter to JHACH and to others, and ends her own life. Ultimately, Maya Kowalski is discharged from the hospital after her mother's life has ended, and this resulting litigation happened several years later. Litigation was fought very strongly by the hospital in opposition, to the point where the matter went up on appeal during the pendency of litigation, was essentially stayed for a year while the matter was pending appeal, came back down. Judge Carroll got it right, went to trial. Trial was, I think, 12 weeks long, and the trial resulted in a $260 million judgment, or $260 million jury award against the hospital. So the hospital is saying, one, you couldn't get a judgment against us because we were immune. We were protected by Chapter 39. You shouldn't have been able to get through that. Two, you can't sue us for someone else unaliving themselves. And three, it was unfair to allow them to say insurance fraud because the hospital was billing this against to the insurance company as CRPS treatment, and Munchausen's by proxy diagnosis at some point in time, but there weren't proper billing. The billing was a mess. I don't know why the hospital focused on that as being one of their primary arguments, but their real argument is we did the best we could for Maya. Maya was totally great in our care. The jury resoundingly found in opposition to that. So that's a brief synopsis of the case, and we get caught up on the oral argument.
First, expressly covers any act authorized by Chapter 39. I think that's the first important point because the judge said it covers reporting. From there, the authorizations, Chapter 39 is a voluminous chapter, and the legislature has said that this is a robust immunity. Courts have said this is a broad immunity, and there are very strong public policy reasons for that. I think particularly relevant here, there are immunities granted under Section 39.303(3), subsections A and subsections F that apply to the child protection team. Dr. Sally Smith, in this case, is the child protection team medical director for Pinellas County. She was actively involved in what were child protection activities throughout. Subsection A, 39.303(3), gives her the power to diagnose and evaluate a patient. It gives her the power to order laboratory tests, to perform x-rays. And subsection F gives her the authority to collaborate with the treaters to develop a treatment plan.
So you would agree.
Treatment plan. Remember that word. She can order tests and she can coordinate to develop a treatment plan. And the judge that chimes in here, she gives you a real good impression right off the bat where she is on this case.
That even with the immunity, that if there were an intervening tortious act by the hospital, that would not be covered under that immunity.
It would depend on what the act is. The problem here is that much of the immune conduct was just labeled tortious.
Well, let's just take the claims as they are, the intentional infliction of emotional distress. If that did indeed play out, then would that be covered under the immunity as you just described?
I think a true case of intentional infliction of emotion.
All of these caveats. He's like, they just labeled these things tortious. Well,
I mean, that is their argument.
That is. And to say that an intentional touching against someone's will is tortious it's tortious. It's a battery.
I mean, it's kind of the prototypical tort.
Yeah, that's how that works. And then when you're saying that, like in the typical case, well, counsel, here's the thing. This went to the jury. The jury made findings. Like take my question for what it is. Let's say hypothetically, the jury found that the conduct was egregious. Like, so he tries to reframe a lot, and it really does a whole lot of very significant discrediting to the allegations made and the allegations found by the jury by Maya's team.
Distress would not. And I think what your question is getting at is
right there. I think a true case of intentional. So the implication is, oh, well, this is not a true case of intentional infliction of emotional distress. Oh, okay. Explain why.
Is this an absolute immunity?
Correct.
If a child is being protected, anything goes, and that is not the position of the hospital. It is certainly possible that intentional torts can be inflicted upon someone and there would be accountability. I think a good example on the medical malpractice side is that if a patient had appendicitis and Dr. Sally Smith performed an appendectomy because she's skilled as a surgeon, and this is hypothetical, of course, but if she performed an appendectomy and botched it, you could bring a medical malpractice case saying, well, that's not child protection activity. But what the hospital was held to account for here was Dr. Sally Smith is going around and asking questions, and she's rude and she's weird and she's got this raspy cigarette voice and I'm trying to clean up my child and she's asking me all these questions that don't really seem related to what we're there for. That's core investigative child protection activity.
Well, let's go.
Sally Smith did a whole lot more than that. I mean, and there was a real big fucking ambiguity as to whether she was an agent of the hospital or not.
Can we go to the intentional infliction of emotional distress claim by the estate?
Yes.
Okay. There's the case of Nelson, which I'm sure you're familiar with, because if you're relying on it for the intervening cause of the suicide, that would absolve any liability by the hospital. And so in looking at Nelson, it allowed the claim of suicide to go to a jury, right? Because they were remanded for trial. And so it talked about the difference between.
So she's already saying the appellate court disagreed with you already on this regard. They said that claim can go to the jury. Like, you already lost this argument once. So why don't you refocus? Focus.
One being driven to suicide versus the actions and circumstances, and I'm paraphrasing, but driving one to be mentally ill and then that person on their own volition committing suicide. And I focus on that because that distinction is the issue. I believe the court in that case is why they took it and it became a jury question. Why do we not have that same jury question here, where the facts are that we have the hospital's position was that Mrs. Kowalski we had the Munchausen, I think I'm pronouncing that correctly, by proxy. And so they've already indicated that there's a mental illness there. I believe one of the doctors had mentioned, his name is escaping me now, but I believe one of the doctors had mentioned that she was in some sort of mental state, as maybe had relayed some information to them to that effect early on upon the admittance. And then you have, after that, you have, and I realize while they're not direct, some of this isn't direct to her, but you have statements by Nurse Beatty to the husband saying, why don't you divorce her? You have statements that the daughter's faking it. You have, Mike is going out. You have some allegations of interference with her religion, and it was noted that she was extremely religious. And you have them challenging her medical profession as a nurse, and then challenging her as a mom for the way that she treated her daughter. So my point to all of that is that's like everything of the woman. That's like her whole existence. It wasn't just one thing that she was being challenged on, it was all of those things. Why is that not enough evidence on the issue that was in Nelson that they remanded for, not enough to go to the jury?
All right. Let me summarize her question, because her question was really compounded, really complex, but it's really actually more simple than that.
It was basically, isn't there a million things
it was
that
kind of
your
like,
client did?
But what she starts the question with is basically saying, look, the appellate court shot this back down and said, here's the thing. The question is up for the jury. And if the jury reaches the conclusion that A, mom had a pre-existing mental health condition, and the actions by the hospital when interacting with that pre-existing mental health condition and the situation that mom already had, that mom with that mental health condition independently chose to end her own life. At that point in time, there's intervening cause. So you, the jury, if you decide that based on the evidence that this is what you found, that you should not find the hospital liable. Alternatively, the jury has the option of finding B, that the hospital engaged in conduct that was so egregious as to this specific individual that that conduct can be deemed the intentional infliction of emotional distress. And the reason the judge goes through these different things is the judge basically says, isn't it true that the jury presented with these two alternatives and presented with all the factual allegations that were made and the evidence that was presented, didn't they have enough information in their hands to reach the conclusion that the hospital engaged in this action that was intentional infliction of emotional distress? That was the summary of the question. That's what the question actually goes to, and says, you know, you've basically just, you've said that everything that's important to this person, you've taken away from them. Everything. Their decision-making, their daughter, their ability to interact, their religion, their faith, and whether that information or that testimony is in dispute or not, that's not really up for us, right? If the testimony was disputed and the jury found a certain way, we can't invade the providence of the jury and unring that bell. So the judge is like, wasn't there enough to go to the jury? And the lawyer swings really hard, but I think he misses where the judge is coming from.
I think the most important distinction is that Nelson versus Seaboard is a FELA case, the Federal Employers Liability Act, and that has a almost non-existent causation requirement. FELA cases, the instructions to go to the juries are, if you find even in the slightest that this caused, you can find liability. It is significant that this is a 1980 FELA case, and we don't have a case in the following 45 years where a Florida jury has been asked to find someone liable for causing the suicide of someone who there's no clear duty owed to. And I think that the other part of your question, I'd like.
Pausing here because there was an amicus brief. Amicus is a friend of the court brief. There was an amicus brief filed in this case. It was permitted, filed on behalf of the Florida Hospital Association in support of the appellant, JHACH. And the amicus brief basically argues the sky is falling, and the sky will fall if you allow this to stand. And the amicus brief goes on and says that if you allow the immunity to be invaded to this level, right? If you allow these judgments to be entered against the hospital, then you're going to see endless litigation. Didn't he just say that the case itself was from 1980 and we haven't seen a case with suicide for 40 years?
I mean, the thing is it seems like even if you allow this, and even if you say that this is a major precedent, at the end of the day, what we end up with is that this is not something that's going to come up all that often, because like most people don't have the level of evidence that Maya had, right? Yeah. Like it's just, you know, who else has that level of evidence?
Yeah. And Judge Smith is probably, you don't like to try and predict based on questions how the appellate court is going to go. However, the questions give you a pretty good indication as to the areas they're focused on. And Judge Smith is pretty much giving you the indication that says, one, you're telling me this didn't have enough to go to the jury, but I find pieces A, B, and C, which means it goes to the jury.
Yeah.
And two, once the jury makes that call, who are we to disturb it?
Like to address is, you know, how do we not feel for a mother who's accused of abusing her own child? And that ingredient.
Gee, that's
isn't that a really good question?
Yeah, maybe you should have thought of that one. Like
he starts his argument. He starts his argument.
Some way to avoid that.
I know. He starts his argument with 3 months later, she committed suicide. And And then he's like, how do we not feel for a mother who has these things taken away from? You're like, wait a second, sir. I mean, I get it. You argue what you have. This is by far.
But maybe you should try to have better.
You should have better. This is by far his weakest argument. His strongest argument is the immunity argument.
Yeah.
And we'll get to that in a minute. But the argument about the facts and the tortious conduct is really, I mean, that is trying to get the judge. I mean, that's why there's 36 pages of facts recited in their brief, because they have everything in factual dispute. And once you do that, you're kind of giving away the show. You're saying, here, all of these are facts that we think the jury got wrong. Well, I'm sorry, you don't get to do that on appeal. That's not how that works.
Yeah, you're kind of typically stuck with your factual record.
Present in every single child protective action that the state and pediatricians and social workers ever take to separate a child from a parent. It is always traumatic. It is always awful. It is always terrible.
Well, on that point, following up on Judge Smith, if the hospital is operating under a shelter, to what extent and what is the nature of any duties or obligations they might owe to the parents?
This was a very good question. This is a really good question. And this is one that came up in the trial, and I think that it was kind of overlooked. This judge is focusing on a really good question, which is, if you, a hospital, are acting under jurisdiction and under the order of a court, right? You are now a sheltering entity. How does that interact with your independent duty to involve the parents? And how does that interact with the parents' rights? At that point in time, is one of these laws superseding the other? Does one of these laws take precedent and take the forefront? And he doesn't really answer it. I wish that the court could come down and answer, but this really isn't on point here. But you can tell it's bothering this judge.
Profoundly different obligations. I think one of the core principles of child protection law in Chapter 39, and we see this in the case law, the duty is to the child. This law exists for the benefit of the child and not for the parent, because the parent is always outraged, is always upset, whether the allegations are true, whether the allegations are false. They are going to be devastated, furious, and they are going to sue. And because of that, we have a history of healthcare providers who are very chastened, very nervous to get involved, because the entire history of child protection legislation since 1963 in Florida has been, you need to get involved, and when you do, you will be protected from litigation.
But don't you have to balance that with a parent who's talking about a minor, a 10-year-old minor? Don't you have?
Before Judge Smith lays in him on this one, I fucking call bullshit on this. I'm going to repeat his prior statement. Hang on.
In history of child protection, very nervous to get involved. Healthcare providers who are very chastened, very nervous to get involved because.
False. 1,000% false. Where he's saying
they're down to clown.
Healthcare providers who are very chastened, very hesitant to get involved.
And that's like, nope, they are down to clown 100%.
Unequivocally false. Anyone who's ever been in litigation involving hospitals, involving families, involving medical care and treatment knows damn well the hospital they give no fucks about what they dictate and decide and what they cram down your throat as far as their rules and policies, to the point where, I mean, one of my law partners was telling me about a case where his clients, the parents, took the children out of the hospital when the children were in like the ER, like before they were being treated, like before they actually got admitted, took the children out of the hospital, and the doctors chased him out and said that if they didn't have the children back in the ER, that they would have the parents arrested. Under what fucking authority? No, hospitals love to play this game. And hospitals play this game because they are a giant. They are a Goliath. They are a fucking entity to be just absolutely not fucked with. And they love throwing their weight around. So no, I reject your premise, sir, 100% about their hesitance to get involved. You know what? If I had a shitload of money coming into me in medical treatment and care, and that was what I was delivering, if I had a shitload of money coming in and the statute had some way for me to argue that I could be absolutely immune for all of my conduct, you're damn right I would argue for that absolute immunity. Yeah, give me that immunity so I can do whatever the fuck I want.
Oh, yeah. I mean, a while back when there were pardons going around, people were like, would you accept a pardon? And I'm like,
yeah.
Yeah, if they gave me a blanket pardon, I'd be like, can you date it next week? Because I would have some things to do in between now and then.
Yeah. You're damn right the hospital is going to come and say the sky is falling. And my God, we're going to be sued and we're hesitant. And why would we possibly treat this person and this child? No way could we ever treat this person. When in reality, when you put a child or a person into that hospital and you admit them, you know how hard it is to get a person discharged from a fucking hospital?
When the hospital doesn't want to?
Oh my God. That's what I mean. This is one of those things where the hospital is asking for an interpretation of this immunity that it is this case. I walked into this case skeptical that the relief could be sought and granted because of the immunity and the broad protection of immunities given in these particular cases. But then when you see the conduct engaged in by the hospital on almost an individual level, like, and it's systemic. It is every system in this hospital was aimed at or was not appropriately.
That's the thing. There's so many of these cases that seem to come up where like the starting point is this case is dead in the water. And then when you find out that it's not, it's like, oh, wow, that's a whole thing. Cause, like, you know, Karen Reed with the Karen Reed was framed. It's like my initial thought was, okay, we're going to watch defense counsel fall on their ass. You know, cause there's no way they deliver on that. And then, Johnny Depp, my initial take on that was there is no path for Depp to prevail. And that turns out to be not correct.
Yeah. So, and this is a point. Do you not remember the hospital administrator who said point blank, when a parent signs treatment forms, they lose all rights? Yeah, I remember that. I remember when the doctor said it was a question. It was in one of the Zoom hearings. It was well, when they sign that treatment form, I mean, we get to make decisions. Wait, what? You said that out loud? That was, you think that? You actually believe that? Oh shit!
Oh yeah, 100% they do.
You see him say that, and you're going, "Oh wait, you're joking, right?" And then they keep going, and you're like, "You're not kidding. You're serious."
No, they think parents are sort of an inconvenient afterthought.
And this gets back to one of these fundamental premises that we talked about the fundamental rule, and then where do you find exceptions to that fundamental rule? So we're circling back to the very beginning of the show. Fundamental rule: parents have the rights to make decisions about their children. 2, when do you make the exception? When do you terminate that right? When do you sever that right or temporarily suspend that right? On what level of proof? And when you have allegations of misconduct or abuse when it comes to a child, yes, that level at which you suspend or intervene on that right might be a lot lower than everywhere else, because the person that you're suspending that right for is, by definition, innocent in every regard. So you are playing this balancing act. And where do you draw the line? Problem is, hospitals, and in some cases CPS, draws the line very unreasonably, which is horrible, because you also have cases where you want CPS to intervene. There are never good outcomes in these cases, by the way. I wish that there was a magical ball for us to be able to predict the future and outcome of every single possible case of abuse and see it for what it was at the outset without any of these hurdles of due process and all the other things, but we can't. So you have to draw some lines, and it's not easy to do. So I'm not pretending it's easy. I'm just saying that it's been
it's easy to get wrong.
It is. And it's been a long road of the line being drawn a certain way where a case like this comes back and we take a look at it, we're like, do we need to reconsider where that line is? I'm like, yep. Hi, can we do that? Reconsider where the line is? Like just a little bit, please.
Because the entire history of child protection legislation since 1963 in Florida has been, you need to get involved, and when you do, you will be protected from litigation.
But don't you have to balance that with a parent's, we're talking about a minor, a 10-year-old minor. Don't you have to balance that with the parents' rights that they have with the hospital? I mean, they're the
And he's like, parents, they have no rights.
A minor child who's a patient in the hospital, and can't those coexist?
They can coexist, but the legislature has made a clear policy choice because
he means no.
Yes.
He means no. That was Judge, that's a cute question, but no, they can't.
All of these cases, there is this fear, what if I'm wrong? Or what if I'm right, but there just isn't the proof? How much blowback is there going to be? And the history of these cases across the country is there is very often fierce and intense blowback. People are angry about this. And if this is allowed to go to a jury will be angry about this. And
well, then maybe
there's something about what you're doing.
And that's the interesting part about this is maybe if you're saying that the legislature, which is a representative body of the body politic, the individuals, which are citizens, which honestly, you would hope that a jury of your peers would be made up of these very citizens. Maybe the legislature, when they write their policy, if a jury who's supposed to match the legislature would be seriously offended by the conduct you're engaging in, then maybe you have a misinterpretation of the policy. Maybe you just read the room wrong. Because a jury, if they're saying that what you did was fucked up, but
no, always correct.
The testimony at trial amounted to, if you're going to accuse someone of child abuse, you had better be right.
And this is the same thing as oh, baby. All right. What's his name just became Elaine Bredehoff. Elaine Bredehoff made this exact same claim when it came to women's rights and women being abused. If you're going to make an allegation that you're a victim of abuse, you better have all the receipts. You better have photos. You better have video. You better have everything in a row, or else you're not going to be believed. If you're going to make an allegation that a child is being abused, you better be 100% right, or else you're going to get sued. No, asshole. No. Sorry. Lawyer, you had to make the argument you had to make. I'm sorry. That's not, I'm yelling at the hospital. That's a terrible position. No, that is not what we're saying. What we're saying is that you just can't go as far as what JHACH did. It's not that difficult. You just don't go that far. That's where we're going to draw the line all the way out there. And you can deal with that part.
And the entire history of child welfare law is that is fundamentally wrong. It is the exact opposite. It is that if you have merely a reasonable suspicion, you have to report, you have to get involved. And doctors now face risk of losing their licenses. They face criminal liability.
Let me ask you this. Was there anything in the, I think there were 5 dependency orders, was there anything in that limited the parents' rights to be informed of Maya's treatment or participate in those decisions?
Yeah.
All right. Judge Smith is my favorite person now.
Sorry about that.
Her. Judge Smith is awesome. She's like, so the orders that gave you the authority to do what you were doing, was there anything in there that told you what you should be doing?
The parents were included that they would have decision-making authority. It is necessarily a massive limitation of their rights as parents when the child has been removed from the state and is being sheltered in another entity. And when the reason for this is the good faith belief, and I want to emphasize, good faith is an important limitation. You are not protected for bad faith actions. You're mad at your ex, you're mad at your neighbor, and you accuse them of child abuse to mess with him. That is not protected at all. This is good faith child protection activities. And there is an inevitable conflict. These are always awful, terrible, raw, sensitive.
It didn't remove the parents' rights to be informed and to be involved in the decisions of treatment.
Certainly not as an absolute matter, but there is, for instance, when they want to do.
The thing is, that's you didn't answer my question, counsel.
Video monitoring. They want to have the child in a room for 2 days to monitor without her knowledge, just to see, because they're repeated from the immediate outset, vast discrepancies between what they're reporting she can and cannot do and what they're observing with their own eyes.
And that was something that I believe the testimony was approved through risk.
So, in case you missed that, that was not the hospital engaging in shelter activity. No. That was the hospital engaging in independent investigation authorized through risk, not ordered by Sally Smith, authorized by the hospital to put Maya in a room to be monitored to try and prove that she could in fact walk when the reports were that she could not.
Yeah, and how did that one go?
Worked out great for you. She soiled herself, I think, 3 or 4 times.
Yeah, great success.
Management.
Yes, the assistant risk manager approved of that.
And
the difference, what does a hospital use as a guide to interacting with the parents to get consent or at least inform them? And in the case of the monitoring, just doing it on their own, it'd be the advice of the people who were involved in minimizing risk.
Oh,
that's another good question. God, these judges are good. The judge is basically saying, so the hospital is acting, and here's the thing, the hospital is interacting with this order from the dependency court, and the dependency court says, hospital, you can do this in shelter. And as a part of that, you have to abide by these certain requirements. But there's a certain part of activity you can engage in as far as sheltering where you're allowed to restrict parents' access. However, where you, hospital, are acting independently with an examination authorized by your own risk team, are you now under a different subset of rules where now you have to go to the parent because you're not operating under the shelter order, you're operating separately. Now do you have to go to the parent who has rights to authorize treatment and seek that authorization before you engage in that treatment? So this judge just got him with if you're not right here, if you're not right here, you're not right here. Like you got to pick one. You're wrong in one of these things.
A lot of these Chapter 39 orders give this discretion to the hospital. They say the hospital has these rights, these rules are in place, the parents have these rights, but all these things like visitation, care, this is going to be done as seen appropriate by the hospital and consistent with the best interest of the child and the best interest of the care. When the theory of the case, the theory of the detention is the mother may kill this child. The mother not only, and this is not a case of a parent who drinks a case of beer and starts wailing on the kids where simply physical separation solves it. This is a psychiatric dynamic that's going on between the two, and that's the leading theory. And
so you guys are experts in psychiatric dynamics now, huh?
Yeah.
How'd that work out?
So would it be psychiatrically, would it be traumatizing, for example, if this child, steadfastly believes in their faith and you didn't allow them to actively engage in that faith? Would that be damaging psychologically? Maybe a little bit. I mean, this is it.
Of the hospital. And if it's presented as a medical malpractice case where, well, did you have advanced psychiatric experts? Are you absolutely certain the mother had this problem? That cannot be the standard. The hospital has to have.
I'm trying to get my arms around this. How is it in the best interest of the child to videotape her to prove their theory when the risk was that if she was incapable of getting out of bed, they would rather her fall to prove that the mom was right? Or
no, Judge, they just wanted her to shit herself. And I hate that I have to say it that way, but that's what happened. Oh, and there was a reported incident of fall.
Yeah,
sorry,
I am mad. I am mad.
Yeah, that's this is the frustrating thing is there is a place and an argument where the hospital makes this argument and is 100% right, but it ain't these fucking facts. It's not these facts. So I understand the point the hospital is trying to make. Maybe not on this one. This one's a little tougher. So it just, how are you actively sheltering the child when you're putting them in a condition or in a situation where if you happen to be wrong, this child cracks their skull open on the floor? And you, the hospital, who are sheltering to protect this child, have just caused grievous injury to the child.
Yeah.
Or psychological injury. How do you think it is to that child's psychological well-being if you have locked them in a room and don't come to their assistance to the point where in the middle of the night, when they're not being assisted and you're testing them to see if they can get out of bed, they instead soil themselves in the bed as a teenager? How do you think that does for their psychological well-being go forward? Do you think that might be a little traumatic when it happens more than once?
Oh, I know their answer. It's honey badger don't care.
That's what I'm saying. It's I went into this case to take care of my case. You guys can watch the coverage. There's a playlist. And I had a fair degree of skepticism, but the more that I heard from the hospital and the more the hospital started advocating this position, I was going, holy shit, this ain't that case. This case is its own set of facts.
This is one of those cases that they probably should have just written a check quietly.
Yeah.
Or to prove that she actually was a victim of Munchausen by proxy.
No, there's no desire to create a fall or anything like that. And that among all the conspiracy theories, that has not been suggested that they wanted the child to fall. The idea was there is necessary for medical and for child abuse investigatory reasons to find out why is there this very strange, immediately apparent discrepancy between what they say the child can do.
Yeah.
I feel like when you have lost at the trial level, you no longer get to use phrases like conspiracy theory.
Yeah. Or like the tortious or the conduct. When you lose at trial court level and a jury found these things to be true.
Yeah, it's like among all the conspiracy theories, it's like you lost, dudes.
You mean what a jury came back with unanimously? Like that thing that was factually proven at trial? So
yeah.
And what she does right in front of their own eyes. There is a vast difference in her behavior from when the mother is in the room, from when the mother leaves the room. They are presented with a bizarre situation. This girl shows up.
Okay. I don't know if any of y'all have experience with girls that are of the age between 10 and 13.
Thank God, no.
They behave a little differently around other adults that they don't know than they do around their mother or their parent.
That seems unlikely.
Especially under high stress environments. And when they have to report pain or sadness or emotion, because teenage girls are fucking complicated.
Rob, I feel like that should be a shirt.
Because teenage girls are really fucking complicated.
I feel like a lot of parents would buy that shirt.
And they have these walls that they put up. And they're there one moment and gone the next, and you don't know what brings them down, but the behavior tends to swing significantly, especially in times of high stress and pain and illness. So, counsel, the premise that this is somehow suspicious, I'm going to go ahead and put a fair deal of, take that with a couple of grains of salt. Because I remember the testimony, and it wasn't, I mean, you were saying that she was reporting pain, or she was crying, or she was exaggerating her pain when the mother was around. Yeah, because her fucking mom's there. Yeah, because it's someone that she's trusted to handle that pain and help that pain for a long time. And there is a world where that can be bad, but when that's what you're going off of, I mean, pick a better statement. Like, pick a better
mother report, she has been put in a ketamine coma that we took her to Mexico to
see. Should have led with that. Should have led with that. Lead with that one this time. Next time. Not the behaving weird.
do, because they're not done in the United States. And we've been taking her to a doctor who advertises on the internet as nopainhannah.com. And he's pumped her with 55 ketamine infusions at levels that are 10 to 100 times the amounts that this this hospital.
But counsel, was there evidence in the record from, say, perhaps an expert that says that this was done under the guidance of someone with a medical license, and, you know, that this could be a possible, arguable, appropriate treatment? Oh, and by the way, the fact that a medical doctor is prescribing this to a mother, wouldn't that make mother's behavior, you know, somewhat more reasonable? I know you don't agree with it. I get it. I completely understand not agreeing with it.
Rob, you're trying to use that logic stuff, and you need to stop it, because that's not how this works.
I don't want to. I want to be in the logical part of my brain. The logical part of my brain is my safe place. It's a safe place to be, Ian.
It's your happy place?
It's a happy place. It's just not here.
I'm sorry, Rob, but I think that logic and sanity have left the building, and you're just going to have to put up with that.
I 1,000% understand the ketamine infusions being a concern. I get it. Oh my God, I absolutely get it. But it's one thing to have the ketamine infusions being a concern when you're at the trial court level and you're presenting that to a jury, and another one when the jury has said no, it's fine, and you're in front of appellate court, and you're trying to re-argue the facts.
The other thing is, like, I am sorry, but a mother who's watching, you know, the child basically get tortured over and over and over constantly.
Oh yeah.
They're gonna look for answers, right? They're gonna, and the other thing that I just kind of feel in my cynical little cold nub of a heart is that the hospital might have been extra pissed if it looked like it was working, because nothing is going to piss them off quite as much as, oh my God, somebody else is pulling this up. So
as a Canadian, how did you like the remark of had to get these treatments outside of the United States? Because the United States is the only, it's the only country that has any medical procedures that are legitimate. And if you go outside of the United States, it is inherently illegitimate. Look, I understand, like people who do the Brazilian butt lift, don't do that. I'm not a medical doctor. Yeah. Just don't do it. I get that shit. But to say that medical treatment for things that we don't have a good handle on, like CRPS or cancers or certain other chronic diseases, people going outside of the States. Shit, if I had a chronic illness like that, I'd go anywhere I fucking needed to get treated.
Yeah, no kidding. I don't know. I mean, I'm going to try to avoid getting into Canada-US relations at this current time. Because
I didn't mean that. I meant just the aspersions by medical professionals as to medical treatment and care.
Yeah, I mean, it's you know, it's a whole thing, right? Because the US tends to make certain assumptions about the uniqueness of the US in certain ways. And it's like, well, okay. I mean, I've had Canadian medical care. I had my appendix out. It was literally that I went to the, I went off to the hospital and same day they were like, or, right away, they're like, yep, we don't think it's your appendix. And then, yep, it's definitely your appendix. So, chop, let's get that out. A friend of mine who discovered she had breast cancer was literally, she went in with like, hey, I've got some concerns. Are they something I have to worry about? And they, suddenly were like, oh, well, off you go. That said, people have some awful experiences both in Canada and the US. I'm not thrilled. I see Julia mentioning it. I'm not thrilled with how Dr. Moo's treatment went, but I'm also not thrilled with how Maya's treatment went. So, the thing is you can't. Yeah.
I think the point I was making, Ian, and I'll just summarize. The point I was making was, if your argument is the treatment is bad or lesser because it occurred here as opposed to here, your argument is stupid.
Well, somebody in the chat does point out there is a whole industry of like
pain medicine management.
Well, like scam.
I get that
stuff, right? Like Latrial, people were going to Mexico for that, and like that's basically just that's garbage. So it's tough, right?
But as Judge Smith's about to drive home, when it plays,
whenever give a child.
That was under the direction of the medical doctor here in the States. The referral was, right?
The referral to Mexico, or
no? I think the referral to the doctor was that under the advice of a medical doctor.
Yes,
that she was being treated by.
You can find doctors in Florida that will sell you pain medications, and they got a $10,000 ketamine 4-day treatment from Dr. Kirkpatrick. Dr. Hannah sold them ketamine at least $1,000 a pop 55 times. The Mexico ketamine coma was $40,000 plus. There are doctors who will sell you high-powered pain medicines and prey upon vulnerable families who are desperate for some solution. And everyone loves an easy solution. Ketamine's a magic drug. This will fix your daughter's problems. And the healthcare providers, when they are presented with this, they call Dr. Hannah. They ask, we're getting these reports, what's going on? They ultimately agreed to titrate her down, but to give her these high levels of ketamine that were the same levels that put her into a coma just the year before, but her tolerance has grown so high.
I know. I'm sorry, SF. I get it. To the point of that, yeah. To the point of that,
I don't think they were demanding an apology. I think they were just engaged in some gentle mockery.
What does that have to? I mean, what does that have to do with the cost of tea in China? I mean, that's the thing. You're saying these numbers like I give a shit, or like they give a shit. Like you're saying these numbers, and you clearly have forgotten where you are. You're in front of the Court of Appeals. A jury has already made these determinations. You have lost that argument already. And now you're trying to say, you learned judges of the Court of Appeals, you are intelligent individuals rather than these jurors who were just individuals that were by the bus stop on the street. You judges need to take your judgment and wisdom and say these amounts are just egregious, and you substitute your judgment for that of the jury.
Are you saying they're not just the bus stop randos? That's not what the that's not what I was led to believe by
yeah. And this was the comment you made about that Marmar brought up earlier. I hate the amount of control hospitals think they have. Yes, Dr. Moo was not allowed to leave the ER once. Was led to a psych ward and he refused to go in. Talk to a social worker first. Said I saved his life by showing up for him. Yeah. Marmar, one, God rest his soul. Two, hospitals flex their muscles all the fucking time. And they pretend like they're the victim here. When you look at how many people hospitals have victimized, it is astounding to me. For those of us that lived through COVID and saw people enter hospitals that were not allowed to see other loved ones or interact with anybody at all, and those people just didn't come out of the hospital. Like, I'm sorry, the medical profession. I mean, and I'm not saying the professionals themselves. I think a lot of medical professionals are phenomenal people. Amazing things what they do. But don't look at me and tell me that you're protecting me from myself all the time. It's fucking horrible. I'm turning the volume up a little because I'm getting reported a little bit louder for the hearing.
That as her mother writes in a blog, writing in the first person as Maya, I'm taking enough drugs that would kill a horse. I mean, that's not hyperbole. She's taking massive amounts of ketamine because she's built a high tolerance, and the care providers are gobsmacked by this. They do the due diligence, they file a report. It is found as a matter of law. They had good faith reasons to file this report. It is immune conduct, but yet the entire and they also won summary judgment on civil conspiracy. They won summary judgment on malicious prosecution, and they won summary judgment on intentional interference with the parent-child relationship. Those were all proper, and none of those are being challenged on appeal. They won those, and what they had to do was defend a medical malpractice case that made all of those same claims. You're interfering with a parent-child relationship. This is malicious prosecution.
Mangoes, you're free to disagree anytime you want. I'm asking people to question certain things. You don't have to go along with everything. You can question certain things. Like I said, you start with the general rule and you start deciding where the exceptions are. And when conduct gets to a certain point, for example, JHACH in this particular instance, and some decisions, not all, I didn't make a blanket rule, some decisions, you have the right to question certain things. People have individual agency. So you're free to disagree with me. That's fine. You have the absolute right to. I hope you stick around because people listening to disagreeing thoughts is very good. Ian and I disagree about a whole lot. We fight about it all the time, publicly. Because that's healthy.
And I mean, when I had my appendix thing, they were like, so you got two options. You can do antibiotics or you can do surgery. And the thing is they very clearly had an opinion as to which option I should do, right? Very clearly had an opinion, which was do the surgery. But they were there like, hey, you've got an option because you are a person with agency. You get to make decisions. And so when I was like, you say do the surgery, let's do the surgery. And, they were like, oh, cool. But it is something where it's like, okay, I've got an option. They think this second option is a stupid option, but they're still going to give it to me.
Yeah. For example, the option when I get admitted to a hospital, one of those options is I don't want to be treated here. I would like to walk out. Well, sir, if you walk out, you could just die.
And you're like,
okay,
yeah, that's a risk I'm willing to take.
I would like to walk out. I'd like to not be here. Well, you have to sign this piece of paper. You mean to tell me that I have to sign something in order to physically stand up on my 2 feet that I have right here and walk out of your building?
I mean, that one I get,
policy.
Right? I get that one. I got no problem with them saying.
The signing a doc, but here's the thing. If you're signing 15 million different waivers, no. You don't got to do all that.
Oh, not a but just something that says, hey, you are signing out and we told you that's a stupid thing. Right? I got no problem with that, as a sign the thing that says that you acknowledge this, that we think this is dumb, right? Fair enough.
Yeah, that part. Yeah. You are leaving of your own volition against my advice.
Yeah.
Fine. I just told you that verbally. I will very gladly write in commitment that that's what I told you verbally.
Yeah. I don't think you should go. And you're like, well, about that.
You just don't like this mother because she challenged your opinions and you're out to destroy her. And
what's your end game?
I think the end game is that
you want a new trial. If we agree with you, a new trial or strike through various image items.
We certainly need to strike through the suicide claim. That's not appropriate. There's nothing remotely close to the level of extreme and outrageous conduct beyond all possible bounds of deep.
Here's the thing. That was a jury determination. They decided that. They made that decision.
Decency, conduct utterly intolerable in a civilized community. This is child protection activity by licensed pediatricians, healthcare workers, who admittedly have an honest disagreement with the family over what's the proper medical care. The actions of Sally Smith are entirely immune. Those are Child Protection Team medical director expressly authorized.
Oh, no. She did a search before she had any authority. Anyone remember that lovely inquiry where she logged into the computers under her JHACH credentials and did a search? Or no, it was someone operating under Sally Smith's direction that did it. Yeah, no. I don't, and the jury heard that too, and the jury said she was an agent. So, no. That fact, you don't get to relitigate the facts, counsel. You're missing the point of
I want to,
appeals.
because the facts were so bad for my client.
And I get it. Shapiro and Hunter made certain decisions as to how they were going to present their case.
Actions. The hospital cannot be tied to her and have to defend Sally Smith's conduct as the face of the hospital. The retrial, to answer your question more directly, cannot include claims of insurance fraud. This was put in purely for the poisonous effect it had on the jurors and the effect it had on their view of the hospital. This is a hospital that lies, cheats, and steals from its patients. It's rotten to the core. And when it got to closing argument,
quote him, folks.
Counsel, you said it, not me. You said it, not me. I wasn't the one that said it. That just came out of your mouth. Did you hear him? What he just said?
I did. I'm like, oh, that's notable quotables right there. Clip it.
attorney. The hospital is rotten to its core. It's just my word.
The plaintiff said, you know what? Just give us $1 because we don't have the evidence of this. They're thrilled they were able to say it for 8 weeks, but we don't have.
Nope. I'm not letting you get away with that one either. Fuck off. No, I'm not letting you get away with that. You don't get to relitigate not just the case, but the motions practices as well. You know why they didn't have it? Because JHACH didn't turn over fucking documents. So where are those lovely documents? Where are they? I'd love to see them. I would love to see the discovery that you were ordered to produce. Where is it?
They're like, what? Nah, we don't
remand it. You know what? Remand it. let him put on additional evidence on this issue, because you're going to get your ass kicked. These are trees that you're barking up that are just
have the evidence,
wrong.
just give us $1. The jury gives them $5 million even after the plaintiff's request, just make it $1. And in the briefing, you see that the plaintiffs still argue that the IIED claim is supported by the evidence because of the evidence of fraud. You know, this jury could have found it because of the fraud. This was you don't bring a $1 claim unless it's going to deliver something. And this delivered immense prejudice against the hospital. So that's the second part of what a new trial can include. I think the third part is that the new trial must follow proper application of Chapter 39, which will sharply limit the type of evidence that can come in at the retrial. So much of what was presented at the first trial was immune Chapter 39 conduct, even conduct by child protection team workers going in and confiscating this food, taking away the sacrament. I mean, things that are very sensitive, taking away her laptop, taking away her cell phone. These were actions done by state actors, or whether they're contracted through Suncoast, but non-hospital actors as part of their child protection duties. And they are.
And were the ones you just laid out here, were those specifically laid out and authorized by the dependency court orders for them to do?
I don't know that the court says iPads, but the actor.
No. The answer is no, counsel. No.
Also,
the answer is no.
I just went ahead and bought a flamethrower.
Good. Can we put it to JHACH's case? Can that be the first thing we burn?
We can print out their materials and I can shoot flame at that.
I said their case. I didn't say them. I said their case. Which is what I meant.
So, yes.
It's the child protection team that's making these decisions.
Sorry, what?
I couldn't justify the XL18, which has the 110-foot range. So instead, I got the X15, which has the 50-foot range, but hopefully 50 feet.
50 feet.
Can I drop a link in the chat for if anybody else wants a flamethrower and wants to give me a cut of their flamethrower purchase?
You can drop a link in the chat. 50 feet. Now I want a flamethrower.
Next stop, gas station. You know how much fun it's going to be stopping at the gas. Here's the thing that will be the best part is stopping at the gas station, setting the flamethrower down and filling the flamethrower.
That's what I mean. And they're just waiting for the questions to come. And I mean, the possibilities are endless. And now I want
and Lorley Annie is saying, do I have a discount code? Not yet. I've got a link that provides no discount, but gives me a cut. Yeah. So.
You're saying simply because they are a child protection actor, whatever they do and they think is right is immune.
I'm saying that.
God, I love this judge. Yeah. This judge is like, I'm done with you.
A, they're certainly not the hospital. B, there's the immunity should be broadly construed as a robust immunity. And I think there's a very strong presumption that when.
Why is it frozen? Why was the screen frozen? There, now it's back.
What does that term mean to you?
I think it means that it reflects that there is a policy.
Specific state requirements in 39.
Yes.
That's defined anywhere.
I mean, and the word robust actually, I think, comes from the trial judge himself when describing the Chapter 39 immunity before failing to apply it. I think it goes to the idea that these situations are always terribly sad. And if angry parents can bring lawsuits that quibble over details. You were allowed to do this, but it didn't expressly say you could take the iPad. So I'm going to say you maliciously took my iPad in order to make me miserable. And I'm going to talk about how sad I was for 97 days. And I'm going to have experts refer to my hospitalization and sheltering as a captivity.
Did he just say how sad I was for 97 days?
Yes, he did.
My flamethrower isn't here yet.
I know.
And I want to set some things on fire.
I know. I told you. It's very. It's like, no, these are things the jury relied on when they made their determination, and you just disagreed with them, and that's fine. But they still relied on them, and they made their determination. You lost.
This language of kidnapping, abduction, and torture.
Was there an option where she could receive care when the trial court was considering the shelter?
It was a fluid situation. There was the initial detention, which was done by the hospital, and that's under 39-395.
And that's their initial. That deals with their initial.
There are even two initial reports. There's an October 7th report and October 9th report. The October 7th report, the reporter says the parents are cooperating. They're doing what we want to do. And DCF's response is, well, then we're okay. Then if they're doing what you suggest, that we'll leave it alone. 2 days later, they call back and they say, we have much graver concerns now because of what we've learned in the last 48 hours, and an investigation is opened. That point creates enormous protection and immunity for all of the good faith child protection activities. Again, if you're operating in bad faith, that's an entirely different.
You keep using that word, good faith. I don't think you know what it means, what you think it means. Like, you keep using the word good faith. The jury found that you were not acting in good faith. So how is it that you intend for the appellate court to overturn the judgment of the jury as to allegations of specific conduct and what that conduct meant, factually speaking? Again, stop arguing the facts. The immunity clause, he's lost in the weeds. Like, he is in the weeds. He cannot see beyond these facts. And the judges aren't letting me get beyond it either. So he's kind of stuck where he is. It sucks. You don't want to be here. But that's what they set up.
Matter, and you're not protected. But good faith child protection activities must be broadly protected, because if someone is on a 91-day sheltering 24 hours a day for months on end, who is able to get, just through testimony, someone said this, I didn't like the look on her face when I was talking to my mother. I mean, they go to trial over facial expressions. I didn't like Kathy Beatty made bad faces when I was talking to my mother. And
are
they're
you
saying she also constantly interrupted.
Wait, he's about to say it. Wait, he's about to say it.
When my mother and I would stop speaking English and began speaking in Polish. Well, that's in the order. You've limited.
Yeah, that part was legitimate. That's not what they argued, though. Wait till you say it. Wait.
They're worried about the psychiatric dynamic and the pressure being put on the child by the mother. And a clear stipulation is, or not stipulation, a clear part of the order is, these are going to be monitored calls, and of course they have to be in English. If you switch to a language that the monitor doesn't know, you're no longer monitored.
Can you clear up something for me related to the false imprisonment? At what point in time between the first report in October 7th and the next one, when did the Kowalskis ask to leave the hospital?
It's not entirely clear.
It's not to me either.
Appellate counsel is writing down the exact fucking day and time it happens. Like, you see him right there in the background. He's like, oh no, I know when it was. I'm going to tell you. And I brought this one up because he basically says that undesired touches, pats, and sitting on the lap, that is the egregious conduct. I'm like,
yeah, that is egregious, actually. Like,
that's not okay. I don't care who you are or what you're doing. No. And when we're talking about this, we're talking about, side note, for those of you who did not watch this trial, Sally Smith and Catherine Beatty, when Maya was going to trials, required her to disrobe, photographed her before she left the hospital to go to her hearing. I mean, disrobed, photographed her before she left the hospital to go to her hearing, and then made her disrobe and photographed her again upon her return from the hearing. Where in the fucking shelter orders was any of that authorized?
Yeah, there's a certain point where you're like, is this just something you're into? And if so, like, maybe you should be into something else, like a prison.
This case was so bad. So bad. Oh, I make it sound so simple. How about the testimony about Maya crying when it was happening? And just all of it. And they did it because they were documenting the lesions. But you know what? They said they were doing it for a medical purpose. Oh my God. Oh, no. They were doing this as a part of her care and treatment to document the lesions. You know where the pictures were located within the hospital's records? Was it in the medical file? Was it? No. It was in the risk management file. So they told the jury, we were documenting this for medical reasons, for her treatment. Where were the photos located? In the hospital's risk management file. So forgive me when you're trying to relitigate the facts, and we're not going, you know. Oh yeah, and it was on the photos were taken on a personal device. I forgot about that part too.
Yes, and I've spent a lot of time on this, and I can't delineate exactly when and where. There is the testimony, we were threatened, we'd be arrested. In the light most favorable, we have to go with the assumption that they did detain the child. I can't identify what day, what time that happened. But there's also, throughout the medical records, repeated references to extensive communication, family meetings, and consent. They agreed to placing the nasogastric tube. They agreed to a colonoscopy.
And then
And the court is like, wait.
Stay at the hospital.
Yes.
At some point in time. I guess my next question to follow up on this is, were they forced to stay? Because there's allegations here that they would only leave if the hospital would remove the Munchausen by proxy or the syndrome from the records.
So let me interrupt. In fact, we do want you to answer the question, but you're in your rebuttal time.
All right.
So all of the time was played on defense. He played defense the whole 30 minutes.
I mean, sometimes that's the best place to be, because if they're asking you questions, you're not dead yet. But I don't think that's where he was. I think he was dead when he walked in, and they were basically like poking him to see if he would breathe.
I don't know. If you're still getting shot but somehow still standing, aren't you still getting shot?
I think this was really just like, let's poke him and see if he can breathe at all. And the answer is no.
No.
I get yelled at.
I'm sorry. Could you please?
What was that? Is that an accurate depiction of what happened? That they were not allowed to leave unless they agreed to the theory of the hospital that she was a victim of the Munchausen by proxy?
Thank you for repeating it. That's absolutely false. That is what they present as their interpretation. The medical record is prepared. The hospital wants to transfer them to Nemours. The family wants to go to Nemours. But the mother's intent, I want a clonidine pump that is inserted into her spine that provides these massive painkillers. And Dr. Santana Rojas at Nemours says, well, we're not going to do that. Dr. Rojas is a CRPS expert, and the Hopkins throughout admittedly said we are not CRPS experts, but we are, professional child anesthesiologists, pain management experts, pediatricians. This is one of the elite hospitals of Florida. There's a lot we can do, but we're not the ideal place for this case, which has a psychiatric dynamic and a CRPS dynamic, and we want to move you there. The parents spike the plan. They do have to consent to the move. The hospital's ready, Nemours is ready, and they say, take out this part about suspected Munchausen. And the hospital says, well, no, that's the medical record. That's the honest view of the hospital. And they argue at trial. This meant we would have had to agree to it. It doesn't mean that. You can write, that's what you think. I disagree.
Okay, but why did it have to be in the transfer paperwork? I mean, I get the hospital's point. You can't rewrite the diagnosis, but also there was a contentious issue here. The child was the patient. The child was the patient. Children are not diagnosed with Munchausen's by proxy. The parent is diagnosed with Munchausen's by proxy. So it's a diagnosis of the parent, not the child. So that is a misstatement there. So it should not have been on the chart for the child. It should have been on chart for Beata. But Beata's not there. H. Scorpio. Between legal fees, judgment, and the lost donations, how much do you think this has cost the hospital? Millions and millions of dollars. How much could they have quietly settled for? Well, I know what their offer was at the settlement conference. I'm not allowed to disclose that, but I know what it was. And I'll put it this way. It would have sent my ass to trial if I got that offer. I think they probably, look, if you are a lawyer and you see a north of $5 million settlement offer, you are telling your client to look at that seriously with the risk of trial. In a case like this, even with the damage, because the damage are there, and you're saying north of $5 million settlement offer. And here's what I'm saying is the hospital paid more than Ian, you're probably right. More than $5 million in cost fees and that by now.
I think their legal fees are probably over that.
I think so too. I think if you received an offer somewhere between 5 and 10, I would look at my client. I would say, you need to seriously consider this. Like, I understand we can get more at trial, but it's a risk because it can play one way or the other. How much did they get at trial? 213.
I bet she would have settled for 50 and a non-disclosure.
I think she would have settled for 10. I mean, having had conversations with the players on the ground, I think there's also two positions. If the settlement offer was made before that first appeal, 10, I think you're probably more accurate, like 20 after the appeal and it came back and it's going to trial. But
and that's just what's thrown to the jury is we were trapped because we would have lost our license. But that's the medical records. There's no right to change the medical records, not to correct errors, but to adopt our theory that we are not child abusers before you consent it. There's no right.
Jury said 261 million. It got reduced by remediator to 213 million. 213, not 230. I said 213.
To do that, there was no barrier to do that. Thank you for the time.
Thank you.
Thank you.
Mr. Tanner.
Mike Tanner, Gunther, Yoakley, and Stewart for the Appellate.
He's like, I'm just here to spike the football.
I'd like to begin by answering your questions and the two last questions that you ask, and then follow up on the questions that you asked, Judge Black, about the scope of the immunity. But I would like to start out with your last question on on when the Kowalskis were told they couldn't leave the hospital. And you heard my colleague say that it's not clear. It's actually very clear. It's at page 3208 of the transcript.
He's just loving this.
God, I love this. Don't get me wrong. Both of these appellate lawyers are very good. They're both very good. They don't get hung up on questions. appellate litigation is remarkably challenging. I mean, it is insanely hard. But both lawyers are good. It is easier to be the lawyer responding, generally speaking. Like the lawyer that's standing right now, it's easier. You already know the points that he thinks are his strongest, and he hasn't been able to talk about the points that the judges haven't focused on. So you can walk up and start hammering away. And
also, you were winning when you walk in the door is always the better place to be.
Oh, yeah.
It's like,
especially with a jury verdict. Oh, yeah.
Yeah,
And Jack Kowalski testified there that they arrived on a Friday afternoon, October 7th, and he said there that on the following Saturday morning, the next morning, he asked to leave and was told he could not, or they'd be arrested. So 3208, and then look at his testimony at page 3265 and 66, where he elaborates on that. And then, and I think this is important also to your question, you don't need to accept Mr. Kowalski's testimony about that because it's actually in the medical record. Look at the record at R109-987. And that is a record by Dr. Voss that was done in the early morning hours of the following Tuesday after she'd had a conversation with Beata Kowalski that evening, in which Beata said, we want to take Maya out of here tomorrow morning. Tuesday morning would have been the 11th, to take her to an appointment with Dr. Hannah, one of her treating physicians. And Dr. Voss goes in and memorializes in that record what the hospital's response to that was going to be the following morning. And it was that leaving with Maya was against medical advice, and therefore they would not be allowed to leave. And if they attempted to, security and risk management would be called. It's right in the medical record. And the documents that counsel referred to that show that purportedly the Kowalskis agreed to stay at the hospital, those are all cited at page 13 of their initial brief. I commend those to you. I want you to read those because
bro, when you cite the opposing counsel's brief and you say their attachments on their brief, please read them because they support my case and not his.
Mm-hmm.
Oh,
that is such a wonderful moment.
Yeah.
Actually,
side note, this is a masterclass in appellate advocacy. He is addressing each judge by name, remembering the questions they had. He's not he doesn't have a piece of paper in front of him, and he's referring to the specific pages of the indices and the briefs and the attachments to point them exactly to the answers that a prior counsel was not able to point to. Prior counsel made a lot of allegations going back to the facts in the dispute, but this lawyer is pointing to the specific mentions in the record of the testimony that the jury relied on. So this isn't just like a slam dunk. This is like, you're roasting.
He's like, Judge, you had a lot of questions. I got lots of answers. So let's party.
Yeah. And Purple Prose, this is false imprisonment. That's you know what? You might actually, if you hadn't watched any of my coverage of the Take Care of Maya case, please do, because there were a lot of times where the hospital was going down this dialogue and we got to this place and said, okay, so get me beyond the fact that you told them they couldn't leave.
And the thing is false imprisonment at the end of the day is actually pretty simple to make out a lot of the time, because false imprisonment is just any time you want people to, like somebody wants to leave and you say you can't. So, as an example,
one more step, you do something to make them feel like they can't. It's more than just saying.
Yeah, but you'll get people who get, issues like that because they're having a fight with their spouse and their spouse is like, I'm leaving. And they go, I'm blocking the door.
Yep.
And yep. And boom. And you're like, wait a minute, but and that's even if 2 minutes later, you're like, okay, you can go. You still had false imprisonment for 2 whole minutes. And yeah.
The false imprisonment was that was one of the first allocations in there about the conduct. It was one that went to the jury because it was, and I remember them trying to refute this to Judge Carroll, and Judge Carroll was like, but there's evidence in the record that they didn't think they could leave. And the hospital's like, but it's not credible. And Judge Carroll's like, but there's evidence in the record that they thought that. So doesn't this go to the jury?
Yeah. You know who decides whether something's credible? The jury does.
Yeah. Yeah. The false imprisonment was anytime that the question got brought up about how the hospital was protecting and all these protected activities and all the above, I said, great. Let's say I buy your argument 100%. Get me past this. When you told them that they couldn't leave and you didn't have the right to do that. Or tell me how you're putting them in a camera or monitoring them with a camera was for their medical care. Or photographing them before a trial and a hearing was medical in nature. Like
actually show is that those are all dated the 12th or the 13th. After they've been told what they were told and memorialized in the record on the 11th. What those show is that the Kowalskis are attempting to accommodate themselves and get along as best they can in the circumstances they find themselves in. And they're agreeing to do some things the hospital is suggesting and disagreeing with other things. But at no point is there anything in the record where they agreed that they would stay there and that that's something they wanted to do. And I just wanted to start off with that. And I will add this as well. I think what you heard this morning was very much like their brief. And what's remarkable about it is the number of factual disputes that they continue to assert and factual issues that they continue to believe that they can litigate here with you in this court. They dispute, for example, that ketamine was efficacious for Maya. They dispute, as you heard just a few minutes ago, that they told the Kowalskis they couldn't leave the hospital. They dispute that they put Maya in the room to video her and that she soiled herself. They dispute that still. They say that.
No, counsel, they didn't even admit that they soiled. I mean, they didn't bring that up and it didn't get brought up, but thank you for bringing that back to the forefront. I appreciate the fact that you brought that out and not let them get away with that.
It was for medical treatment, yet it wasn't in the medical file. Counsel said to you this morning that there was an assistant risk manager approved putting her in there. Well, it wasn't an assistant risk manager. It was the risk management department. And we have documents in the file we gave you that show the very senior people at the hospital who were involved in the risk management department. So I wanted to kind of start off with that to give you a flavor of what we perceive as a very, very factual kind of presentation in the briefing here this morning. And all those issues were submitted to the jury. And the jury found against them on those issues. And yet they want to litigate them again here in this court. So Judge Black.
I mean, this is his strongest point, right?
You're saying that's the strongest point?
I mean, the whole, like, he wants to relitigate the facts because that is straight up what they want to do.
Well, and their brief, when I look at their brief, and I showed you guys the brief, when pages 6 through 45, or no, 6 through 48, 6 through 48 of a brief that totals 115 pages total, when 6 through 48 are facts, that's a problem. Factual recitation in appellate briefs is usually, Ian, I usually use like 3 pages. And then I reference
sometimes not even that much.
Yeah. You make a bunch
my
of
factual
record.
Yeah, sometimes my factual thing is like a page. Like, here's what happened. Here's the citations to the transcript. Let's move on. You know, sometimes you can capture the issue real fast. And the thing is you want the facts to cover what needs to be covered, but you don't want to waste a lot of time on it. So.
Yeah, because they pointed out 6 or 7 assignments of error. That's a shitload of legal argument.
Yeah. And I mean,
what is the?
Sorry.
Usually you're limited pretty sharply by page count, right? And so it's like you have, you got 30 pages, and the more pages you spend on, not your point, the less pages you get to spend on your point.
Yeah. Well, the hospital's point is the jury got it wrong. That's what just keeps on coming up.
The hospital's point is on top of their head. It's
I think what you mean to say is the hospital's a bunch of dickheads. I love that I can translate Ian. It's fantastic.
The scope of the immunity. And I listened very carefully to my colleague.
Oh, he's going to answer the question the other lawyer didn't. The other lawyer was asked the question, which is his strongest fucking argument. Oh my God. This part drove me nuts. The other lawyer was asked repeatedly, what's the scope of the immunity? That's your strongest argument.
Well, he doesn't want to answer that one because his answer pretty much has to be all the way up to intentional activities.
Kind of based on how the jury came back, but he doesn't answer the question. And this lawyer's like, oh no, I'll articulate it perfectly. This is great. I love it.
Here in answer to your question, Judge Smith. Well, what about tortious conduct? Would that be immune? And I think I got a concession that it would be in theory, but then what was that? We have torts here. That is, the jury found torts in this case. And yet we don't have a concession that those torts would be subject to the immunity. We have some other torts, I suppose, that would be. But if you go through their brief, I think the residual point is this. They contend that everything that followed in time from the act of reporting should be immune. They don't say it that way, but if you read their brief closely, look at pages 24 and 25 of their reply brief. I think it becomes clear there. Everything after the act of reporting, they say should be immune. It would be good faith sheltering in their words. So there are two reasons why that's wrong here in this case in particular, but generally. And
I'm going to need more than two because I know you got more than two reasons why that's wrong. Basically, you make the initial report, and if you make that initial report in good faith, you have a blank check. You can go carte blanche. You can do whatever the fuck you want, and it's all protected. And that is what the hospital did. The hospital said, suspicious conduct. We don't like it. And then they used that as the shield to engage in a whole lot of activity that damn well shouldn't have happened. So let's go ahead and make sure that they don't do that in the future. Please, if we could. Oh, no. The judges are not asking questions. Is that bad? No. No.
It can be. It can be here. Because sometimes the judges don't ask questions because basically they have already decided, that there's nothing you can say. But in this case, they're not asking questions because they've already decided that there's nothing he has to say.
Yeah.
All he's doing right now is he's dunking or he's spiking the football. And
very effectively too. Very effectively. He's remembering every judge's specific question, answering them, pointing them to the point in the record. They're all just like, bro, I already decided with you when you started talking. You didn't need to say this, but this is great because it gives my law clerk a place to look in the record when they're writing the opinion that I'm going to write in favor of Maya Kowalski.
The trial judge, I think, drew the line very correctly and very carefully between the immune and the unimmune. It's wrong because the statute that we're talking about, and it's 39-203-1A, immunizes certain types of conduct. It immunizes reporting, and the trial judge gave them that. And counsel here said today that they won a certain number of claims. I want to make sure we are talking about who won those. The hospital won those. The false and the malicious prosecution, the abuse of process, the negligent infliction claims, the interference with parent-child custodial claims, all of those were tossed out by the trial judge on Chapter 39 grounds. So they won those claims, not the plaintiffs. But the trial judge correctly ruled that The things that are immune are the claims and the liability that logically follow from the act by reason of reporting. And so he eliminated all those claims I just described. But then he went on and assessed the remainder of the claims under the remaining language of Section A, which they ignore. And we're asking you and believe that you should apply the full language of the statute. And the remaining language in Section A, and Judge Black, this particularly goes to your question, I think. Section A immunizes reporting, but it then also immunizes conduct that is authorized or required by Chapter 39 and undertaken in good faith. And your honors, there's no such thing as a good faith tort, especially a good faith intentional tort.
Oh, God, what a way to drive it home, man. All this good faith talk, and he's like, Judge, just a reminder, you can't engage in good faith tortious conduct. Like they don't exist
I
together.
slapped him for a great reason. It was, I didn't like his face.
That's, yeah. You cannot batter someone in good faith. You lose good faith protection when you engage in intentional tortious conduct.
I flamethrowered them for the best reasons.
And really good reasons, Judge, to flamethrower them.
Which is, they worked on fire, and I knew a way to fix that.
And nor is anywhere in Chapter 39 tortious activity authorized or required. And so that was the trial judge's analysis, which we suggest was correct. He looked at the nature of the conduct and decided if it's tortious and it's not clearly required or authorized by Chapter 39, then it would be an issue to go to the jury in answer to one of your questions, Judge Smith. So, so that's partly why they want to exceed the statute or ask you to exceed the statute when they ask for what would essentially be blanket immunity. But the other problem is this: they ignore Section 1B. It goes on to say that any person, which would include a healthcare provider that itself abuses children, is not subject or does not get immunity for any of that. And the trial judge ruled that this kind of conduct, based on the allegations, would fall squarely under that. And that, and the authority for that would be the Yamani case and the Floyd case that was cited. So, Your Honor, I hope that's an answer to your question. I think that's the scope of the immunity, and that's what the trial judge did, and we say he did it correctly. Yes, sir. So, Judge Smith,
I just like we know.
Address your question on Nelson. And I think you summarized quite well all the conduct that we laid out in our brief on the application of that case to the IIED claim. Two things I would just say about Nelson. In their brief, they predicted that there would be this avalanche of litigation if suicide causation claims were allowed in the state of Florida. Well, that hasn't occurred. Nelson was 43 years ago, and there's been no avalanche of litigation. And I think the trial judge correctly ruled that under Nelson and under the Tate case, which is cited and is the basis of the Nelson ruling, that his jury instruction was absolutely correct, where he gave it a two-prong instruction of the substantial factor, which comes right out of Tate, and also the uncontrollable impulse, which comes right out of Nelson. So you would be following the first district if you applied that analysis and affirmed the trial judge on that instruction. And I will say this as well. Counsel said it again. They said it in their brief that, well, Nelson is an outlier, and also it's based on FELA principles. I think if you read the case, you'll see it's not based on FELA principles. Tate, which it relies heavily on, is a common law case, relies on majority jurisdiction, American civil trial court principles. And then Judge LaRose, I do want to get to one of your questions. I'm sorry it took me a while to get there, but you ask, what are the duties of the parents under the shelter orders? And I think it's important.
More specifically, what was the hospital's duties?
Yes, sir.
God, I love that. He's hammering away, and the judges haven't interrupted at all, except for this one moment where it's like, you asked about this, and he's like, well, I actually want to know about this little part. Do you have that? It's more like I love where you're going with this. Let me just get you all the way there. If I'm an appellate lawyer and I'm having this in response, I'm a really fucking happy appellate lawyer.
I mean, this is basically you just throw on cruise control and you and you win it.
Yeah. And this lawyer that's arguing, by the way, is Michael Tanner. He is the president of the Florida Bar. So he is who the Florida Bar, all the lawyers in Florida elected to be their president of their bar association.
I feel like that guy might know a couple of things.
A bit. And I think he might know people and might know how to be persuasive and how to argue. And I also think he doesn't just take cases on a whim. So
he might take cases that he believes in a little bit.
I think so. He does a damn good job.
And the trial judge, at the request of the hospital, gave an extensive instruction on that to the jury. And one of them was, Judge Smith, this goes to one of your questions too. The parents were permitted to participate and be consulted on medical decisions regarding Maya. That's right in the order. But the other terms of the orders were that the parents were to have communication with Maya. They were to be allowed to have certain types of visitation with her. The husband and, yes, the father and the brother were allowed communication. The mother was allowed telephone communication at first. Later, that was expanded to allow FaceTime. And they were allowed written communication with her. So, and as we said in our brief, the hospital's refusal or failure to carry those out was part of what we contended was the part of the IIED claims. And those come right out of the shelter order requirements. I do want to address the points he made about Dr. Smith.
Answer your question, Lady Drake. The original appellate counsel was Ray Elegant. That was the original appellate counsel, who's also remarkable. It's just this lawyer's really good. He's really good. He knows what he's doing.
I mean, the thing is everybody looks really good when you're in this seat.
When you have this case, when you have this argument, when you were given that to respond to.
Yeah.
Yeah.
The fact is, they said it in their brief. Dr. Smith did not present well as a witness at trial.
Oh, God, I love this. Oh, I forgot he said this. Dr. Smith did not present well at trial. Guys, I have several videos on Dr. Smith's testimony. You might want to go back and rewatch those because holy shit, was she a nightmare, including one with Spidey, which was actually really fun. She was a disaster in person and in deposition. She was horrible. Guess who called her?
And I'm sure they regret calling her. The fact was that the plaintiffs played one deposition clip from her. It lasted about 30 minutes. The hospital called Dr. Smith to the stand and kept her there for quite a while. And so if there was any sort of prejudice to the optics of the case from Dr. Smith's presentation, the hospital bears the responsibility for that. But I think it's important to remember also that Dr. Smith and her apparent agency was an issue in one claim out of all of these, and that was the medical negligence claim. It was not an issue in any of the other claims. All of the other claims are based on the acts of other individuals and in the hospital, none of whom were shown to have any relationship with the CPT or the dependency court. It was only the medical negligence claim. And the verdict form for the medical negligence claim laid out two questions, or three questions actually. Is Dr. Smith an apparent agent? Yes or no? If the answer to that question is yes, was was she guilty of medical negligence? Yes or no? But then it went on to say,
oh, this part right here is a brilliant part of the argument. Dissecting the verdict form. So he's basically saying, throw Dr. Smith out of this because they're trying to make her this bad person. This part's great.
Say, were there any other employees of the hospital other than Dr. Smith whose conduct rose to the level of medical negligence? And they answered that question, yes, because there was abundant evidence in the record of other medical practitioners who were involved in the treatment of Maya. And so you really don't even need to reach the issue of Dr. Smith, because the medical negligence verdict is, you can affirm that on the conduct of all of the other doctors. And it was the other doctors in the hospital, Dr. Vose, Dr. Tepa, Dr. Dees, who made the decision to terminate Maya's ketamine. And that's the basis of the medical testimony that Dr. Chopra testified that it was the termination of the ketamine, which was an efficacious treatment for her, that permanently aggravated her CRPS. And the hospital has not challenged the admission of that testimony in this appeal.
God, I love Dr. Chopra. All right, I think we can wrap with that. I think he we can all agree he was a slam dunk, right? We're good. We all agree slam dunk.
I feel like this appeal is pretty. I feel like they've got it decided, but
I mean, what's sad about this is that
I assume there hasn't been a verdict yet.
No. They heard this last week.
They're going to do written.
Yeah,
there's no. I mean, sometimes they'll do a verdict from the bench, or
not an appellate law in the U.S. No, but
okay, we do it here.
That's bold. Wow.
Yeah.
Wow.
I mean,
okay.
My Supreme Court win was delivered from the bench.
I forgot that. And I made the terrible mistake, by the way, of just taking a glance at the Take Care of Maya free Reddit page for a second.
Oh God.
Oh my God. The brief has been filed. The appeal. It's full of manipulation, emotional manipulation. Really? I don't think so. I think that, look, here's the thing. JHACH very clearly, very, very clearly has the position of the jury got it wrong. And they hide behind the argument of there weren't facts presented for the jury to reach this conclusion. But the appellate counsel for Maya Kowalski's team was very apt in pointing out each part of the record where all those things were discussed and offered to the court. So I think the strongest argument JHACH had was the Section 39 immunity, and then the Beata Kowalski decision to end her own life being an intervening cause.
I think that's the biggest argument they've got, is the intervening cause argument.
I do, but I don't think he really ran up against what I thought was I didn't expect that strong of an opposition from one of the judges on the panel. She pushed back hard. She said, that's everything for a woman, for that woman. That's everything.
Yep.
And I think that, look, if you get one, it's pretty good. So I thought that was fascinating. The argument, just doubling down on a position is something that you do from time to time because you have to. This entire litigation has, for me, felt like an own goal at every single step. A lot of it. There was a way to resolve this matter that would have had JHACH taking a different tack. Howard Hunter, bad call for the trial attorney. Just bad call. Just terrible. And I think he was guiding a lot of the decisions being made behind the scenes too.
I suspect JHACH sort of.
Go ahead.
I suspect that they basically made the decision that they wouldn't settle under any for any reason.
I think the reason why they would do that, though, is they don't want to open the door to other litigation. That's the concern they have. If this case goes through, then everyone thinks they can sue. The problem is, if this case goes through and a $213 million judgment is allowed to stand, then they have just broadcasted the whole world the scope of liability that can exist in these cases.
I mean, that's the thing is, if like I see somebody saying that there was a offer for 17 million. I don't know if that's correct, but if they just said, "Yeah, we'll do 17 million, but we need no admission of responsibility." 17 million
was not prior to trial.
Mm.
Prior to
and
trial,
if it was just no admission of responsibility and an NDA, like they could have gotten off so much cheaper on this.
Yeah, prior to trial, they wouldn't have been able to pay the medical bills with the offer. At least the bills being leaned against their house. So it was a choice by JHACH. Just a bad one. K-Rab, I just spent $3,000 on a ferret who had stopped eating.
No, I mean a offer from the defense to settle for 17 million. Not JHACH. Yeah.
Oh, from the defense. Oh, from Maya's team.
Yeah.
17 million.
We'll call 17 million good. Like if they said, "Yep, that's good."
Told
but
you, I think they would have accepted 10 pre-trial.
Yeah, that's a big mistake.
By JHACH.
Yeah.
Yeah, bad miscalculation.
Like a big old expensive mistake.
I would say so. K-Rab, our dog had just passed recently. I don't have the heart to tell my son. It's too much. Oh my God, I'm so sorry.
Oh, I am sorry.
Yeah. Ian, can you take over for a second? I just need one quick break.
Do you want me to read super chats, or do you want me to just?
If you wouldn't mind, a couple chats.
All right. I think there was one there that was for me. Ian, do you think Canadian children's hospitals are similar or different than JHACH? I mean, my experience as a kid was not fantastic, but it was, I don't know. I mean, I could tell you sort of my childhood experience, which was I had asthma at an early age, and so my earliest memory is actually in a hospital. It's being in an oxygen tent. So that's not great, but I mean, at the same time, it's nothing nearly like what Maya went through. And I suspect that the oxygen tent was kind of necessary. So yeah, I think Canadian children's hospitals are better than JHACH. I mean, it would be hard to be worse. Certainly when I went, like I do fundraising for the Stollery, and certainly like what I saw there, was actually pretty cool. So like the Stollery has got things like they've got a play space that is no doctors are allowed in there, because it's basically just, it's got to be and one of the things that they're doing with, one of the things they're raising money for at the moment is that they are trying to expand that to include an outdoor play space, because a lot of these kids just never get to go outside. And so this is like, doctor free and also sort of safe for kids who have immune issues kind of thing, but outside space, which I'm just like, that is amazing. That is super cool. They have got things like, if a kid is being taken off for surgery, they've got like this tunnel they can take them through with lights, so that the kid, as they're laying on their back on the gurney, gets to see like cool stuff overhead.
Oh, that's cool.
And so it helps distract them as they're going towards surgery from where they're going. And I'm like, this tells me that I think that the that the Stollery is a way better hospital, because they're just thinking about all these things, right? And they're putting all this effort into it. So yeah.
Yeah, and I don't really view it by country by country by country. I think there's ample evidence in the record, especially towards the end, about JHACH specifically being a problem hospital.
Yeah.
So,
and I just feel like it's sort of like they're sufficiently famous that they feel like they can get away with anything. Because like, how many of us
Which is
have
why,
heard of John
which is
Hopkins,
why
right?
Johns Hopkins didn't allow them to just say Johns Hopkins. They had to go by JHACH, Johns Hopkins All Children's Hospital, because they are an entity that was acquired by the broader Johns Hopkins.
Okay.
But Johns Hopkins didn't really
But they're
take
like
full
mildly
ownership
to seriously sus.
of all the things. Like, yeah, this trial was an experience to cover. I might go back and rewatch some of the old coverage because my God, that I remember just my
you did
brain.
such a good job. And I mean, your coverage was also watched by
trial counsel.
what do you call it? Watched by like counsel on the file, who were like, "Yeah, we got to, if we need insight, we're going to watch this," which that tells you something right there, right?
It was difficult because those daily coverage and the daily recaps that covering trials live, guys, is insanely difficult, time consuming, and challenging to do it every day for trial.
Oh yeah.
So I'm very impressed by those that can do it. Megan Seals, so happy to be joining y'all from Texas. Happy Friday. Happy Friday to you. AVX in PX in Phoenix. I'm 69 years old and finally realized I have PTSD for being tech support for my sisters for the last 20 years. Part of that's probably funny. Part of it's probably a little bit serious. Probably a combination of the two. Kathy Brewer celebrating 9 months smoke free. Congratulations. That's a remarkable achievement.
100%.
Stick with it. Keep with it. Destiny Salazar, Rob, is the blurred jury behind you a metaphor or just coincidence? You mean from the
it's just focus, distance, I suspect.
It's just focus. Yeah, probably just focus. Elise Charlene Fine Art, you show intro mini mischief to bullet journaling. I can try to figure something out like that. Jet J, my youngest and her horse both turned 18 this weekend. I am on the verge of madness. Thank you for FNF. Thank you for being here, Jet J, and congrats to both of them. Lola says woof hi to Leo and Zora. Both Emily D. Baker and Ian made special appearances at Karen Reed's motion hearing this week, courtesy of Turtle Boy. There it is. I told you I had it. The chat starts flying and it gets difficult to catch up with things. Lori Marie, so if I have a broken leg, I can't run. That means I haven't run. Yet my leg is broken. So is it my fault that since I can't run, I haven't run? Oh, this is the disclosures. I can't make the disclosure. Yeah, but it means you violated the rule. But I can't comply with the rule. You can't comply with the rule, but you still violated the rule. Okay? Get it?
I think sometimes that's how it works.
It is how it works. And the remedy in that case was a voir dire, which is, it's not a sanction. It's just a remedy.
Yeah. This is our best way to fix it.
Yep. Lady Drake, thank you for gifted memberships. Mama Wolf, thank you for gifted memberships. Someone bloody random is the removal of Zoom code for bring a toothbrush. No, it's not. No, it's not. I hope
she's not going to throw them in custody.
No, and I hope that she chills the fuck out a little bit. I just don't have the highest aspirations. SF in Texas, you notice how Brennan said he'd wrap this up in 60 seconds? That was a dig at Elise. Oh my God, Alessi, I didn't catch that part. Potentially criminal, she and Brennan are going to look like scumbags when this turns out to be a bombshell full of mouse farts. You know what? I'm going to borrow that phrase, Sean. Bombshell full of mouse farts. I would argue that Yannetti and Jackson should move for recusal after that hearing ends. I think she's not going to recuse herself. I think you have to make the motion.
Still ask for it.
You have to make the motion for it. And I think you do it. You're like, Judge, I have to do this to preserve the record. I have to do this to preserve my client's rights. You do it apologetically, but still you do it. Mama Bear,
I don't even know if it's that apologetic.
with how she behaved. Judge Bev, attitude towards defense has been terrible. This is the first time I felt she walked in angry at the Commonwealth and got angry at them as it went in. She was angry at the defense, not the Commonwealth. Crazy Cat Queen. So did JHACH ever hand over the documents? Nope. W, thank you for gifted memberships. Ian Paler, thank you very much. Shame on JHAP for twisting the knife further. I start a question just to tell Jolene, I saw your question. I start it. I don't know how to answer it because, well, you know what? I can answer in this context. Ian and I had a back and forth on Twitter that was rather humorous, involving a certain individual who produces content on a certain platform getting pregnant. After engaging in a certain activity with a number of males,
it's over 1,000. There is some doubt as to whether this is an actual thing.
I think it's got to be a farce, right? Right.
Yeah, I suspect that we see in like 3 weeks either her saying, you know, I didn't keep it, or her saying, you know, there's been a mystery miscarriage or whatever. Like, it's all just marketing. That's my suspicion.
But Jolene, I started your chat just because you said, I know Law Lover only reads super chats. No, I read more than that. It's what I can read and what I can't read, depending on where I'm looking at the time.
I mean, we are 5.5 hours in, and yeah. You got to get through.
Happy Sunshine. Is anyone covering the updates on the lawyers battling in court? I was on Peter Lawyer, you know, his podcast discussing some of the back and forth. I know there's a hearing set for that on March 6th. I have tried to stay out of that to the extent I can, but I'm also trying to just provide a very straight down the middle neutral approach to it. My assessment is it's sad. Both lawyers have lost the forest through the trees. They see red, and the only person that's losing in this case is Maya. It's really unfortunate. Lady Fang, consent can be withdrawn at a time. I work medrec. Yeah, you can say stop treating me. Snoopykins, hi, been a while. Any news on gifts being sent? Yes, Snoopykins, I need an update to go out to a lot of people. I have a whole pile of gifts, things, pens, gifts, and things that need to go out of this house, and I need to put them into a box and get them out of this house. I will get you an update, I promise you. Angie, how about allowing the parents to at the very least have supervised contact with parents while child is in the hospital? Also allow them to practice their religion. There were parameters around contact. It was very much under the control of someone who demonstrated pretty quickly that they were an autocrat and just were going to prohibit everything. Marmar, Rob, I'll email you again this weekend. Thank you, Marmar. I'll take a look at it. Nancy Flewelling, you answered this question already, Ian. Lauren L., you mean the ketamine treatments that JHACH installed the port for before this happened? Those treatments? God, it's infuriating. Yeah, JHACH did install a port for some treatments prior admission. It's Lady Fang, if the patient refused to sign the waiver, the doctor can complete it on their behalf, and they always can write the patient refused to sign. It's the other part of it. Morgan, I caught COVID while I was in the hospital for pulmonary embolism. I was in isolation for 8 days, and then they wouldn't let me go home after treatment. Had a 3-day long panic attack during those last days. Thanks, hospital. Every person's experience is a little bit different, and I don't want to lump in a whole category of individuals, but what I will say is that I'm tired of hospitals gaslighting a lot of people who have very serious experiences that need more than just a complete disregard for what you've gone through. SF, Megan Fox clipped all those statements. Oh, that'd be interesting. She loves those little clips. Purple Dragonair, Rob needs to see the drone and RoboDog. I absolutely have. I love the RoboDog. I need one of those.
I love the RoboDog, but the RoboDog is 10,000 US. So
not worth it, but it does throw flames.
Especially with the Canadian dollar being at like 70 cents right now. That would be so much money.
It throws flames, right? Yeah, I want that.
It's a dog that throws flame. Like, it is a fire-breathing dog. That said, it is not nearly as cuddly as like Zora.
No. Gwynnie Bly, JHACH living by Monty Python Creed. It's just a flesh wound. Every time. Lauren Lori Leanne, Marmar wondering, yep, that got posted in the chat, the link for Dr. Moo. So you can please go take a look at that. Sandy, thank you for getting memberships. Dawn, ECT, is this the last step in the appeals process? There is one more appellate court above this, but it's not an appeal as a matter of right, which means that you have to actually ask the court to take it rather than taking it as a matter of right. And the court gets to say, I don't want to take it or not. Usually, the Court of Appeals comes down with an opinion. The Supreme Court would have to really want the issue to be resolved in order to take it. And I don't know that you'd get there with this case. This case is rather messy. Crazy Cat Queen, I wonder what happened to the JHACH sanctions issue. It's still up for adjudication. It's still pending. It's not yet resolved. And then Zess Alex, I was diagnosed with CRPS at 10 years old, and a family friend warned us to stay away from hospitals and ERs. I think about it constantly now. I appreciate you guys and all you do. That's the other part about this. CRPS and other chronic pain illnesses, hospitals don't really know how to deal with it. If you go in there saying that you do X to manage your pain, they very much start questioning X and whether it's reasonable or not. And once the CPS investigation is open, closing them, it's not the easiest thing in the world. So, okay.
Yeah.
Go ahead.
I'm aware of somebody who got in some trouble for, what is it? They had a kid with serious pain issues, and their solution was to give the kid THC, which they did on their own volition. And they got charged for doing so. And the charges got killed after the kid got a prescription entirely after the removal. They got taken to a doctor, and the doctor's like, you know what would really help here?
THC.
Some THC. And so it made the case against the parents really difficult, because it was like, oh, the parents got it right without actually, like, okay, it's like, we can't really call this abusive now. So all of that got unwound.
Yeah. Every case is different, and I wish hospitals would treat it that way more than what they are more focused on, which I don't know. I think the practitioners are great. The administrations always suck.
Yeah.
Okay. Ian, you're going to be live on Monday?
I should be live on Monday.
And on Tuesday. I'm in trial on Monday and Tuesday, but when my trial is done on Tuesday, I'm going to watch your recap of whatever the hell I read.
Yeah. I got to talk to Mrs. Runkle and just be like, so, can we do a reschedule? Because I feel like I'm invested and I really need to cover that one. So
yeah, after going through that thoroughly. Yeah. So guys, keep an eye out for Ian. Check him out on Monday. Check him out on Tuesday if you can. Ian, thank you for being here again, man. I haven't talked to you in a while, so it's nice to be able to catch up.
It's been a hot minute because you've been busy. You've been
in the office all day Sunday too, prepping for trial.
I need to. I mean, yeah, I got so much prep I got to do because this Baldoni thing, the new thing, it's like 600 pages or some.
Oh, the amended filing, the amended complaint. Yeah. I know you need it. This, you know
what I would be doing.
This is what AI is built for.
You know what I'd be doing if I was the court? Please resubmit briefer. Like, is there no filing limit for this shit?
I don't know. I think complaints these days have gotten so long that the art of legal writing has fallen out the window. It's just gone. It's ridiculous.
I mean, they have the initial notion that, like, oh, well, we want to, we want this to be kind of litigated in the public, but I feel like this amended, like, complaint is partially designed to like snow the public out, because
like
nobody's got time.
So complex that
nobody's got time to read 600 pages of.
So I mean, you know what people have time for? If a deposition of Blake Lively takes place, the transcript of that deposition is. I would have time for that.
Or if they release the video, because oh my God. There's already some really serious fodder for the deposition. Like, one of the really interesting things is that in her first complaint, she says that like he brushes up against her and says that she smells so nice during this scene. And he's like, did y'all forget I was mic'd up? We have the original audio of that. And so then
posts it.
And then she files the amended complaint where that is no longer alleged. But the thing is that first complaint doesn't vanish from existence. So like when she gets when she sits down for a deposition, it's going to be like, so why was that in your, like, why was that there? So that was not true, right? And either she says, well, no, it wasn't true, or she says, yes, it was, and then it's like roll tape. Yeah, a lot of this is going to be real difficult for her, so we'll have to see, but yeah.
This is going to be a very interesting process as it plays out. So, like I said, I commend you to those who are covering it. 600 pages is beyond what I am capable of reading and covering right now.
I mean, I'm going to have to figure out like which bits to cover, because I don't think I can, like, if I quit my day job, I could do a whole thing of like, we're just going to go through this beginning to end. And
I know Alita's been covering it substantially. She's been putting a lot of time into that.
Yeah, I mean, she's got the advantage, she's got full time on it. So I cannot do beginning to end on 600 pages. So I'm going to have to, maybe if I devote a whole week on it, but yeah.
I can give you an opinion on this one, Boppet. Are the Baldoni Lively complaints written for the court or the public? Public. 100% public.
If you're writing it for the court, you do not do 600 pages.
No, you make it 6. You state your allegations. That's it.
Yep.
Yeah, it's public. All right. I'm going to wrap the stream because we are 5 hours and 30 minutes in. Thank you all for being here.
Four chats left, I think, or 4 things left that just came in.
Oh, let's see. Well, where are those? Was I kicked out of the studio at that point? Pull the other ones up. I don't have them. Oh, thank you. Yeah, I was out of the studio. Thank you, Fiona W. Thank you, Sandy.
This is from
today. Oh, yeah.
Excellent. I'm glad things seem to be making it. So those of you who haven't got their stuff, it's either in the mail or it's in my garage, except with one case. There was one. So there were 2 people who ordered a set of 2 books and 2 autographed books. One of those, I don't know what happened to it, but the person who sent it to me was thankfully able to get a replacement. So that's on its way to me. And then once it arrives to me, it'll go out to that person. So everybody, I'm hoping, is going to get everything. All of this is incredible stress. And then I'm going to have a bunch of stuff left over that I got to add to the next one, or I got to figure out something to do with, like, auction off. And I don't know if we ever actually auctioned off the golf clubs cover. The one that is
I'll take it. Just kidding.
I may I could put a price tag on it for the extra life donations, but so
I'm seeing that one of our mods' daughter is in the chat.
Oh, I have been not on my best behavior. The Alice Cooper thing. Yes. I don't know if it was auctioned off. I got to check. And yes, Against the Tide, my mod is reminding me, don't send things to me I got to figure things out for all of that. So don't send things my way until I've figured out the new system for it. And until I've given sort of approval for things, because I got so many things.
It created chaos.
Yeah, well, and somebody's like, what Alice Cooper thing? Oop, something just fell and I don't know what it is. This is by Daphne's head covers for cover your driver before it knows what hit it. I think that is super cool.
That's pretty fun.
So,
Cynic in Chief, what the hell's now has a lawyer making up quotes?
Oh God,
I haven't followed any of that story, but I think it's a whole lot of catch up that I can't do right now.
Yeah, I just am like, that one is one I can't catch up on.
Tracy Collins, regardless of the poll results, we can all agree on one thing. If we're road tripping down conspiracy lane, let's give Brennan the Google Maps directions. That was a good one to end it on. All right. We're going to bid you guys adieu. Have a lovely evening. Have a great weekend, guys. Get out in the shop, get outside, go make something. You'll feel better. I promise you. I'm going to make a bed and sleep in it this weekend. that is what I'm going to make. I'm going to make a bed. I'm going to sleep in it. And by making a bed, I mean
from scratch.
No, I'm going to put sheets on it. I'm going to get in. I'm just going to go to sleep. That's going to be my goal. I'm going to make a clean house. All right. Good night, all. Thank you for being here. Much appreciated. We'll catch you next time. And like I said, go make something. You'll feel better.